Good afternoon. This is a hearing of the House Judiciary Committee on February 27th, 2025. Earlier today, one of the sons of the Speaker of the House, Adrian Jones, passed away. We are still learning more about what happened, but I wanted to take a moment of everyone's time and the committee's time to convey my and this committee's deep sorrow for what the Speaker must be going through right now as she has lost a son. We deal with a lot of very difficult and very challenging issues in this committee. We deal with a lot of very difficult and challenging issues across the legislature, but none can compare to what the Speaker of the House is going through right now. And for that reason, I would ask us just to take a moment to reflect and to hold the Speaker in our prayers. Thank you all very much. Ladies and gentlemen, we have quite a few bills today, and the Speaker very much would like the work of the people of the state of Maryland to continue, and that is exactly what we are going to do. And so with that, House Bill 966, Delegate Cardin, if you'd please go forward. We'll take your bill first. It is Judge Hecker, who is, I think, here. Is he here? Oh, come on up. That'd be fine. Delegate Cardin, you'll have 3 minutes. Judge Hecker, you'll have 2 minutes if you promise not to hold me in contempt. All right, that's fine? All right, thank you very much. Delegate Cardin, please.
Thank you very much, Mr. Chair, members of the committee. For the record, John Cardin on House Bill 966 asking for a favorable report. This bill had a very, very positive hearing in the Senate with the Chief Justice testifying on the bill there, but however, he's in the air right now, so he couldn't even testify remotely. So we have an amazing substitute who's going to talk from the judiciary's perspective. This bill comes, for those of you who don't know or don't remember, I was able to be the sponsor of the very first revenge porn criminalization bill in the state of Maryland back in 2011, and Grace's Law in 2012, and then the Grace's Law 2.0 in 2019, dealing with a lot of cyber bullying, cyber harassment, and issues of what has now converted into, as technology moves forward, into artificial intelligence influencing people and being able to cause safety concerns. And this bill was born out of this, and Senator Hester really did an amazing job of crafting this legislation, and I am proud to be her cross-filer. It establishes an artificial intelligence evidence clinic to support Maryland judges by providing expert analysis on whether electronic evidence has been altered by AI. For all intents and purposes, what this bill is doing is creating a system whereby judges can use the expertise of our intellectual and academic community who are experts on AI to be able to inform them to make sure that whether it be juries or witnesses or other interested parties in judicial tribunals to be able to effectively understand things without being inappropriately or unsafely influenced by artificial intelligence. That's the essence of the bill. I'll let the judge testify maybe and answer questions on specifics if necessary.
Mr. Chair, Madam Vice Chair, members of the committee, I know you have Chief Justice Fader's written testimony, so I won't repeat that here. I do want to thank Delegate Cardin for sponsoring this forward-thinking legislation. It's clear that both our branches of government recognize the increasing role that generative artificial intelligence plays in our everyday lives. To be sure, advancements in AI have facilitated remarkable innovation. But with advancements in AI also come big challenges to the authenticity of digital evidence and the specter of what has become known as deepfake evidence in our courts. This concern is heightened in cases where parties lack the resources to hire experts to scrutinize suspected fabricated evidence. Consider, for example, a fabricated video, audio, or photographic evidence in a domestic violence protective order trial used by one party to undermine the credibility of the other. These are not hypothetical situations. I suggest to you that they are happening every day in courtrooms in Maryland and around the country. The use of such evidence makes getting to the truth much harder. And this legislation will help courts reach the right result by offering a mechanism for testing evidence that may have been created or altered using AI. House Bill 966 will provide courts with tools to confront suspected AI-generated or altered evidence, provide an essential safeguard, and we hope a deterrent against the use of fabricated evidence, thereby strengthening confidence in the judicial process, and perhaps most importantly, prioritizing civil cases in which one or more parties lack the resources to secure expert opinions. So I commend the sponsors of this legislation for recognizing the urgent need to address AI evidentiary concerns, and we urge a favorable report. I'm happy to answer any questions you may have.
Questions from the committee? Delegate Kaufman.
Yes, Delegate Cardin, I wanted to commend you on this excellent bill, but I did also want to give you a chance to respond to the fiscal note, which is $250,000. It said general funds increased by $250,000 in FY 2027 and 2028. And so I just wondered if you wanted to, I wanted to give you a chance to respond to the fiscal note.
Yeah, so of course, in the pursuit of justice and in the pursuit of fairness, there are expenses. These are very, very reasonable, and they would be, presumably, there can be an attempt to figure out how to incorporate those into the costs in higher education could perhaps come in. We have a year to figure that out. I think that there's an attempt to figure out a way to have them incorporate the costs in their budgets, as well as the judiciary certainly sees this as a valuable, coming in and support, sees this as a valuable tool, and could perhaps find the ability to subsume it in its budget. I will indicate that there is no opposition. There's no opposition from the administration in terms of any budget concerns. And there is an amendment that I forgot to mention that conforms it to the Senate bill, which was approved by the judiciary as well.
All right, thank you, Delegate Cardin. Thank you, Mr. Chair.
Seeing no further questions, we thank you very much.
All right, thank you.
All right, thank you, Your Honor. All right, we're going to go next to House Bill 1222, and Delegate Williams is going to make her way up. I'm good with this. And we'll ask Ms. Manuel, Stephanie Wolf from the Office of Public Defender, Katie Nash, and Ms. Frimpong, Emma Frimpong Hauser. All right. We'll hear from the sponsor for 3 minutes, hear from everybody else for 2. And we're going to, I know that there are people on this list who are listed favorable with amendments. I'm aware the sponsor has been working with people consistently. So I'm going to take favorables and favorable with amendments together before for a little bit here. So with that, Delegate Williams, please, for 3 minutes.
All right, good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the awesome House Judiciary Committee. I am Delegate Nicole Williams, representing District 22 in Prince George's County, Maryland, and I'm asking for a favorable vote on House Bill 1222, also known as the Public Safety Immigration Enforcement Maryland Values Act. This bill would prohibit any agent of the state or unit of local government from entering into certain voluntary immigration enforcement agreements with the federal government. What this bill does not do is state that local enforcement will not cooperate with any valid warrants that are issued as it relates to individuals who are convicted of a crime of violence here in the state of Maryland. This legislation comes at a critically important time in our country. As Marylanders, we are in the backyard of a federal administration that has wasted no time in targeting and uprooting individuals who live in my community and in your community. There are individuals who left the countries that they were born in to come here to America in search of what we call the American dream, to create a better life for themselves, for their families, and for their children. These individuals go to work here, they go to school, they raise their children here. The 287G program is a mechanism through which certain communities are terrorized and creates a fear of cooperation with law enforcement. Under these agreements, state and local governments can voluntarily enter into collaboration with ICE to enforce federal immigration laws. In doing so, police officers are deputized in performing immigration-related functions despite being offered minimal training or guidance to do so. In February 24, ICE has reported 153 agreements across the country with law enforcement agencies. In Maryland, we currently have 3 jurisdictions with such agreements: Frederick County, Hartford County, and Cecil County. These localities are obligated to spend their own funds to participate in this program, despite Homeland Security having one of the largest budgets of any federal agency. ICE will provide training, equipment, and oversight, but offers no form of reimbursement for staff time, overtime, incurred by our localities. In a budget year where our state is facing substantial deficits, it does not make financial sense to continue with these agreements. And it does make financial sense to prohibit these agreements and to sunset the existing agreements and transfer those savings back to the communities in which law enforcement is authorized to serve. Ending these programs in our state makes the moral sense when we consider its inconsistencies with our values here in Maryland that we hold dear. Our state has had a history, and I'm a little short on time, but we have passed the Maryland Dream Act, the Dignity Not Detention Act, the Family Prosperity Act, and other pieces of legislation. And this is just a furtherance of our values that we hold dear and dear to our hearts. And for those reasons, I am asking a favorable vote for House Bill 1222.
Good afternoon. My name is Ama Frimpong. I am the legal director at CASA. Delegate Williams, thank you so much for your leadership, and to the many members here who have co-sponsored this critical legislation. This is a defining moment in our history. Our immigrant friends and neighbors, Black and brown community members, right here in Maryland, are being targeted with renewed, aggressive, and cruel intensity. ICE agents are literally smashing the car windows of harmless community members and dragging them out of their cars, all in the name of public safety. Our community is afraid, and rightly so. 287G feeds into this machinery of fear, and Maryland must not be complicit in this. Let's be clear, 287G does not enhance public safety. It actively undermines it. By turning local law enforcement into ICE agents, 287G destroys trust between police and immigrant communities. When people are afraid of the police, they stop reporting crimes, and that makes us all less safe. At CASA, we see this harm firsthand. When you live in a 287G county, simply being an immigrant is considered a crime. The evidence is overwhelming. 287G does not make us safer. It fuels racial profiling, diverts resources, and weakens law enforcement's ability to do its job. Maryland has already taken steps to limit ICE entanglement. In 2021, we passed Dignity Not Detention Act, recognizing that such ICE partnerships violate our values. Ending 287G is the necessary next step that gets us closer to aligning with the values that we hold dear here in Maryland. Thank you for your time.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the committee. For the record, my name is Yanetta Emanuel, Public Policy Director with the ACLU of Maryland, here in strong support of HB 1222 with amendments. This legislation is both urgent and necessary. An extensive 2017 study on Frederick County concluded that the program's adoption in 2008 led to an increased number of arrests of Latina individuals by the Frederick County Sheriff's Office. While technically 287G is a jail-based program, it incentivizes racial profiling and pretextual stops to funnel people into the deportation pipeline. Just look at the example from Frederick County in 2018. Sheriff deputies stopped Sarah Medrano while she was driving with her daughter, her grandchildren, under the false pretense of a broken taillight. In reality, the taillight was fine and the stop was motivated by her race. Deputies questioned her about her immigration status and even asked her where she was from, all because of her Latina identity. They held her and her family in the car for nearly an hour, even demanding her daughter's identification despite the child being a passenger. This family, including young children, were forced to endure fear and anxiety over what they thought was the last time that they would see their mother and grandmother. In the Medrano versus Jenkins, the court ruled in favor of Ms. Medrano, and if we don't end 287G programs, there will be more Sarah Medranos. It's also clear that 287G is not an effective public safety strategy. According to a recent reports in Frederick County, over a 12-year period ending in 2020, only 17% of people with ICE detainers were charged with felony offenses. According to the Frederick County 2012 annual report, 60% of civil immigration detainers issued by ICE were for people charged with minor traffic violations. This program creates a climate of fear and breaks down trust between law enforcement and the communities they're supposed to protect. Lastly, we object to the provisions of the bill that mandate detention and transfer, which courts and the AG have flagged as likely unconstitutional. The crux of this bill is about ending 287G. Maryland must uphold due process and disentangle immigration enforcement with the criminal justice system. And so for the foregoing reasons, we urge a favorable report on HB 122 with amendments. Thank you.
Good afternoon, Mr. Chair, members of the committee. My name is Stephanie Wolf, and the Maryland Office of the Public Defender respectfully requests the committee issue a favorable report on HB 1222 with the important amendments described in our written testimony. 287G agreements undermine due process and make innocence irrelevant, eroding trust in our legal system by obligating local law enforcement to act as ICE agents and arrest those they encounter in the course of enforcing local law. There are no exceptions to this obligation for situations involving minor charges, factual innocence, or any extenuating circumstances. The jurisdiction gets no discretion to decide when an ICE arrest is appropriate. 287G does not target people with serious convictions. It funnels the innocent and those who have committed minor offenses into the deportation pipeline. We know this from the data, which is outlined in my written testimony, but the reason for this is that 287G agreements only allow ICE to arrest people who are being released from the local jail. And that is not typically where you find people who have been convicted of serious crimes. Those people are in DOC, and they are already consistently being turned over to ICE, as ICE has acknowledged. People being released from the local jail are generally either people who have been found not guilty, people who have had their charges dismissed or placed on the STET docket, people who have been released by a judicial officer while they're awaiting their day in court, or people who have served a short local sentence for a less serious offense. We know that ICE is not concerned with innocence or level of culpability. You can hear this in Field Office Director Ellison's comments to Fox 45 last week. The handcuffs are off. We have to anticipate that going forward, 287G will be used even more aggressively to put Marylanders with little or no criminal history into the deportation pipeline, co-opting local law enforcement into an efficient source of collateral arrests. This is contrary to Maryland's values, and we urge a favorable report with amendments.
Good afternoon, Mr. Chair, Vice Chair, members of the committee. Katie Nash, President of the City of Frederick City Council. The mayor and I have both submitted written testimony. My written testimony largely focuses on my view as a local elected official who must make budget decisions regarding safety and the general welfare of our city residents. That testimony provides a rationale for ending an ineffective program that is nearly 20 years in operation. Our fiscal climate necessitates, as the sponsor eloquently pointed out, our need to examine programs and especially consider ways that we can take action to pivot our government to alleviate unnecessary suffering. I'm here today with two main goals. first, to be a resource. If you have questions of our professional police force in the city of Frederick, I will certainly take those back and get you an answer. Second, I wanted to be here in my capacity as a council member and ask you to view this legislation in a somewhat different way. You've heard testimony, and you will, about how the outdated 287G program actually makes us less safe. This is common sense for me, but if you don't believe that by now, respectfully, I likely will not change your mind. What I believe is at the heart of this policy debate is if you think that as our state policymakers, individual jurisdictions should continue this practice of having a relationship on their own with federal immigration above what existing law requires, particularly now. Said another way, should the state set a uniform policy for engagement with federal government and local governments should not be in conflict with that policy. I know this committee frequently hears emotional testimony every day, and I am grateful for your leadership, particularly in days like now. I ask you in my capacity as a local leader who desperately wants to keep all of her residents and our visitors safe to work to create a uniform response to our safety challenges. Please pass HB 1222 with amendments out of this committee. Thank you.
Questions from the first panel, Delegate Eric.
Thank you, Mr. Chair. Thank you guys for being here today. I'm going to start with a brief story about my county, which you referenced, and then I'm going to ask you a couple questions. In 2017, there was a workplace shooting in our community. Many of the victims and the witnesses were here illegally. They were not afraid to come forward. I know because I know the owners of the business personally, and I was physically present for the meetings. They were offered U visas. They proudly came forward. They were not afraid of our county. They were not afraid of 287G. They both resided in our county. They were buried in our county, and they proudly lived in our county, and they came forward to help with crime in our county, which has one of the lowest violent crime rates in the state. Okay? My question is for the young woman on the end. You referenced Mr. Ellison's comments, but then you didn't actually quote any of them. Could you tell me what he actually said?
Yes, so the quote, and apologies if I didn't make this clear, but he did say the handcuffs are off.
That was the only quote?
That was the only part that I quoted.
Okay.
And that was in the context of a story for Fox 45 News, and we can provide, I believe it's linked in my written testimony, we can provide the full context of that, but it was in explanation of saying that ICE is now not going to arrest anyone they encounter who is in the country without permission. There will not be consideration of who the target initially was. And that was after an incident in Prince George's County where ICE stopped the wrong person in a car. And despite knowing that it was not the person that they were trying to stop, they broke the car window and pulled him out in order to arrest him for a civil immigration violation.
I've actually been pulled over several times for having a broken taillight. I don't know if you would consider it racial profiling, but it's happened to me many times. And in fact, my taillight was not broken. Furthermore, the piece on the financial stuff, I understand that the city of Frederick is here. Why was this not a city of Frederick delegation bill? Why would you include 2 other counties and step on the local courtesy policy that we typically have down here?
Because with the bill, the aim is to also prevent further jurisdictions from entering into these agreements. And so that's why it's not a local bill, it is a statewide bill. And I will just say, you know, I'm glad to hear that individuals within your community, Delegate Eric Ham, were willing to participate with local law enforcement. I will say in my community, I have constituents and neighbors and residents that are scared shitless right now.
Well, I'm sorry to hear that. I think it's probably because of the outlandish commentary coming from the left about what the policy actually is, which is putting people, decorum, y'all, which is putting people who have committed crimes, who are already in our jails, on the list. That's it. That's what it does. It doesn't grab people who are eating peanut butter sandwiches, which is just factually inaccurate. But thank you.
Delegate Conaway.
Thank you, delegate and panel, for coming in to testify. My question is, did the President of the United States of America give an order about this issue?
Has he issued an executive order about this issue in particular? I know he has made comments with regards to the 287G program, but I don't think an executive order has actually been issued yet.
So did he make an order about people that are undocumented?
He's made lots of comments over the years.
But I asked you specifically. You don't know?
He's-
Okay.
he's-
Have
okay.
elected people been warned about non-cooperation with the federal government?
So there have been several executive orders.
We're on the next question, so.
Oh, I'm sorry.
Have elected people been warned about non-cooperation with the federal government? Maybe on Fox 45 News?
Elected people warned about non-cooperation with the government.
Yes.
This bill is not seeking non-cooperation with the federal government.
I didn't
In fact,
ask
this
that. I
bill
didn't ask-
does state that local
thank you
law
very much.
enforcement will continue to honor any ICE detainers and judicial warrants that are issued.
I'll be brief, Mr. Chair, but I have two. My question is, for Ms. Frimpong's, I think, that's your name from CASA? I'm sorry if I butchered it.
Frimpong.
Okay, I do apologize. Can you go into, and again, briefly, we have a long day, your amendments, what you would like to see changed, because you're favorable with amendment, and if there have been any constitutional issue concerns raised about them? And then my next question is for Ms. Wolf. My friend from Hartford County articulated a positive interaction she felt that people had with ICE and different things like that. So does this, if they so choose, does this prevent any and all collaboration with ICE? Is that what Delegate Williams' legislation does? So the first person about the CASA amendment.
Sure. Thank you for that first question. As we explained in our written testimony, we are urging the committee to remove the language mandating detentions and transfers. The Maryland Attorney General, right, and several courts have signaled that this is unconstitutional. Right. And so we are seeking to and are actively working with the sponsor to make sure that we are able to have language that serves the purpose of public safety, right, without violating individuals' constitutional rights and without exposing localities to potential liability.
Okay, thank you. And Ms. Wolf, do you need me to rephrase my question, or you remember it?
No, I remember. Thank you very much. This does not prevent any and all cooperation with ICE. And it's important to understand that what 287G does is obligate the county to cooperate in every single instance. If ICE wants an arrest, there must be an arrest. So it removes local sort of discretion to decide when and how much cooperation is appropriate. This bill preserves the locality's ability to decide whether or not to cooperate.
Just very briefly, my other question is, because we often hear about the importance of local autonomy and states' rights. So would you contend that, Delegate, given the explanation that you just gave me, that Delegate Williams' bill, is in support of states' rights and local autonomy?
I think yes, and the reason, there does need, as Delegate Williams said, to be a uniform policy here, because the spillover effect of the fear that 287G creates is not going to stay within the boundaries of the county that's decided to sign that agreement. And this is the opposite of local empowerment. This is allowing certain individual law enforcement officers in certain jurisdictions to hand the reins of their agency over to ICE without preserving any discretion for themselves. So I think this bill actually preserves local autonomy.
Okay, thank you, Ms. Wolf. Thank you, Mr. Chair, for your indulgence.
Thank you, Mr. Chair, and thank you, Delegate, for bringing the bill, and thank you, panel. I just want to get a better understanding of what's being implemented at this point with the three counties, Frederick, Hartford, and Cecil, as it pertains to some of the examples the panel provided with the traffic stop from 2008. It's my understanding the program now and its current practice is that these ICE procedures by local officials are currently only in detention centers. They're not out actively engaging in traffic stops and doing interviews of citizens on the street. Am I incorrect in that assumption or what I've been told?
Yeah, I mean, they currently are engaging in what we call the jail enforcement model now. There's multiple different types of models as it relates to the 287G agreements, and that is the model that they are engaging in now with anyone who's arrested for anything. And I don't know if you want to elaborate on that.
Absolutely, yes, thank you. I think it's very important to remember that the impact of the jail enforcement model extends far outside the jailhouses, right? We have verified reports that there are officers in 287G counties that are engaging in immigration enforcement outside of the jail. That is the first thing. And the second thing is it's really not necessarily about, it is not only about putting an end to the current agreements, right, but really thinking about the moment that we are in right now. The federal government has issued clear mandates that ICE is to expand the use of 287G, okay? We have at least one county in Maryland that has a pending 287G agreement. So the idea is that 287G would be expanded here. So it's not necessarily just about what is happening now, but what could happen, and we need to make sure that we put a stop to it before there's more harm done. And I also want to say respectfully to a comment that was made earlier about this being about rhetoric from the left. I really want to note that as a Black immigrant woman myself, I find that very offensive because it is minimizing the actual fear. It is minimizing and misstating what our community is facing right now.
Right. And I would just also add that under the jail model, it is targeting individuals who are arrested for anything. That doesn't necessarily mean that they are guilty of what they're being arrested for, nor are they being, it could be just as simple as urination in public, and that's what they're being arrested for. And now you have individuals that are asking about their documentation status here in the United States. And so I think that is the concern that we have with the current model, is that you are targeting individuals who may presumably be innocent of any type of crime here.
Would you agree the jail model or in doing all of this process in a controlled environment, though, is safer both for law enforcement and for the constituents we serve or in our communities? Because it's in that controlled environment?
I think what's safe for law enforcement is to obviously detain individuals who are engaging in criminal activity and to engage in law enforcement against criminal activity. I think that what you do is you start to create a scenario where you have individuals within communities who are now going to start to be afraid to talk to law enforcement, to cooperate with law enforcement when they do see criminal activity taking place within their communities. And we have seen this in other jurisdictions. Even as goes so far as when we're talking about domestic violence and women who are victims of domestic violence being afraid to go to local law enforcement to report these domestic violence crimes for fear of also the immigration matters that may take hold against the individual that they're reporting.
But in that report, law enforcement now wouldn't be doing like immigration type of work in that scenario,
If that
correct?
person is picked up under the jail enforcement model, they would be.
Okay. What can I? Thank you, Mr. Chair. And this question would be for Council President Nash. Thank you for being here. I just wanted to touch on your testimony about the intersecting of the funding component of this. With the detention centers in Frederick County specifically being county funded, how does that impact from a fiscal standpoint the city of Frederick, whom you represent?
Sure.
How does that intersect?
Absolutely. Thank you for the question. I thought it might come up. You're right, and we're grateful to have you in our delegation, Delegate, that the county does oversee the detention center and it's their funding model. And I think there are a lot of questions about that we could take offline. Specifically for us, our budget for community policing is based on community policing. It's the intersection of the community and policing. And we, as a city, spend a lot of time and money trying to get our officers into that place of trust with our community. Right. From my perspective, respectfully, Delegate, I believe that the 287G actually undermines that. And so for me, as a city official, I feel like I'm spending money trying to get our officers off, in the streets. That's from my perspective. Thank you.
That makes sense. Thank you very much.
Delegate Thomas.
Thank you, Mr. Chair. Just kind of wanted to follow up, I think, where he's not there anymore, but Delegate Conaway was going. So I'm looking at testimony from Talbot County's Sheriff Joe Gamble. And he brings up that the bill would be in direct conflict with federal law, which would prohibit access to federal funds from jurisdictions who are recognized as sanctuary jurisdictions. This would negatively impact current programs in place to include grant funding to the police protection of a local jurisdiction who have lost their police force due to funding constraints, and 2 48-hour hold agreements between the Department of Corrections and the federal and ICE. I think when he's referring to federal law, I think he's talking about President Trump's one of his recent executive orders, I think. Can any of you comment on that?
Sure. I mean, I think we can be absolutely clear. Ending 287G agreements is not a violation of the law. That's the first thing. We absolutely, of course, we cannot guarantee that the federal government will not attempt to, sue localities or the state for ending these agreements. However, thus far, such threats, such attempts have failed because they're not constitutional. So we stand on solid legal ground to be able to fight back, right? What is important is that we're sending a clear message that we are protecting the community here, all residents, regardless of the rhetoric, right, that is being put out.
Right. And I just want to add, I represent Prince George's County. In my county, we have a statute on our books as it relates to not entering into these agreements. And yet we have still, our law enforcement has still been able to obtain federal funding for various law enforcement programs in Prince George's County that has not been affected one way or another from us being able to still obtain that federal funding.
Okay, thank you.
Delegate Simmons.
Thank you, Mr. Chair, and thank you, panel, and really appreciate y'all coming out here and advocating for the community. I represent northern part of Anne Arundel County in the Glen Burnie, Brooklyn Park area, which I have a large consistency of the Latino community, African diaspora community. So looking at this and the conversation at hand, can you speak a little bit to the sense of urgency that's going on in these communities, and what does the numbers look like? I know we at one point put out a number that people can call when they're having issues. Are y'all seeing a large arrest? What are y'all seeing behind the concerns that are being put forth?
Thank you for that question. And yes, absolutely, there is a sense of urgency, right? Again, as my colleague shared, right, ICE has explicitly said the handcuffs are off. What do we know that means? It means we are going to seek to find, arrest, deport every immigrant that we come across, period. So our community members are terrified. Our community members are reaching out to us. We are seeing, I have been doing this work now for about 15 years, and I haven't seen anything like this before, right? I have not seen anything like, I have not seen ICE act with such recklessness, right? Ever. And so we need to be absolutely, we need to make sure, right, that we are moving quickly to stop this now before things get worse, before the harm grows, and before there's even greater impact on the community.
And if I can also add, I just also wanted to add, I don't have exact numbers, but I know anecdotally I've been hearing in my county individuals who are pulling their kids out of school because of the fear. Our libraries in my county have various programs that are catered to children within our community. The numbers of the people who are showing up to our local libraries for just noontime reading has decreased because of the fear that people have in venturing outside of their homes because of what is taking place right now. So we have children who are not getting educated because of the fear that's going on in our community.
Sure, I just want to follow up with that. So, and I appreciate your testimony. My concern is how we respond, right, to these concerns. So I'm out in the community. I'm meeting with different groups to try to educate them. I also go out on ride-alongs with our law enforcement. You know, so my problem is that I am not seeing where people are being arrested. You know what I'm saying? I'm not seeing where ICE is going, grabbing people. I hear about it, right? You hear these stories, but I'm not seeing it, and I'm not seeing any data that say otherwise. So that's why I'm just trying to, you know, how we proceed is very important. You know, are we being proactive or reactive to what's being said? So is it fear-stroking, or is it actual stuff going on pertaining to Maryland? You know, that's the question. I think we're trying to get some levels of clarification on, you know, who, are y'all talking about people specifically or just in general?
No, we are talking about people specifically. So CASA has been operating an ICE arrest hotline, right, for the past 6 weeks, right? And so we are actively receiving phone calls every single day from Marylanders, right, letting us know what is happening. And again, this is at a level that we have not seen previously. And second, I urge anyone here who has not seen that Fox 45 video in which ICE director is himself saying this, that our numbers are increasing, the handcuffs are off. And I think it's important to know that as of a month ago or so, every local ICE agency is expected to meet a quota of 75 arrests per day. The ICE director in the video shared, I believe he said there were about maybe 35, 40 arrests per day, but all that to say, there is now a quota to be met, and what does that mean? Arrests are going to go up, and they are going to meet that quota however it is that they can.
Thank y'all. Appreciate you being here.
Delegate Taylor.
Thank you, Mr. Chair. For the young lady that serves as the counsel for CASA, which county has a pending 287G program?
Carroll County.
Okay, great. And then I have a follow-up question. So we can't be the only state looking at this or the only state that has 287G programs. Can you, what other states have them? What other states are pulling back at this time? And also, are you seeing that on the local level that it's happening too, and maybe there's some states that are pulling back locally?
Sure. So there have been.
Siri doesn't understand.
Siri didn't understand.
That question was for me, not for Siri, right?
Now it is.
Absolutely right. So at this point in time, I think the last time that we looked at numbers, there are about 20 states that historically have had 287G agreements. A lot of states have ended their 287G programs, right? So several states, New Jersey, Washington State, Colorado, have ended 287G programs through legislation, right? Which is exactly what we're seeking to do now. There are other states that have simply never participated, right? There are some states that have said this is just not for us, we're not even going to look at it, right? And then on the local level, not on the local level here, Anne Arundel County, right, ended their 287G agreement, I believe in 2019, right, in recognition of the fact that it was ineffective, right, and for all the reasons that we're talking about today. I do want to flag that there are other localities around the country that were forced to terminate their 287G programs because of egregious civil rights violations, right? I think most of us here know about Maricopa County, Arizona, right? And so it's like, okay, you can either end it through legislation or wait until things get so bad that you are forced to terminate it, which we need to make sure does not happen here in Maryland.
Thank you.
Okay. Delegate Simpson.
Thank you, Chair. So I did watch the video, and I had lived in Anne Arundel County that got rid of their 287G, and now, of course, I'm in Frederick where we have the 287G program. And watching the video, it seemed what he was saying went farther. You say the cuffs are off. He said if anyone is illegal, then they're going to be arrested. So it seems to be beyond the borders of, that they're talking about beyond the borders of just the prison or, you know, the correctional facility. It seems to be talking about anywhere. In fact, there was someone who, so I just want some clarification, an individual that's in a car, their window is rolled up. Is it constitutional for someone to be able to break that window? And especially if, can you clarify, like, was collateral, was not the individual they were even after?
Yes, so you're absolutely right that this was a collateral situation. My understanding, and this is based on the media, obviously, so based on what's been reported and what Field Office Director Ellison said, they pulled over a car looking for a particular subject. They realized that the driver of the car was not that subject, and instead of just saying, sorry about that, go about your day, they attempted to interrogate that person. And it was not clear to me from the segment or from the interview afterwards exactly what they got in that interview. And I think that would be the crux of the question about whether it was constitutional for them to attempt to effect an arrest after that. But your original point, or where you started, was it sounds like this is beyond the borders of the jail, and that is absolutely true. So what the quote about the handcuffs being off and the rest of that story is a stated intention to engage in collateral arrests. Collateral arrests are, we were out doing something else, looking for someone else, but we encountered this person, we decided to ask them questions, and we arrested them for a civil immigration violation, even though when we went out this morning, we had no idea who they were, we just happened upon them. And the 287G agreements in a jail-based model are essentially a way of scooping a very large number of people in as collateral arrests, because those are folks that ICE wasn't going to encounter, except now they've deputized our sheriff's deputies, our local law enforcement, and anyone who they are encountering, anyone who they are booking into a jail, has now been encountered effectively by ICE. And so those people, whether their case is resolved with, sorry, we got the wrong person, or you had a trial and you were found not guilty, or this was a very minor offense and the state decided to put it on the stat docket, no matter how it's resolved, you've had an encounter with ICE, and what their stated intention is we are arresting those people. If we encounter you and you're in the country without permission, we're going to arrest you because the handcuffs are off. And so that turns our local jails, our local law enforcement, into a way to scoop a very large number of people, especially black and brown people, into the deportation pipeline as collateral arrests.
And the area I live in is very immigrant. You know, I live on the Golden Mile, which I think it's golden because it has the beauty of people from all over the world. But so ICE is a federal agency, correct? Mm-hmm. Do they have the authority to pull someone over if it's not a federal land? I didn't think they had that authority.
Yeah. They can't just conduct a traffic stop for a taillight the way our local law enforcement can. And again, so that's one of the ways that this 287G agreement expands ICE's ability to kind of get to people in our communities. But they can stop someone in a car if they're, you know, pursuing their own law enforcement aim.
Right. So if they have their own warrant or their own detainer out for someone, they could go and actively find that person and detain that person based on their own ICE detainer out in the community. And the jail model is just one of the models of the 287G agreements. There's also the task force model, which is a much broader model that would deputize local law enforcement individuals and would allow those local individuals to basically, as they are encountering individuals in their daily activities, to ask them questions about their status and arrest individuals that they believe have violated immigration laws. As was stated earlier, none of our local jurisdictions have entered into that model, but that model does exist, and local jurisdictions can enter into that model currently.
And a quick follow-up. My council president and I are from actually the exact same area, practically across the street. So can you share with my fellow committee, what is the impact? What are you hearing from the people that we live with What's going on in Frederick?
I appreciate that question, Delegate. You probably saw me reach when Delegate, from Anne Arundel County, asked the question. Just from being from a 287G county, we are being asked as a local body to figure this out, right? And this is not, like I said, this has been in essence for 20 years. And the emails that we're getting and the stories that we're hearing, I'll just speak to, in Frederick County, the fear is very real. And Frederick City, being a city official, we're sort of stuck here because our county is doing one thing that we really don't want. And so I appreciate the question. The fear is very real. I think that was the intent, if I may be so bold, is to strike fear. Mission accomplished. So we need to do what we can here in Maryland, and I thank this body for your work.
Delegate Cramer.
Thank you, Mr. Chair. I have several questions. First, help me understand how the bill works. It seems we've kind of limited the way, the who that we could detain by defining covered individual. So by defining covered individual and specifying the crimes, if I had a person that was arrested for harassment and ICE had requested a detainer because they knew the person had committed a murder in Honduras, we could not detain that person under your bill. Is that correct?
So if a person was arrested for harassment and convicted for that crime of harassment, first of all, they're going to get fingerprinted. And once they get fingerprinted, their fingerprints are going to enter into the national database, which ICE is a part of. And so ICE is going to get dinged that that person is going to be in our custody for harassment. If ICE has a detainer for that person, ICE can reach out to that local law enforcement agency and ask to come pick that person up under that detainer. That is current law. And that would continue to survive under this bill.
But you've standardized the way we're doing things here, in that you're covering certain crimes and you're actually limiting the number of hours that we facilitate.
The 48 hours is what's currently in place under the ICE detainer request. So that is what is under the current law.
Explain to me how the crimes specified in this bill differ from the crimes that were used, that mechanism you said that would survive. What am I missing there?
So, as I mentioned before, they're going to get dinged in the system. We are not going to be required to, under the harassment hypothetical that you have provided, because that is not a crime of violence, required to notify ICE and hold that person for the 48 hours. This bill specifies that if someone is convicted of a crime of violence, first-degree rape, first-degree murder, those types of things, that we would detain that person for up to 48 hours in order to facilitate the transfer to ICE.
So you're essentially saying your bill is a shall, but in all other cases, there's no guarantee that we're going to hold them at all.
That is correct.
Okay, that's what I wanted to clarify. One of the things it's been mentioned several times, it's the handcuffs are off. It's this kind of emotional terrorism that we're hearing about this issue constantly. But ICE is here, and I think we're going to be able to hear from him. But when I've talked to ICE, they've said, we're not going around arresting people for eating peanut butter sandwiches in public. We're not going into schools. All these things we're saying are actually not true at all. The crimes that they've listed to me, and I've seen publicly, child pornography, murder, armed robbery, drug distribution, these crimes are okay to me. So I wanted to ask specifically, what evidence do you have that there's this kind of broad sweeping authority collecting every illegal immigrant in the state of Maryland? Because what it seems like is you're just gaslighting the hell out of this committee. What evidence, seriously, what evidence can this committee look at to kind of assess these continued claims that ICE is doing this?
Do you want to talk about the hotline, or I can talk about it? Do you want to start?
I'll defer to the sponsor.
I mean, I know I've received emails, I've received phone calls from individuals within my community. I have pictures of ICE near one of the local libraries in my district. Like I said, I don't have exact numbers, but I have been receiving those concerns from my constituent.
I love you, Delegate, but I think we need something a little more substantive than that.
And I'm sure CASA can speak about the hotline and the calls that they have been receiving as well from individuals across the state of Maryland.
I understand the calls and the hotline, but is there data? Is there something hard? Because we talk about like tangibles here.
Yes, there is concrete data, and I will pass it over to Ms. Wolf in just a second. I do want to highlight a specific case example. At some point, I could even share a specific Maryland case number with you all of an individual who was arrested, Cecil County, second-degree assault, which of course is a minor charge, just a month ago. I heard rumblings,
going,
right? But again, does
going.
not fall under the category that you are mentioning, right? But this individual the district court judge found it fit to issue a low bond. Family posted the bond, and instead of the individual being released, he was transferred to ICE. He will not be able to go to his court date in March to even say, hey, I wasn't the person you were even looking for, or hey, I'm not guilty, right? Why? Because ICE has transferred him to El Valle Detention Center in Texas. That is what is happening with 287G, right? There are concrete examples, concrete cases that make it clear that, respectfully, the messaging that ICE is sharing with you all is just not true.
Well, let me move to my next point. And I do believe that was part of the complaint of ICE for not shutting down Maryland's detention centers that were here, is that we wouldn't have to transfer those folks to Texas or Pennsylvania or somewhere else. I wanted to wrap up with this question. The example we gave was, one of the examples we heard was, they're arresting someone or they're holding someone for not a crime of violence, but for urination in public. So if you've come here illegally and you violated federal immigration laws, and then you come here and you violate the criminal penalty of urination in public, and I go back to my district and I say, well, what do you think we should do with those folks? They would say that person is really not representing American values. They violated federal and criminal law, and we believe the majority of people from my district would say that they want our local law enforcement to work in cooperation with ICE. So my question to you is that if we have to kind of normalize this behavior of violating federal immigration law and subsequently allowing people to skirt criminal law, what values, you've mentioned the values, what values are we really advocating for here?
Yeah, I don't think we're advocating for people to circumvent our immigration laws. Part of the problem, and this is outside of our jurisdiction, is really fixing our immigration system, and that's something that can only be done on a federal level. Unfortunately, none of us in this room have the authority to fix that right now. But that's really where the rubber meets the road. And so what we're saying is we are not going to use our resources here in the state of Maryland for ICE to do their job. ICE needs to use their resources to do their job.
Well, hopefully they have a great giant facility here in the state so they can do that. Thank you, Mr. Chair.
If I could just add really quickly.
Thank you, Mr. Chair. I'm intrigued by my colleague's questions and some of where he was going with it, but I just want to continue pulling on his line of questioning about whether there's any basis for concern in Maryland. Isn't it the case that we actually have Maryland cases where there are constitutional civil judgments that have been issued into the hundreds of thousands of dollars exactly for the case that was described, someone being arrested for eating a sandwich? Is that not true?
That is true.
Is it also true that it was not ICE that caused that problem? It was a 287G local Maryland county's police department that caused that problem. Is that also true?
Yes, and that local jurisdiction had to settle that case and use taxpayer resources to pay that settlement.
And it was more than one case. Is that also not true?
That is correct.
Thank you.
Delegate Carvalho.
Thank you, Mr. Chair, and thank you, Delegate, for bringing this bill. I just want to first go on record to say that I am not in support of anyone abusing their power and people being intentionally targeted. But I also have to mention that I am a mental health therapist, so my job is to really help people, manage their anxiety. And I'm hearing a lot, especially the word fear. And I'm in the role where I have to really help people understand that fear is a reactionary emotion, and I am here to help people balance emotion and intelligence. So I'm hearing a lot of fear and a lot of emotional, messaging, but I don't hear anything that's really showing, where that fear is actually coming from. I've heard isolated events. One event is too many in my opinion, but we really need strong data to really, at least help our community see exactly where we are. I mean, I'm hearing from advocacy groups, I appreciate your advocacy, but I mean, where is the data to support this? Because I just haven't heard any strong numbers. The only numbers I've heard today are 287G and 75 arrests per day is the quota. So what in, the counties that you mentioned, Frederick, Hartford, Cecil, how many people have experienced, specifically, how many people have experienced these type of events where they were in, it sounds like it's a jail enforcement model. So how many people were in the jail and then they were actually, progressed or moved through this whole ICE process that you're referring to? How many people?
I would love to answer that. So in my written testimony, I did cite a lot of data. The overall numbers of the data that we have runs from the end of 2016 through, I believe, either the end of 2023 or the end of 2024. It's about a 7-year period. That was, in that time, in the counties that had 287G in Maryland, there were just under 800 people that came through this program. That's a little bit of so that's over this period of 7 years, which encompassed 2 different presidential administrations, and there's some significant differences between the first set of years and the second set of years. But what I think is really important to note is that of those 770 some, there were more than half were people who had no conviction at all. The vast majority, 92%, were people who had either no conviction at all or a minor level 3 conviction, which the exact definition of what counts as a level 3 conviction is not super clear to me, but we know it's a misdemeanor. And so either no conviction at all or a misdemeanor is 92% of the people who are coming through the 287G program. That remaining 8% are people who had some kind of felony conviction. Of those 8%, only 4 individuals of the 770 some had a level 1 felony conviction that is what ICE considers to be the most serious conviction. So this is exactly not targeted at people with serious convictions. It is doing exactly the opposite.
Okay, thank you so much for that. I mean, that really helped clarify things based on the numbers you just gave. So, but it sounds like the data is, you said 2016 through 2024, so we don't have any data since the executive order, since the new administration. Is that correct?
I do not, and I think, at this point, what we have is what CASA is seeing through the hotline. What I am seeing, I'm the Director of Immigration for the Office of the Public Defender. I have some anecdotes, and I can tell you the folks that we are seeing detained are not people who have convictions of serious offenses in many cases. We had very recently an instance of a gentleman who was detained after he elected to serve 2 days on a driver's license offense in order to try to avoid the conviction because he had some immigration applications pending.
Okay, so you're talking maybe 2 or 3 cases. So you have not seen a significant increase since the new administration?
I have. I certainly have.
Can you provide those numbers?
I don't have, the numbers are low still, but it is a marked increase from before.
Okay, so we don't have exact numbers.
I don't have the exact numbers.
Okay, how many calls or complaints are you receiving to the hotline? Can you give us exact numbers? How many per day? Not anecdotally, not this is one caller and isolated, exact numbers.
Absolutely. And transparently, we have not done a complete analysis of that, but would love to be able to send you that information. We are working in partnership with the Amica Center for Immigrant Rights, the ACLU, with OPD, right? It has been 1 month, right? And so we are really trying to compile those numbers so that we can have concrete analysis of what exactly we are seeing and how much things have increased.
I think that, if, and it seems as if you all are very passionate about this, I would think that you would pounce on this day one and monitor and track it daily if this is such an issue in communities. Respectfully, Delegate Simmons, he and I are both representing Anne Arundel County. I've heard that, they're going into schools, but every teacher I've talked to, every school, I've done my research, and I can tell you unequivocally there have been 0 cases of ICE going into schools. Okay, I can tell you that for sure, 0. Prove me wrong. Please correct me if I'm wrong, because I want to know. Anne Arundel County has seen 0 in our schools.
Delegate, you're absolutely right. The proper public information is so critical these days. I mean, and I think we're seeing social media and all that. I see the same. What I would say, though, respectfully, is that when I hear the term gaslighting, we hear national rhetoric, we read it in the papers, we see it filtering down, and then when we come to you and say people are scared, I think the rhetoric was meant to create that feeling, and I think it's being very effective. And you're right, and I'll tell you, as a city council member, I have thousands of emails, as I know you all do too, but I haven't sat there and counted them, but I'm happy to come back to you and say and I'm actually going back to Frederick tonight for a community meeting, and so I'm happy to transcribe what people are saying, but it is real, and I ask just for your partnership and trying to make this work. Thank you.
The other question I have, and I know that this is probably sensitive for a lot of people to share their personal experiences, especially if they have undocumented or if they're undocumented. But do you have people here today who are not advocates, who are not attorneys, that are going to share their stories with us today? Actual people.
Yes, Delegate, we do have impacted community members who are here today to share
Thank
their
you so
stories. And if I just may make one clarification, I just wanted to make clear that yes, at CASA, we are tracking, monitoring every single day calls that are coming through. I would much rather give you a concrete number, concrete analysis, and not just, kind of throw out the estimated number, which is why I asked you to provide it later on. Okay. And one final point, right, is the fact that we cannot minimize the fear, right? If we are talking about we want to be in a place where public safety is enhanced, regardless of the numbers that we are seeing, people are afraid. If people are afraid of the police, the calls that we get, people think every person in uniform is an ICE officer. They think every marked car is an ICE car, right? And so we need to make sure that we're clearly delineating who is ICE and who is local law enforcement. Right now in Cecil County, Frederick County, Harford County, people don't know, if I call for help, am I essentially calling ICE on myself, or is someone going to help me? And so again, that is what this bill is meant to do, is to end 287G, not to end cooperation with ICE, but to disentangle local law enforcement from ICE so that it is clear who is doing what job and who the community can look to for trust.
Okay, and thank you for that. And I'm going to say that I'm not in the business of minimizing fear, but I certainly am not in the business of inducing or exacerbating fear. I'm in the position to help people manage their fear, and I help people manage their fear by allowing them to see what's realistic, what's logical. Are we being reactionary, emotional? And while we're working, at the same time to resolve the issues, okay? But in order for us to do that, we need to do it with specific information to give to people to help manage the problem, solve the problem, and manage emotions.
Isn't that so?
Isn't that so?
Isn't that so? All right, here's what we're going to do. Delegate Pasteur, then Delegate Simpson, then I'm letting this panel go. It's 2:20. We've been on this panel for an hour, which is actually sometimes a little short for us. But having said that, there are many more people who want to testify. So I'm going to set in some rules of the road on questioning after this panel is done. Delegate Pasteur, Delegate Simpson, and then we are moving on to the next panel.
Thank you, Mr. Chair. I just want to know there's been so much because there's been a lot of conversation here. Bottom line with the bill, 287G, if gone, will folks who want to contact ICE or able to contribute any of the information that has been asked for today, how do they do that? What happens? Just what is the bottom line here?
I mean, they could still contact them.
Ending 287G does not end cooperation with ICE, right? Localities are still able to determine what is the scope and level of engagement that they want to have with ICE. 287G does not change anything else, right? It's just ending that specific practice of local law enforcement acting as ICE agents.
Thank you.
Delegate Simpson for a 30-second second bite.
So does about over 1,500 Frederick residents that have been processed for deportation and 81% of them being for traffic violations and nonviolent offenses sound about right?
Yes.
It's actually 88% for misdemeanor, 60% for minor traffic violations.
Thank you for the correct. Appreciate it.
All right, thank you very much. That concludes the testimony for this panel. Now I'm going to call up the second panel. There are two people who are on virtually in the second panel, but in the room, Connie Serrano Portillo, Joanna Silver, and Solomon Ayalu. Virtually, Eric Lopez and Bayron Cardona. From here, for the purposes of, for the advocates of the bill, there are still quite a few people who are going to testify. I'm just going to go straight through the lists unless I hear differently from the sponsor. Okay? So with that, start from my right and move across, please. Go ahead for 2 minutes. I also, but before you start, so what I'm going to say to members of the committee, when we get time for questions, I'm going to be looking at my watch, my phone, I guess, and I'm going to give it about 3 minutes in total, and then I'm going to ask you to start wrapping it up. I'm going to also ask you, this is, your job is to ask questions. Questions would be appreciated, and I really don't want to have to say, isn't that so, at the end of it. So let's try and keep it pointed so that we can continue to hear from more people. Go ahead for 2 minutes, please.
Good afternoon, Chair, Vice Chair, members of this committee. My name is Connie Serrano Portillo. I serve as a council member for the town of Edmonston in Prince George's County. And I came here today to express my support for this bill. I've added amendments to my written testimony, but I will just focus on my story today. In 2008, when I was 17, my stepfather, and the only man I've ever called my dad, was deported. I vividly remember waking up to my mom screaming on the phone. I remember waking up confused, scared. It was 6 in the morning, and he was supposed to be returning home from his overnight construction job. He was supposed to wait on the couch until I was ready to drive me to school. He was supposed to put on our favorite music on that drive. He was supposed to drop me off and tell me to have a good day. He was supposed to be home after school to help me with my math homework. Instead, the next months felt like a blur. I watched my mother go from action mode to a slow but steady depression that gradually kept her from parenting me. I graduated high school, I went off to college and moved out of the state, all while my mom only worried about immigration paperwork and saving enough money for us to visit my dad. I lost my dad that day, but for a few years I lost my mom too. I am here today to testify on behalf of thousands of undocumented Marylanders who are afraid to walk into this building. For years, our communities have spoken out against 287G, a deeply flawed policy that targets people who just want to live in a country that allows them to provide for their families. In the last few weeks alone, we've seen businesses, schools, and places of worship subjected to aggressive immigration enforcement actions. I hope that my story has left you with some perspective. My father is now a teacher in a public school charter school in DC. My mom continues to do social work for adults seeking career readiness and education. My brothers work and go to school. We are an extremely small percentage of families that have been able to reunite and move forward, but I'll never not have the memories of the day my dad was detained and the days, months, and years that came after. Thank you.
Thank you. My name is Joanna Silver, and I am testifying as a community member who has a close familiarity with the issues raised by HB 1222 through my over 20 years as a federal public defender here in the District of Maryland, where I regularly represent people charged with the crime of illegal reentry into the United States after deportation. I urge the committee to issue a favorable report on this important bill, but with an amendment to the language requiring the transfer of certain people to ICE detention. I want to make a few brief points to supplement some of the other reasons offered for ending 287G in Maryland. First, ICE usually prioritizes people with more serious criminal histories for prosecution for illegal reentry. As a result, it is actually unusual for me to get a case in which my client came from a 287G program, since that program tends to catch low-level offenders, including many whose charges are dismissed. Second, I want to make sure you understand that if there is probable cause to believe that someone committed the crime of illegal reentry or another immigration-related federal offense, it is easy for ICE to get a judicial warrant from a federal court and send that warrant along with the detainer to a local jail. This will be even easier now as the Department of Justice has instructed its U.S. attorneys to accept every ICE referral for an illegal reentry prosecution. A final note is that my illegal reentry clients are all people who are here without lawful status, who have some criminal history, yet they are also parents and children and extremely hard workers who contribute to the fabric of this economy and its community. They have the same complicated reasons for their criminal involvement as my other clients, such as adverse childhood experiences, often in their home countries, and they are all capable of the same rehabilitation as my other clients, given the opportunity. An opportunity that cooperation with ICE through programs like 287G usually eliminates. Thank you very much.
Good afternoon. Thank you. My name is Solomon Ayalu, and I'm representing African Communities Together, as well as here in solidarity with CASA. Maryland has long been a place where cultures, histories, and communities come together. Our state is home to the 4th largest share of immigrants in the country, and coincidentally, the 4th largest share of African immigrants as well. Racial profiling permeates this 287G. With 287G is putting a target on Black migrants back, on Black communities back as well, as these officers are not adequately trained to do this work. For ICE officers, they're trained, I think, up to 12 weeks, while local officers are only given up to 4 weeks. This is not adequate training, and inadequate training leads to racial profiling, leads to mistakes, leads to deportation that should not have occurred, like the stories you just heard here today. Additionally, this is a costly program. It costs Frederick County, according to Center of American Progress, $3.2 million annually while it was in function. And that is enough to hire 50 to 60 teachers. And we all know there's a teacher shortage. What are we doing? That's the real question here. So my question is, why are we spending money to terrorize our residents? Why are we spending money to create a culture of fear? Why are we spending money to make it so that people are afraid to come out? The Center of American Progress also released that in a study of undocumented Mexican immigrants that 61% were less likely to report witness crimes, and 43% were less likely to report victimization due to the fear of deportation. So just like with all stacks, there are exceptions. There are people that would be willing to come out for a U visa. There are people that would be willing to say something, but the vast majority of people are terrified. We have mosques, we have churches where their congregations have dropped considerably because they're afraid to come to church, because there's no safe space when this 287G bill is enacted.
Byron Cardona, please, for 2 minutes.
Thank you all. My name is Byron. I'm a Frederick resident, and I am being a victim of 287G. Back in 2009, I was a passenger side in the car, and I get arrested by a police department in Frederick, Maryland, and arrested and be in the jail for 1 month. And one more thing, a very important thing is, eight out of 10 people detained at the same time with me. Was with zero criminal record in Frederick, and I was in the cell with a drug dealer guy, and I'll be suffering this one for a long time, and that's why I said the psychological and moral impact. The impact cannot be erased from my mind with the time, and I've been arrested 2 times in Frederick. For these special and very bad 287G. More than 2,000 deportation has been in making immunity condition, has been racial profile, and just the people are overwhelming black, brown, and black people in there has been detained, and it was in 2009, and then back in 2013 I'll be detained again for the Frederick Police Department. And put in the jail for a month, only with driving with no license, with driving no license. Now I'm a resident in Frederick. I own 3 houses in Frederick. I'm paying taxes to the Sheriff Janskin in Frederick, and I'm thinking to move for another state that I'll feel welcome. I don't feel welcome in Maryland anymore. 287G is not good for people. Thank you.
Eric Lopez, please, for 2 minutes.
Thank you, Chair, Vice Chair, and committee members. My name is Eric Lopez. I'm a Deputy Program Director with the Amica Center for Immigrant Rights, and we respectfully request a favorable report with amendments on HB 1222. The Amica Center provides legal representation services to individuals in ICE custody. We have witnessed firsthand the devastation that immigration detention and deportation wreaks on an individual, their family, and community. 287Gs cause real harm to Marylanders. First, Marylanders detained by ICE are dehumanized and thrust into a confusing system and removed from their families, communities, and livelihood. These people are primary income earners for their households, whose family goes out without food, loses the ability to pay rents, and is often displaced. There's also the emotional and psychological harm that family separation causes on the detained person, their spouses, and their children. Second, employers and local businesses are harmed when they lose their workforce to ICE detentions and are left to bear the turnover costs. Local governments and states also suffer from ICE detention when they lose tax revenue when detention leads to deportation. Third, they make our communities less safe. As immigrants without lawful status fear having any contact with law enforcement, even when they have been victims of crime. But this extends beyond those without lawful status. It is also felt by those with lawful status who fear losing it, and those in mixed status households who are U.S. citizens but fear that contact with law enforcement will prejudice the family members. I'd like to highlight one example of a case we've worked on. Susan, the victim of domestic violence was a victim of domestic violence at the hand of their U.S. citizen spouse. She was arrested in the 287G jurisdiction when their partner made fraudulent allegations against them. Their employer turned out to court, and she was turned over to ICE, where she spent months in detention before moving forward. ICE detention is up nationally. We're talking about daily averages of 40,000 people. Please support 1222 with amendments. Thank you so much for your time.
Questions for this panel? All right, seeing none, thank you all very much. I'm going to move along to next panel. Aaron Mansour, Bridget Sharp. We have Mayor Jordan, who should be virtual. No? Well, we'll see if we can find them. Yaiza Hernandez and Amos Fawn. All right, we'll start from my right and move across. So please, if you begin for 2 minutes.
Okay. Good afternoon, members of the committee. My name is Erin Camp Mansour, and I'm a member of Patapsco Friends Meeting, which is a Quaker faith community in Ellicott City, and a partner congregation of Christ Church Interfaith Refugee Ministry. I'm also a member of the faith-based advocacy group Quaker Voice of Maryland. Quakers and other friends across Maryland have shared with me their deep concern for immigrant protections. We see HB 1222 as an urgent priority in response to the ongoing use of certain agreements with federal immigration enforcement agents that deputize local police in order to implement federal mass deportation policies. Our Interfaith Refugee Ministry currently has 7 Afghan families who have been resettled in our area over the past several years. Our friends arrived with various forms of protective legal approval and documentation. Many of our friends worked with the Americans in Afghanistan, but were forced to flee their country when U.S. forces left because they were harassed and threatened by the new authorities there. Now that the U.S. immigration processing system has ground to a virtual halt and policies are changing almost daily, we are worried that our friends will lose their legal immigration status and face new dangers. They could become undocumented immigrants. Because they have dark skin and don't speak English very fluently, we worry that they will be stopped and interrogated by police, perhaps for a minor traffic violation, for example. Then they may be detained while police and immigration enforcement agents try to determine their legal status. Sean Van Diver, a military veteran, summarizes the situation this way. We made a promise to our Afghan allies, and fulfilling that promise is not just about policy, it's about honor and integrity. I agree with Sean. We owe it to our friends to ensure that they are not harassed, detained, or forced to leave the country like they were by the Taliban in Afghanistan. We hope the passage of this bill will help protect our families and others from unwarranted and discriminatory immigration enforcement actions. Since the bill sponsor has amendments to the bill, we ask for the committee to issue a favorable with amendments report for HB 1222.
Hi, my name is Bridget Sharp. This testimony is being submitted on behalf of Candle. Our organization supports HB 1222, Maryland Values Act. Our original written testimony was submitted as favor. We'd like to change that to favorable with amendment. Enacting this bill would end 287G agreements in Maryland, ensuring that state police and sheriffs meet the needs and values of Marylanders and not the political whims of the federal government. Marylanders want their law enforcement agencies to keep their communities safe. 287G agreements make communities less safe. They make fighting crime more difficult as they cause community members to be fearful of police and thus reduce access to important information needed for solving problems. And they siphon state funding away from fighting crime and into the enforcement of federal civil immigration laws. Marylanders do not want their law enforcement agents to target people simply because of the color of their skin. 287G programs have been shown time and again to increase racial profiling. Marylanders do not want to pay for lawsuits defending law enforcement agencies that have violated civil rights under the auspices of their 287G activities. Finally, we believe that having Maryland law enforcement agencies answer to the current federal administration would be very dangerous. You have a chance to keep Marylanders safe now. Please don't lose this opportunity. Therefore, we urge the committee to issue a favorable with amendment report for HB 1222.
Dear Chair Clippinger, Vice Chair Bartlett, and members of the committee. My name is Yaisa Alexandra Hernandez Romero. I am a 20-year-old college student and a proud resident of Frederick. Although with our 287G agreement, less proud resident of Frederick. I am also a member of CASA. As someone living in a 287G county, I have seen firsthand how this program instills fear in immigrant families, fear that a simple traffic stop could lead to deportation, family separation, or being permanently torn from the place they call home. This is not just a theoretical issue for me, it is deeply personal. My friends, my neighbors, and even members of my own family live under a constant anxiety. As a student pursuing a degree in criminal justice, I am taught that foundation of public safety is trust. But 287G destroys that trust, forcing entire communities into the shadows and making everyone less safe. Beyond the harm it causes communities like mine, 287G also exposes Maryland local government to costly legal risks. Court has ruled that holding individuals past their release for civil immigration matters violates the Fourth Amendment, yet counties continue to bear the legal and financial consequences. As a future criminal justice professional, I believe that our tax dollars should go toward crime prevention and public safety, not towards a program that fuels fear, divides communities, and weakens law enforcement ability to do its job effectively. The Maryland's Value Act ensures that Maryland prioritizes community safety over federal deportation efforts. It strengthens public safety and reinforces our state's commitment to justice. This bill is for the people like me. It's for families like mine. I respectfully urge the committee to provide a favorable report with amendments. Thank you for your time and consideration.
Thank you. Sir, go ahead for 2 minutes.
Good afternoon, everyone. My name is Amos Fon. I'm a proud immigrant from Cameroon, a pastor and a longtime resident of Montgomery County. I'm here today because 287G is hurting my community, and we need the Maryland Values Act to end it. I know fear.
My name is Emmett Jordan. I'm mayor of the...
Mayor Jordan, please stop.
I know fear. Many of us who fled our country, Cameroon.
Sir, we're just going to ask you to hang on. I'm going to let you start again and do 2 minutes. Mayor Jordan has decided that he would just go ahead.
Am I on?
Oh, boy. Mayor Jordan is on a delay, and that's what we sometimes have happen when they're listening to the...
I'm sorry, should I begin?
You should mute, if you can hear me. There we go. Sir, in the room, we're going to let you start again for 2 minutes. So please go ahead, okay?
Okay, thank you, sir. I'm sorry for the interruption. Good afternoon, everyone. My name is Amos Fon. I'm a proud immigrant from Cameroon, a pastor and a longtime resident of Montgomery County. I'm here today because 287G is hurting my community, and we need the Maryland Values Act to end it. I know fear. Even if we say that fear is false evidence appearing real, we need trust to make sure that that false evidence doesn't exist. Many of us fled Cameroon to escape violence and persecution, hoping to find safety here. But for Black and African immigrants like me, that fear doesn't end at the border. It continues in the form of racial profiling and immigration enforcement that targets us unfairly. As a pastor, I visit congregations all across the state.
I'm sorry, am I muted? Can I speak now?
Emmett, look at your phone.
My apologies. Yeah. Am I...
Okay, he's muted. Sir, continue, or try to continue. We'll ask the mayor to please stop talking for a little while so that we can hear you.
As a pastor, I visit congregations all across the state. In places like Frederick, I have seen big, beautiful churches full of people become almost completely empty. This is real. This is what happens in places where the police are eyes. People stop showing up, not because people have lost faith, but because they are afraid. Afraid to drive, afraid to go to work, afraid to worship. Is this the Maryland that we want, where immigrants like me and people like me are scared to go to church? Families avoid hospitals. Children hesitate to go to school. No one knows if they will be separated from their family or deported at any time. This is not just an immigration issue. This is a moral issue. No one should live in fear because of the color of their skin or the country they were born in. This 287G program makes us more divided. I urge you to do what is right and pass the Values Act and show that Maryland is a place where all people are treated with dignity and respect. I said that fear is the absence of trust, and the only way to bring trust or to stop fear is to restore trust. Because it's true that most of the things we are afraid of may not happen, but because of fear, we don't do the things we are supposed to do. Thank you very much, sir.
All right. The next person to speak is the mayor of the city of Greenbelt.
Thank you.
Okay.
I'm sorry. So my name is Emmett Jordan.
We're
Mayor of the
ready
City
for
of
you.
Greenbelt, and I'm speaking today in support of the amendment of House Bill 1222. We're grateful to our delegate Nicole Williams for this legislation. We believe it represents a crucial step towards balancing public safety concerns with the need to maintain trust and cooperation between law enforcement and members of our community. By focusing on individuals convicted of violent crime while managing broader cooperation with federal immigration enforcement, the bill strikes a balance between enhancing public safety and preserving community trust. In Greenbelt, we know that building trust between local government and residents strengthen public safety and community bonds. So our police department, like most across the state of Maryland, focus on using our limited public safety resources on protecting and serving every community member, regardless of their status. HB 1222 provides guidelines for law enforcement interactions with immigrant communities. It restricts inquiries about immigration status during routine police functions while allowing for such inquiries when relevant criminal investigations are when they are in play. So this clarifies and helps our police officers perform their duties more effectively and consistently. So we strongly support House Bill 1222. A couple of suggestions. The conversation about detainer requests. Our city, we have holding cells, but we do not have the capacity to detain anyone for more than less than a day. So we really don't have the capacity. It's a burden to ask us to do that. So you can find our other suggestions about amendments in the written testimony, but I just want to thank you for being able to testify on behalf of this important bill. Thank you.
Thank you. Are there questions for this panel? Not seeing any. We thank you all very much, and we're going to go to the last panel, which will include virtually Mr. Green, who has been on the screen this entire time. And so we will have Mr. Green, Sarah Sample, Heather Crick, and Ms. Hoydra. Nick Katz, last chance. All right, Mr. Katz was yielding his space. So we have 4 people on the panel. We'll start for the people that are inside and start from on my right. And that is Ms. Sample. Please begin.
Thank you to the chair, members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we are here to support with amendment House Bill 1222. Our amendments were already addressed by the sponsor panel. Our biggest concern was potential liability for holding somebody for the 48-hour time period without a judicial warrant. Right now, most of our facilities are not holding them without a judicial warrant. So we just want to make sure that we have that in place. But I'd also add that you've already heard today that it's not many of these individuals that are leaving our facilities. So it is sort of a narrow circumstance, but we just want to make sure that that liability is covered. But we've already heard that amendment today, so we would support if it gets included. Thank you.
Thank you so much. Good afternoon, Chairman Clippinger, Vice Chair Bartlett, and members of the Judiciary Committee. My name is Sherry Hoydra. I'm a private immigration attorney and chair of the MSBA Immigration Section. We are here asking for a favorable report on House Bill 1222 with amendments. And those amendments, many of them are technical in nature. One of them is not the definition of crime of violence. We don't have a problem with the terminology used in that on that sense, but we do have issues with the terminology being used of not technically, being lawfully present in the United States. That definition is not even defined really federally. We can't impose a separate definition of that such that, local law enforcement can actually comply with that in a way that can actually protect both the state and Marylanders. We also have problems with the lack of a time limit on the conviction of the crime of violence. The proposed language is providing for a detainer for a person convicted any time. We're not all right with that. There's an issue of retroactivity. There's really no idea if this, based on this language, if someone is currently being held or has previously been held. That's problematic. Also, the detainer statute, federal level, is not mandatory in nature, and our own Attorney General pointed that out. This is merely a request, and law enforcement cannot require, or federal law enforcement cannot be required, or Maryland law enforcement cannot be required to comply. So each LEA has to decide for themselves. So officers with an inadequate level of training would be led to commit civil rights violations through racial profiling, false arrests, et cetera, through this mandatory assisting with transferring detainees. That's problematic. We are in support of the language terminating 287G agreements based on the lack of training of officers and meeting a quota. It's highly problematic, and we don't think that 287G agreements are helpful for our state. Thank you.
Good afternoon, Chairman Clippinger, Vice Chair Bartlett, and members of the Judiciary Committee. My name is Heather Crick. I am a public interest attorney and practicing in Baltimore City and residing in Anne Arundel County. I'm a member of the Maryland State Bar Association's Immigration Law Section Council and ask you to give a favorable report with amendments. I also want to emphasize that this bill does continue cooperation between ICE and state and local governments and law enforcement agencies. It codifies the agreements that already exist, which should continue to be at the discretion of the localities. ICE has the capacity and the responsibility to enforce federal law, and immigration law enforcement is within their function, not within the function of state or local law enforcement agencies. It should not be codified in a way to bring more risk, liability, or cost upon the state and local governments and law enforcement agencies, or to switch the cost between the to the government agencies as it is written. You've heard that it does bring the responsibility and switch the process from the federal government to the state governments to transfer between those holding centers and to the federal governments itself. We do ask for a federal report with amendments. Thank you very much.
Mr. Green, here for 2 minutes.
Thank you very much. I want to thank my other colleagues from the Maryland State Bar Association Immigration Law Section, members of the General Assembly. We are experts in law. I have been practicing for more than 25 years. I'm a former chair of the Immigration Law Section and a founder of the section. I've been both an expert witness and a former adjunct professor of immigration law. I think you've heard already that we are in alignment with the previous testimony regarding the 287G agreement provisions, but the detainer provisions, we have proposed specific amendments for. We understand that this proposed bill, the Maryland Values Act, would create mandatory provisions for engaging in detainers with ICE. And we want to make sure that the bill is drafted, comports with federal immigration law. We understand federal immigration law probably more than anybody else in the state of Maryland because our practitioners have been spending years and years working through this. Our section includes judges, immigration judges, and also federal government officials. So we have the input of all different sources for this. We think that the federal government should engage in its immigration function and that state law enforcement needs to focus on protecting the people of the state of Maryland for criminal matters. So for detainers, we want to make sure that the specific language that is proposed would be amended such that it comports with federal law to the extent that detainers should not exceed 48 hours. This is clear in federal law, excluding Saturdays, Sundays, and holidays. Also, the bill should make sure that the custody is going to be assumed by the U.S. Department of Homeland Security, as opposed to people in the state of Maryland and agencies transferring to the federal government. We want to make sure that only federal immigration officers authorized under the federal regulations are the ones who can invoke the detainers. That's federal law. And that this pertains to people who are in the custody of state and local correctional facilities. Thank you.
Delegate Phillips with a question, then Cardin.
Thank you, Mr. Chair. And to Ms. Sample, you represent all of the counties of the state of Maryland, is that correct?
That is correct.
And the counties have come to a consensus in support of this bill?
Yes. We have a legislative committee that happens every Wednesday, and we review the bills that we think have big operational or fiscal impact, and we discuss them and we come to a decision. And I would say 95% of the time it's unanimous.
Thank you.
Thank you.
Delegate Cardin.
Thank you, Mr. Chair. Thank you all very much for coming and for everybody's very important testimony. But this is for Mr. Green from the MSBA. I just want to make sure I understood. So it should only be ICE that is holding or contractors of ICE that should be holding these people in custody? Was that my understanding?
Yeah, thank you for your question, Delegate Cardin. This is a really important question. Who's supposed to detain the people and then what happens to them? So the bill as drafted doesn't really clarify that this is supposed to pertain to people who are currently in state and local correctional facilities already, as opposed to empowering state law enforcement officers to go out and have to arrest and detain people. So we want to make sure that this really focuses on what the detainer under federal law is meant to do, and that, again, consistent with federal law, that the U.S. Department of Homeland Security has to arrange to come pick up people if it's interested in doing so. This bill is not supposed to compel people in the state of Maryland from actually going out and engaging and rounding people up. This bill is supposed to simply comport with if there are requests from the Department of Homeland Security, from authorized officers, then our facilities have the ability to comply with federal law.
Got it. Thank you very much. And, I'm looking to see if did you guys provide written testimony so that we can refer to it? If not, maybe you could shoot something in.
Yes,
thank you.
Written testimony has been provided, including with the amendments on these particular provisions.
I'll find it. Thank you very much.
All right, seeing no further questions, that concludes this panel, and now we will go to those in opposition. In opposition, Daniel Franklin, Eric Roby, and Yvonne Chester. Whoever would like to go first, usually I start from my right and move to the left, so. Sir? For 2 minutes.
Thank you, Mr. Chair. For the record, Eric Roby, Director of Legislative Affairs, Harford County Sheriff's Office. Sheriff Gaylor had submitted some written testimony. He's sorry he couldn't be down here for the hearing today, but he did want me to send his best to each of you for the work that you're doing during this 90-day session. So I just sat here and I listened to the proponents of this legislation speak to you about a number of different issues. And I'm going to be honest with you. If I listened to everything that was just said here and I believed every word that was said and I knew that that's exactly what was happening, I personally would be opposed to this. I personally would be supportive of this legislation, opposed to the 287G program. But that's just not the facts. We've had a 287G program in Harford County for the last 8 years. This is a corrections-only program. This is not a law enforcement program. Our deputies are out on the street every day, are not out there making arrests, immigration arrests, or asking people what their papers are, what their status is in this country. That's just not happening. What happens in a 287G program is someone is arrested for an offense, and normally that offense is an assault, a DUI. They had mentioned about, the local, coming into the local facilities and how these are not heinous crimes. Well, I can tell you I've got 2 heinous criminals in our detention center. One that murdered Rachel Morin, or was suspected of, let me back up, was suspected of murdering Rachel Morin, and the other one who was suspected of murdering Kayla Hamilton, a 20-year-old autistic girl in our community. They're in our facility. They're in this country illegally. We've had this program in effect for 8 years. It works. It's a good public safety tool. And our concern, and the sheriff has said this over and over again, is not individuals that are in this country trying to make a better life, doing great things, working hard. It's for people that are criminals, that are committing crimes against the citizens of the state of Maryland. And for that reason, we ask you to oppose House Bill 1222.
Thank you. Afternoon, Mr. Chair, Vice Chair, members of the committee. Dan Franklin, Chief of Police, Morningside, Prince George's County. I'm here on behalf of the Maryland Chiefs and Sheriffs testifying in opposition to House Bill 1222. For the record, I encourage all of you to check my facts and question any of the statements that I make. My first one is a question. I would really love someone to please provide me some documents where state or local police officers have been ordered to go out and arrest undocumented immigrants for just that. My jurisdiction sits at the front door and side door of Joint Base Andrews, where president and dignitaries come and go daily. I have yet to see ICE in my community or provided with any such orders. There's no data to support a lot of these things that are being put forth. Because there's no data, because there's limited judgmental incidences, you're making, a lot of these are making the fear of ICE equivalent to the proverbial monster under the bed. It's just not happening that way. When someone breaks the law abroad, whether it's a U.S. citizen or otherwise, they are held there, tried there, and jailed there. Under a lot of the things that go on in the United States, if you commit a crime here and you're from another country, you get returned often without facing charges here. Justice is not served all the time. The other thing that concerns me about this is basically we're drafting a law here that flies in the face of justice. You're drafting a law that encourages not enforcing a law. Terrible precedent. Just very problematic to me. There's 3 county facilities that are in the 287G program. They're all jail enforcement models. I've heard that it's not an effective public safety strategy. Since when is removing criminals from the streets and keeping them out of the public not an effective public safety strategy? For all these reasons, I ask for an unfavorable report, and I thank you all for your time.
Thank you. My name is Lieutenant Yvonne Chester, and I'm representing Harford County Sheriff's Office. I am the Chief of Security of the Detention Center in Harford County, and also a designated immigration officer, or a DIO, for ICE. I have been a DIO for about 8 years. Ran the unit for probably 7.5 of those years. I did the statistics for those the unit. I can tell you that 287G works. I can tell you that the crimes that come in that are being committed by individuals that are foreign-born are not only just driving without a license, you know, your misdemeanors. Like Eric Roby said, we have 2 incidents just in Harford County alone where 2 foreign-born individuals snuck into the United States. Neither one of those were even recognized by immigration because they snuck through the border. They committed a heinous crime, raped and murdered 2 innocent women, one that had 5 children, one that was a special needs girl. And had they been released, had we not had a 287G program in Harford County, immigration would have never known they were there because they had never been fingerprinted. When you come across the border and you do that, come into the country the correct way, and you get your fingerprints done, you pay your fee, you do your paperwork, they do your background, they know that you're here. So we have 2 murderers that just came through here within the last couple of years that terrorized our county, terrorized them. Our citizens were extremely scared to go out. Harford County is, I can't say 100%, but very close to 100% behind 287G. It works. Thank you.
Thank you, Mr. Chair. Thank you guys for being here. I appreciate all of you. Good to see you guys. So to Ms. Chester, you said you actually are one of these enforcement agents. Well, thanks for going through the process and doing that for us. Could you tell me a little bit about what the actual process looked like during intake? Like, I think there's a misconception that there's like papers, and well, what does it actually on the ground look like?
Okay, so when someone comes into our facility, we ask the same set of questions to everyone, regardless of their skin color, you know, if they speak English, if they don't, okay? So it is, you know, what is your name? What is your address, your date of birth? You know, where were you born, your country of birth? What citizen are you a country of? Do you have tattoos? Do you have any gang affiliations? Every person is asked the same set of questions. They're all screened the same way, okay? So when someone that comes in and is foreign born, and they say to us, you know, yeah, I was born in, I don't know, Guatemala, fine. They then notify our 287G unit, and one of our DIOs will come up and look to see their legality within the United States. We ask them a set of questions, we fingerprint them. We've had a serious amount of influxes of what we call EWIs, which is entered without inspection, okay, that have come through. And I can tell you that not everyone that comes through those doors gets a detainer.
Right.
They do not. I can't tell you how many people Since Trump has been in, a little bit more. But when Biden was in, it didn't matter what their crime was.
Wow. So
pretty much. I can't say for everything, but I mean, your DWIs, you know, your even some of your assaults, they didn't touch them.
Wow.
We would issue them a court date, and they were back out on the street.
Wow. Okay. So the attempted information that they gave us before about how 100% of people that come in, that by the way, this is obviously self-reporting. The self-reported people that are born out of country that come in, 100% of them are getting detained.
That's
100%
incorrect.
of them are being deported.
That is 100%
false.
incorrect.
Okay. That's what my gut told me. So it's literally a self-reporting process. The person self-identifies as someone who's born out of the country. That's correct. Okay. I just wanted to make sure. So we're not like, show me your papers or we're sending you to ICE.
Absolutely not.
Okay.
Absolutely not.
I didn't think so, but that seems to be what's happening here. And there seems to be this push towards everyone is so terrified. But as you mentioned, the real terror is having a murderer who murders a mother of 5 on a walking trail.
Yes.
And we can't find the person because they're a total ghost. That, and God bless you guys for finding him, but that's the real terror. Thank you.
Thank you, Mr. Chair. I really want to drill down on the way the bill is defined and how it would impact counties that use these detainers. So the bill limits to crimes of violence. It also limits the application to those convicted. So if you were charged, if you were detained based on that charge, it wouldn't hold you. It also, as was mentioned, an amendment's been requested to not hold beyond the 48 hours. So these little details are ways to quietly limit the way jurisdictions would hold a person who may or may not be detained otherwise. Can you touch on maybe those 3 points and how it would change what you do currently?
Yeah, so just to give you an idea, crime of violence, in the state of Maryland, crime of violence, so things that would not be considered a crime of violence that we could not hold on now would be arson in the 2nd degree, auto theft, 3rd degree sex offense, certain types of revenge porn, child porn. These would not be, we wouldn't be able to hold on these anymore.
Okay.
On these detainers.
How about the convicted versus not convicted? Are there situations where you would otherwise detain? Or maybe the hours, can you touch on that?
Well, we are only able to hold for 48 hours. That is what the detainer states. If they don't, and that does include weekends or holidays. I can assure you that ICE is always there within the 48 hours. We have not had one incident over the past 8 years that they have not reported within those 48 hours to pick up a person that we have a detainer on. As far as the convicted people, we screen all arrestees that have been charged with a crime and those that are already convicted of a crime. So, and even what I was saying earlier, even if they have a conviction, doesn't mean they're going to get a detainer. Even if they are here illegally, doesn't mean that they're going to get a detainer. It just really depends on on what their charge is, what their status is in the United States, and what's happening.
Let me say it a different way. I'll ask it a different way. If we limited it statutorily to those who have been convicted, would it limit the people that you could detain as you currently practice?
Yes. I'm sorry.
Okay. I just wanted to suss that out. Thank you.
Yes, thank you.
I'm sorry, Delegate Kaufman. Okay. Yes, I have a question. And for the gentleman in the blue suit, I think you said you were a representative of the Hartford County government?
Yes, Delegate Kaufman.
Okay, thank you. And so my question is, and you mentioned, in this testimony, you mentioned Rachel Morin, and I think all of us believe what happened to her is abhorrent. But my question is, because immigration is not my forte, is did the 287G program allow you to to put that person into custody any sooner? Does 287G expedite the process for you?
So this individual, this heinous criminal, was arrested in Tulsa, Oklahoma. Tulsa, Oklahoma is a community that has a 287G program. So when he was arrested in Tulsa, he went through the sheriff's office process there to be booked into that facility before he was transported back to Hartford County. And yes, 287G did identify him as an individual that was in this country illegally.
So did it make his, what's the word? Extradition to Hartford County any faster, the 287G?
287G didn't play into the extradition coming back to the county.
Okay, thank you.
Delegate Schmidt?
Thank you, Chair, and thank you all for being here. Ms. Chester, I do have a question. You had brought up a reference to the previous few years, and I have a Baltimore Banner article from 2 days ago that references since fiscal year 2022, ICE's Baltimore field office has made fewer arrests than most other field offices nationwide. You touched on that briefly. Is that
has made less?
less than other jurisdictions? Would you?
I mean, I am a contractor for the Baltimore field office. I can't speak on them, on their behalf. I can only speak for Hartford. We get people every day. We get illegals, or foreign born, I should say foreign born, that come through every day.
Okay, thank you for that. And my question for Mr. Elliston, when you had made the reference to the cuffs are off.
No, this isn't Mr. Ellison.
That's not Mr. Ellison, okay. Oh, there's Ms. Elson. I got you. Sorry, I missed that one. Sorry about that.
I'll be upset.
All right. Thank you all.
Thank you.
Delegate Taylor?
I think my question was, I think it was answered, but just, this is, I understand the 287B to be a jail model, right? I heard jail model, then I heard task force model. So are you saying that there's no other way that these folks are getting to you except through some affiliation with either being in jail or on their way to jail or have been jailed? Like, how, are there other?
Yeah, that's exactly right. That's exactly what this is. And this is the only program that we have any interest in Hartford County is the jail model. So if someone's arrested out on the street for domestic violence or for DUI or any other charge, arson, they'll come to our facility. Our deputies, our trained deputies who are correctional deputies, not law enforcement deputies, will screen them. And if they are in this country illegally, they've committed a crime, they're also in this country illegally, ICE, then they'll be, ICE will be notified. ICE will make that decision whether they want to put a detainer on them. ICE may say, no, we don't want to put a detainer on that individual, which happens quite often in our facility. And then they have even further due process. They get to go through the court system and they get to see an immigration judge. And that immigration judge is the one that makes the decision on whether they're going to be deported from the United States.
But this is an immigration judge. This is not a judge that says whether they're guilty or not. So they're not necessarily convicted yet, right? Help me understand. They are.
Yeah, so they've committed a crime. The only way we would deal with them in Hartford County is if they committed a crime.
And
so
you know for sure that they committed this crime
because one of my deputies arrested them. So they were arrested for domestic violence.
And not convicted.
They were arrested. They come into our facility. We screen them.
But do you understand what I'm saying? So they're not exact, because I think you're not guilty until you're
proven yet. Correct. So it's two different processes. We are concerned at the sheriff's office with the crime they committed against the members of our community. ICE and the federal program is concerned that this individual committed a crime in our country and they're also in this country illegally. So it's two separate processes and two separate tracks that they'll be taking.
But either way, because the fingerprints are on file because of whatever, right? Maybe. So
Maybe.
If they entered without an inspection, if they are an EWI, they snuck into the United States, their fingerprints are not on file unless they have been encountered by immigration before.
So it could be that somebody that you've arrested may actually be innocent, but here undocumented. You call ICE on them, they get deported, but they were innocent of whatever.
But they were in the country illegally. That's a federal crime.
I get it. Okay. Yes.
All right, seeing no further questions for this panel, thank you very much. Oh, I'm sorry, Delegate Phillips. Oh, my goodness. Delegate Phillips and then Delegate Tolles.
Thank you, Mr. Chair. And I just want to make sure I'm clear as well. We mentioned some of the heinous crimes that have taken place, and arrests were made on those individuals, right?
Correct.
They would be prosecuted, correct?
Correct.
Okay. And you wouldn't necessarily need 287G for at some point federal law enforcement officers to understand that you had an individual who was not a citizen. Is that correct?
So if this was the first offense that they had committed, the first crime that they had committed, and they had entered the country without us knowing, EWOB is what it's called? EWE. So they had entered the country without us knowing about that. The 287G is the program that would identify them. So they would do, our deputies would do the work, working with ICE to identify them, that they've also identified the country illegally. So then they would be put in the system at that point.
I'm just trying to understand. So let's take an individual. Individual A, you arrest him on a suspicion of murder. Mm-hmm. We're going to charge that individual. Most likely, if it's murder, they're not going to be released. They will be prosecuted or go through a process. Are you saying at no point in time will there be an identification that this person outside of 287G, there's no other way that we would know that this individual or that federal law enforcement wouldn't eventually find that out? Lieutenant,
why don't you take that one?
If they come in illegally, again, there's no fingerprints on file until they have gotten, like a charge at some point, and then their fingerprints go into the FBI system, right? So if they come in legally, their fingerprints are on file. Those fingerprints would then ping, ding, whatever you want to call it, to some information to be able to say that maybe where this person was from. We have somebody that comes in that's illegal, or again, I'm sorry, comes in foreign-born, and has never been encountered with immigration before. So say, on your suspicion of murder. Immigration would not know that they are there. If 287G was not in place. We don't contact, we wouldn't contact ICE to say, hey, I got a guy from Guatemala here. That's not what we do. We don't have time for all that with all the arrests that we have. 287G is a program to actually be able to document and collect data to be able to identify who is in the country legally and illegally.
Okay. I think there's at some point in time, if you were to, and maybe I'm wrong, if you were to arrest and convict an individual and you did not have those fingerprints, now you've got fingerprints on file, at some point in time, we're going to identify that this was a criminal from another, potentially from either.
Potentially, yeah.
Potentially, right?
More than likely, yes.
More than likely, so we don't need it.
So what about the individual who commits a domestic assault against their partner? And the judge keeps them in there for 10 days, and we run the fingerprints, and they're not identifiable, and we have to let them back out into the community when they're also in this country illegally to continue to victimize that community. Yep.
Right. I'm fine.
Thank you, Mr. Chair. This question is for Mr. Daniel, because Morningside is a part of District 25. How you doing again?
Fabulous.
Good. Can you speak to any incidents, if any have occurred, like, I guess in the past year in the town of Morningside?
Only incidents, for full disclosure, I've only been employed by the town since May 13th. So I can give you 9 months and about 8 days worth.
That's okay. I mean, I'm sure you have reported information.
So, and just to clarify, what incidents are you speaking of? What type?
Anything.
Yeah, we've had homicides. We've had.
As it relates to this issue.
Related to this issue.
Yes.
To the best of my knowledge, we have had one domestic violence incident where the suspect was arrested and taken to the Department of Corrections and was, I believe, released by the court commissioner. I would have to reference the paperwork to be 100% exact. The second day, I believe, following his arrest, I observed him waiting in front of the house, and we were called back there for a disturbance. To the best of my knowledge, that's the only incident involving undocumented immigrants of a criminal nature. And it should be noted, Prince George's County does not have the 287G program.
Okay, this is all like confusing to me, but I don't want to take up too much time. I can always contact you or the bill sponsor to get additional information. I just wanted to know what sort of history there was in the communities in which I represent, because I did get a letter from a constituent that's in the committee testimony, said District 25 constituent. She didn't really say much, but it was a letter, so I just want to see what I could find out. But
So, and like I said, to further reiterate, being that you know where my jurisdiction stops and ends, at the front and side gate of Joint Base Andrews.
Right.
The president and other dignitaries come and go. I have yet to have seen an ICE agent. I have yet to have been informed that there has been an ICE agent anywhere in or near jurisdiction. And further than that, the only federal agents that I have seen in my time have been U.S. Marshals and Secret Service.
okay, no, and Joint Base Andrews is part of my district, so.
Yes, it is.
Yep, so I just wanted to find out. Thank you so much, Miss. Thank you, Mr. Daniel. Good to see you again. Thank you, Mr.
Yes,
Chair.
ma'am.
Okay, now we're done. Thank you very much. That concludes the testimony of those people testifying opposed to the bill. One more person to testify in an informational capacity is Matthew Elliston.
Oh, thanks, man. I appreciate it.
Mr. Elliston, for 2 minutes, please.
Yes, thank you, Mr. Chairman, Ms. Vice Chair, members of the committee. My name is Matthew Elliston. I'm the Field Office Director of Immigration and Customs Enforcement for the state of Maryland. I'm here as an informational only testimony. I will say the 287G program identifies people that we know would no other way know about. We had an example earlier today. The number 2 person of Mara Salvatruce in the United States, Mexico, and Europe was arrested by my officers after having been arrested by Prince George's County in December. We did not know about him in December because his fingerprints were not on file with us. We got that information from a confidential source that he was inside the United States. We found him and apprehended him earlier today, making the entire state of Maryland and the country, to include Mexico and Europe, a safer place to be. Without 287G, these kind of incidents continue to happen. 287G is a phenomenal resource for people that the Department of Homeland Security would in no other way know about because we do not have their fingerprints on file. That is where 287G is an invaluable resource. I would also like to add, there are 3 styles of 287G programs. The warrant service officer and the jail enforcement model are custody-only programs. The task force model is not currently in use anywhere in the United States, especially not in Maryland. So these are people who have been arrested for other crimes by the local police departments and brought into custody and then subsequently interviewed by a designated immigration officer that we have trained that has ICE oversight on every single case that they do. When they interview someone, they reach out to a supervisor from my staff to see if we want to take action on them. This still has a tremendous amount of federal oversight to include the Office of Professional Responsibility. Thank you.
Thank you, Mr. Chair. Thank you so much for being here. I think one of the things that people have been asking questions about today is trying to understand how the ICE 287G process works in conjunction with the criminal charges. I know at least of the most recent case that I've spoken to my sheriff's department about, someone was charged with their crime. It was discovered that, through the 287G program that she did not reside here legally. She was put through the process for her court hearing. She was convicted. She served her time, and then you guys came and got her. I think there's some confusion happening that these people are just picked up at the very beginning when they're first charged, and then none of them seem to see a courtroom for the actual charges. Now, in my county, that doesn't seem to be what's happening. Can you speak to that issue? Are people, for example, we have two suspected murderers being held. You haven't picked them up yet. So I anticipate that they are going to see a judge. They're going to go through that process. Am I wrong, or is that how it's working?
No, that's correct. So immigration detainers are meant to ensure that criminal aliens do not get back onto the street after their judicial court process.
Okay.
So they will go through the same judicial court process, whether they were here legally or illegally. And at the end of that, then they would be turned over to immigration at the conclusion of their judicial process.
Okay, awesome. I think that was very confusing for a lot of people today, and that was what they wanted to have an answer to. So I really appreciate it.
Thank you, Mr. Chair. I think I have two questions for you. First, can you speak to the kind of emotional terrorism, the gaslighting that we typically hear about this? They're going into schools, people aren't going to hospitals. Where do you enforce, like specifically and broadly?
Yeah, so I'll tell you, a lot of this rhetoric came after we removed the sensitive locations policy. The sensitive locations policy did not just restrict our ability to go to those locations, but also enforce the law in surrounding locations. And we were finding that criminals, very smart criminals, were moving into apartments directly across the streets from schools and churches in order to avoid arrest by ICE. That's why we removed the policy. We have not at any point gone to any school, and I've heard at least 10 times where county executives have called me, police chiefs, sheriffs have called me, hey, we understand you're at an elementary school doing interviews. I couldn't even imagine how you would interview an elementary school child about their citizenship. If I asked them where they were from, they would probably say my mom's house. The idea that we're doing that is it's honestly, it's hurtful for my staff. They have kids in those schools. We're not arresting children. ICE does not have child detention anywhere in the United States, which would preclude our abilities to do that. So one of the things I would say as far as the rhetoric is concerned, there's no fear of us going to schools. I've been in this job for almost 18 years. I've been to a school campus once in my career. It's because there was an active shooter. I understand there's a sensitive locations policy, or sensitive locations law in the state of Maryland. I would hope that you would add some sort of exigent circumstance, because ICE is at 20,000 law enforcement strong throughout the country with specific laws from Congress to engage active shooters where they appear. And I would hate for that to inhibit our abilities to do that.
And when you say these criminals are skirting the law by going to adjacent facilities, what types of criminals specifically are you pursuing here?
I'll tell you, I'm so proud of the Baltimore field office. We lead the United States in the number of sex offenders arrests amongst all other ICE offices. Last year, we arrested 175. Previous year, we did 152. Previous to that, when I got here, they were at 80, but the previous record nationwide was 110. It's been my goal to make sure that every person who violates a woman or child in this state is taken out of the state and back to their home country.
So succinctly, do you go into schools?
No.
Do you go into churches?
No.
Do you go into hospitals?
No. Hospitals, we have had to go into a hospital because we've had an inmate in our custody have a medical issue, which again, if a sensitive locations law were to pass, I don't know how I would provide medical assistance to someone if I'm not allowed to go to a hospital. I really don't know what I would do. Am I supposed to let them die in my detention center because I'm not allowed to seek medical treatment? It's something I'm very concerned with about that specific law.
Thank you. And finally, I really do have a concern about the way the bill is structured, because part of what this bill does is advance, the participation in these 287G programs. But the other part of the bill, what it does is it limits the detainer function. And for me, whether as we've heard from Harford County folks, they screen everybody the same way. It doesn't matter to me if you're convicted or you're not convicted or what the crime is. If you are pinged and you say that guy's wanted for a murder in another country, it doesn't matter if they're guilty or not guilty, or if it's harassment or murder or public urination. It seems to me we should probably detain that guy. So can you comment on the way the bill is structured as far as the limitation of the detainers, how you think that will impact you?
Well, what I will tell you is by limiting our abilities to work with local law enforcement and take custody of people who have committed other crimes in the state of Maryland, you're continuing a culture of recidivism. And I think one of the biggest issues I have that I've seen time and time again, specifically in Prince George's County, who has a hard sanctuary policy, I believe I did a media ride along where we had to divert our already planned operation to go out for an MS-13 gang member that the Prince George's County Police had arrested for possession of a firearm and narcotics with the intent to distribute. He was released from Prince George's County. I assume he's not going out to teach Sunday school, right? He's going out to hurt somebody. So we had to divert to go back to go pick that person up. And I can't imagine a reason that you would want to reduce that sort of custody. You know, even as a state level, if you were going to limit what laws and what criminal activity you would want to work with ICE on, I would hope that you would include a blanket for gang members or people wanted in their foreign country for violent crimes as well. We've arrested numerous people in this state alone for Interpol red notices. We have Interpol red notices out right now in the state of Maryland for people actively wanted as a member of ISIS. I've had officers out for the last 3 days scouring, looking for this person. These are the things that when we work together, we can create a safer environment. You don't need to look any further than Montgomery County. You know, in the last year that we've started working together, they've seen a 50% decrease in violent crime. Wow. That is one of the biggest, if not the biggest, single-year decreases in violent crime in the entire country. And the biggest singular difference they did is they started working with us. And again, very specifically, they are working with us in a custody fashion. People that they've already arrested for other violations, and they're just turning them over to us so they don't go back out and re-victimize the community.
Have you ever picked up a gang member who was detained for a nonviolent offense?
I think the best example I could possibly give you is the case that just happened in Prince George's County. The #2 leader of Mara Salvatruche in the country was arrested for driving without a license in Prince George County. But obviously he was let go because it's Prince George County. And again, we had no ability to know. So, you know, thankfully we were able to find him with our colleagues from the Federal Bureau of Investigation, and he is safely in Baltimore detention today.
I think if we could pick up the #2 gang member for a traffic violation, it speaks to the efficacy of the program, and we appreciate what you do.
Thank you.
Yes. Director Ellison, it's nice to meet you, and I mean that sincerely. My question, and I have two, but I'll try to be concise, and that my question is, opponents of this legislation say that you have quotas every day in terms of the number of undocumented individuals that you have to pick up. And in fairness to them, I've read the same thing in the Washington Post. And so my first question is, do you have to pick up through 287G? Does 287G help you meet that quota? And also, is it fair to say that perhaps in order to meet the quota, you'll have to pick up people who aren't potentially accused of something heinous and may just be Tom, Dick, or Harry, an undocumented immigrant?
So what I would say is, I think quotas got misunderstood or, you know, blown out of proportion. My field office has never arrested 75 people in a single day. There's been no disciplinary action or anything. I think there was a goal from the administration to arrest more people in the furtherance of, you know, enforcing the law as it was written by Congress. I myself have not arrested anything close to 75 people in this state, yet somehow I'm not deemed as an ineffective field office director.
But what about my question about, because the president, for example, campaigned on and said his focus would be criminal, but are you having to meet quotas or otherwise pick up people who commit crimes that like serious crimes but
So what I would say is the big difference between, you know, the current administration and the last one is we are also taking what's called collateral arrests. So in the last administration, if someone was a gang member and, you know, was from MS-13 and I went to their house to arrest them and their friend was standing next to them with a big 13 on their face, I was prohibited from asking them any questions to determine if they were also here illegally. Today, that is not the case. So anyone we come across while executing our mission, we will ask questions of them. And if they are here illegally, we will arrest them as well.
Thank you, Director, and I appreciate your public service.
Thank you.
So it's Valentine. Thank you, Mr.
Chair, and thank you, Director, for being here today and testifying. My question, I think you're probably in the best perspective to answer this. Is it a fair assumption to say that in your position you have contact with law enforcement in every part of the state of Maryland?
Absolutely. Every corner of the state. And I also would say that I have yet to meet a law enforcement officer that doesn't appreciate the work that I do.
Excellent. The reason I asked this question to you is we've heard a lot of testimony today from some of the other panels about concerns in neighborhoods. We've talked and spoke with individuals from Harford County, Frederick County, Anne Arundel County, Prince George's County. And I think in your perspective of having a wide swath of the entire state, to the best of, this is a to the best of your knowledge question, are there any sworn local law enforcement officers, to your knowledge, actively on the street today in a patrol capacity that are acting as ICE agents or under your directing as far as a everyday call for service type of a capacity in this state that,
so
citizens should be concerned about?
I could tell you emphatically no. Local law enforcement does not have the legal authority unless delegated by my office. And all of those delegations are in custody and limited to those 3 counties. What I can say additionally, there would be no avenue for a local law enforcement officer to make a street immigration arrest and then try to, I don't know, book them into my custody. I couldn't imagine how that would work. Like my supervisors have to approve arrests being made, and that's the same with the 287G program. It's the same with our fugitive operations officers. They put together target packages that get supervisory approval. It would negate the ability for a local law enforcement to randomly be doing patrol and arrest someone for a Title VIII violation.
Thank you, sir. Thank you, Mr. Chair.
Yep.
Thank you, Chair. Mr. Elston, thank you for being here. And my question was earlier, was the same one I have now, is when you had mentioned, and it was brought up today in testimony about the cuffs being off, if you can just help us understand.
Yeah, kind of the same kind of, example I just gave. In the prior administration, we had a very narrow scope of what we were allowed to take action on. ICE continues, even under, this administration as the last one, we continue to do targeted enforcement actions. And in the last administration, if I was doing a targeted enforcement action on a gang member and I came to their, home and I went to arrest them and they had 2 friends next to them with 13s tattooed on their face, I would be forced to turn a blind eye to that person and pretend like they don't exist and walk away. Where today, I will start asking questions of those people to see if they're here unlawfully. And today, if they were, then I would, if they were amenable to removal, I would take action against those. That's the real difference between being, throttled back on what we're allowed to do and then fully, enforcing the law written by the United States Congress.
Excellent. Thank you. I'm good. Thank you.
Thank you, Mr. Chair. Mr. Ellison, good to see you.
Thank you.
We had our meeting in the hallway.
Yeah.
You mentioned some things that, once again, say to me, why do we need 287G? You talked about what success you're having in Montgomery County. That is not a 287G county.
It's not.
It's not. And so there are other ways to get to where we're trying to go, particularly for persons who've committed heinous crimes. Would you not agree?
So I would say that the one thing.
My question is, are there other options?
Limitedly, yes, but it would not stop the scenario of the MS-13 number 2. Right? Without a 287G program or without one of my officers in jail to do interviews, we would not otherwise know about that person unless we had their fingerprints. So the 287G programs are the best avenue, and they're the only ones that ensure that we interview everybody equally to prevent any kind of profiling issues.
And would you not agree, though, with the 287G program, it's possible that you could end up with people who may be undocumented but have done something minor in a sense? That collateral damage that we talk about?
Well, what I would say is that's a judicial issue for the courts here. My interest is to take people who are unlawfully in the United States into custody.
I get it.
Who are amenable to removal, though. So like a lot of these people who are, minor criminals may not be amenable to removal. They could have applications pending in which we're not going to take any action on, which is why 287G has such a great deal of oversight from my office. Just because someone's identified here illegally does not necessarily mean we're going to take action.
Okay, all right. Secure Communities Program, which was an EO, I think, from many, many years ago. A person gets arrested, and a fingerprint is taken. And what happens with that? And all of our local jurisdictions submit fingerprints to the FBI, correct?
Yep. Yes. So that is.
Let me ask you, that's correct,
yeah.
right?
Yes.
I'm just going to ask you a couple questions.
Please do.
All right. So they submit the fingerprints to the FBI. The FBI then submits all fingerprints, as I understand it, if it's not registered to ICE. Is that correct?
So we have a patch on all fingerprints as they come up. If we've had corresponding fingerprint matches in the past, it will then trigger an alert from us. But if we do not have corresponding immigration prints in the past, we would otherwise not know about that person.
Okay, all right. And so okay, all right. But if you do, that's also a trigger.
If we do have previous fingerprints in the past, then yes, it would trigger. But it would, like the MS-13 guy, it would not trigger on him because we had not otherwise encountered him.
Okay. So I'm just trying to make sure. So there are other options, and we've proven that with the success rate that you have in Montgomery County. And there are also a number of other triggers, particularly for those persons who have a criminal background.
Limited. 287G is a much more thorough process. Again, the MS-13 guy would not have walked away from Prince George's County if we had that level of cooperation. But, there is a very, I don't want to say large, because most people have had some interaction with us, but I would, say in the 30-ish, maybe a third % that do come across that a 287G program identifies, or an immigration officer would have to identify, but otherwise through fingerprints alone, we would not be able to, no.
Okay, all right, thank you.
Yeah, you're welcome.
Taylor.
Mr. Chair, welcome, and you're apparently famous on social media.
I don't know if that's a great thing.
So I'm assuming when you mentioned the ride-along that was planned and filmed, that's what made you famous? Is that what we're talking about, that particular?
Well, I wouldn't say that particular one. I believe that ride-along was done with ABC World News Tonight. I just, because I'm so close to DC, I do more media coverage than anybody else in my organization, and also the prolificness of the Baltimore field office and the level of criminality that we arrest.
I understand. So the one where you smashed the window.
Yes, ma'am.
Was that in pursuit of the MS-13 person in Prince George's?
That morning was a different, actually Prince George case for someone who had an active homicide warrant out of Prince George's County, but is also here unlawfully, and we're trying to do our due diligence and to assist in public safety by arresting someone actively wanted for murder with Prince George County. Yeah. Again, though, the hard part being, if I do arrest them and give them to Prince George's County, Prince George won't give them back to me. So it does, you have to weigh a risk there that this gang member wanted for murder, who we want to all see face their time, in front of a judge, they won't honor a detainer from us to give us back.
I may get back to that, but for now, the person that was in the car, window was smashed. Was he the person you were looking for?
No, he was what we call a collateral arrest. So we pulled him over, we spoke to him, and he openly admitted to being in the United States unlawfully. So we had probable cause for an arrest. We asked him to get out of his car several times so we could effectuate that arrest, and he refused. So just like any other police officer.
He doesn't have the right to refuse?
Well, just like any other police officer, if you were to get pulled over for, let's say, a DUI, and you rolled the window up and said, no, I'm not going to jail. I'm not letting you arrest me. I mean, they wouldn't just leave, right? Like, you've committed a crime, there's probable cause for an arrest. They also would do the same thing, where they would unfortunately have to, make forcible entry into that vehicle to arrest you.
And when we talk about fear and stoking fear in communities, actions like breaking somebody's window on camera may be one of those ways that stokes fear among the community?
It's super unfortunate. We would love to not have to do anything remotely like that. We would love to always arrest people in the most peaceable way possible. It's when people refuse lawful orders, as any other law enforcement agency, we have to take actions in order to effectuate arrests.
I get it, even if it's the wrong person.
Well, I mean, he is in the United States unlawfully. We had a probable cause for his arrest, right? He may not have been the target of our arrest,
Sure.
but, he was still in violation of federal law.
And when we're talking about Prince George's County and the MS-13, if you had taken him to Prince George's County, or if I am Prince George's County representative, so you're saying that we would, if he was found guilty in Prince George's County, that he would not be incarcerated and serve his time for the crime that he committed?
Well, that's up to the judicial system. If he makes his way to state prison, then we'd be okay. If for whatever reason he remains in Prince George's County, maybe takes a plea to a lesser charge, which is very common in Maryland, more so than my experience in Los Angeles. If he took a plea to a smaller charge where he never made his way to state county, then yes, Prince George's County would release, someone who murdered someone, who's an active MS-13 gang member. They would rather release them back to the street, yes.
They would rather do it?
Well, that's their county ordinance has decided that they would rather, the county law is that they would rather not cooperate with ICE under any circumstance, which is the reason I asked the U.S. Attorney General's office to look at filing a lawsuit against Prince George's County.
Delegate Boone.
Thank you, Mr. Chair. Just a couple quick clarifying questions. One, is it always the case that if there's a detainer on someone and they're moving through the legal process, that you wait for that process to conclude? Or are there some folks that you might say, we're not going to wait to see how this trial turns out, let's go get them?
The detainer makes sure that custody is transferred. So if for whatever reason the person is going to be released from custody, the detainer is there to make sure that they don't get out of jail and that they get turned over from the local jurisdiction to us. Whatever the local judicial system is between the state and the offender. My job is to make sure that people do not get out of custody.
So if you're made aware of someone, say, and they are found not guilty, say, what happens then?
It would depend on their immigration status. So like, let's just say someone who's a lawful permanent resident and they're, being charged with murder. We're going to follow the case, and if they're convicted, we're going to take custody of them and put them through removal proceedings. But if they're found innocent, we would not be taking custody of them. Same thing with someone who's here on a visa, someone who's here as a tourist. It really depends.
But if they had the misfortune of being wrongly charged and are exonerated, that bad luck of that case being there would send them on their way for deportation?
It would depend on their immigration status, but it could. If they were here in violation of federal immigration law, then yes.
Okay, and sorry, and then the next question I just want to clarify. If the delegate's bill passes as is, I just want to understand the comment you made about Interpol warrants. Mm-hmm. If someone is wanted for murder in El Salvador, mm-hmm. and somehow they're not in the scope of the bill, are you impeded in some way from getting, if this bill passes?
So I wouldn't, well, it would depend on the local jurisdiction and their level of cooperation with ICE. So I've seen bills like this before when I was an officer in California. And, despite this being a mandate for certain crimes and leaving it to jurisdictions for the rest, a lot of jurisdictions will see this as this is what we're only allowed to do. So they will, they might not. I can only speak to my experience in California. I don't know what the future would hold here in Maryland. I think we would have to make it very clear to the local municipalities that their level of cooperation still resides with them, except the state is now mandating cooperation in these cases.
Thank you.
Last question, Delegate Sims.
Thank you, Mr. Chair. Can you tell me, do you have any MOUs with any of our law enforcement agencies here in Maryland?
The 287G programs, we have all
Just
of those.
other than those sheriff's departments, that's it?
No, not actively to my knowledge. No, we don't.
Okay.
We are trying, we would love to enter into more, but we don't have any others active in agreement right now. No.
Sure, sure. I know some of the concerns that have been asked pertains around patrol. So here in Baltimore, y'all cover what area? The United States, a region? What is
So
your-
the Baltimore field office covers the state of Maryland.
Just the state of Maryland?
Mm-hmm.
Okay, and in doing so, do your officers go out on active patrol looking for people? Or do y'all jointly join in with local police departments to make that happen?
No, we do not do that. So ICE only performs targeted enforcement actions.
As a reaction?
Yeah, so we only do targeted enforcement. We do not do patrol. We do not set up traffic blocks. You know, it was alleged from it was alleged to me by a county executive that I actually had a group of armed officers in front of, I think it was Greenwood Elementary School, I may have gotten the name wrong, and that we were doing interviews of children, which is a deplorable idea and a wildly false notion. We only do targeted enforcement actions. So we would not like sit in a patrol car with someone and drive around.
Sure. Is there any way that if an individual is detained by ICE, that a family member could contact y'all? Is there anything put out to the community or to departments or agencies that help in community awareness?
Oh yeah, absolutely. So on our website, there's the ICE detainee locator. And you can find out if someone is arrested exactly where they're located, and we have visiting hours for those people. I will say that since the state passed dignity not detention, they're usually not here for more than 12 hours before they're sent elsewhere, you know, elsewhere being the rest of the United States. So it could be detrimental for someone to try to contact their family if they need to give them something or their immigration attorney wants to speak to them. Because most of the people we're arresting right now, I think our last transportation went to El Paso, Texas.
Very quickly, so y'all.
Yeah.
Okay. So,
yeah, immigration detention is not meant to be punitive. It's solely to effectuate the removal from the United States in the fastest way possible.
Right. So I know one of the things that we spoke about earlier, and you might have been in here, we was talking about it, was about the hotline that CASA and other agencies have for advocacy. So one of the biggest concerns there was that if they are notified, what would be the timeline that they would be able to make contact with that individual or make contact with ICE for the purpose of advocating?
So they would have a very short timeline if they want to advocate into my office. However, the average length of custody stay is a little over 60 days, and they would be able to do that to the detention center they're in. I feel bad for the individual from CASA and the hotline. I think they are the victims of, everybody appears to be ICE officers to them. Any law enforcement agency that doesn't have a black and white car, if they're speaking to anyone, it gets reported as ICE. I will say I bet if I looked at the CASA statistics of how many phone calls of alleged arrests versus my statistics of how many people have actually been arrested, I bet their number is drastically higher than the amount of people I've arrested.
Thank you.
Of course.
All right, seeing no further questions, we thank you very much.
Thank you.
That was House Bill 1222. It only took us 2.5 hours. All right, we only have another, 10 to go. Delegate Warman, please come up. Delegate Warman, Nick Katz, Maria del Carmen Castellon Quintana, Byron McFarland, Megan Good. It's our first bill here in Judiciary, everybody.
Thank you, guys.
Is there a motion for an unfavorable? Delegate, we promise to be nice at least for the first minute of your speech. Go ahead, 3 minutes.
Thank you so much, Chair Clippinger, Vice Chair Bartlett, members of the Judiciary Committee. My name is Delegate Teresa Warman, and this is my first time testifying before you guys, so thank you for hosting me. I'm here to testify on House Bill 1420, a bill that is rooted in fairness, family responsibility, and ensuring that Maryland's legal system works for all families in their time of need. This legislation comes in response to the heartbreaking collapse of the Key Bridge in Baltimore in 2024. One of the workers lost in that tragedy was a husband and father, a man working hard to keep Maryland's roads safe. His widow, Miss Carmen, should have been able to focus on mourning and caring for her family. Instead, she was barred from serving as a personal representative of his estate simply because of her immigration status, forcing her into a costly, unnecessary legal fight just to secure the benefits her family was entitled to. The intent for this bill is simple: to ensure that immigration status does not prevent Marylanders from properly handling the affairs of a deceased loved one. The probate process should work for families, not against them. HB 1420 ensures that individuals without government-issued ID, whether they are immigrants, seniors, or those facing financial hardship, have a secure and verifiable way to establish their identity when dealing with estate matters. To protect the integrity of the system, alternative verification methods such as notarized affidavits or credible witness testimonies would be developed in consultation with the Maryland Register of Wills Association to ensure security while reducing unnecessary bureaucratic barriers. After working with stakeholders, we have amended the bill to repeal Estates and Trusts Article 5-105C4, an outdated restriction that prevents non-citizens from serving as personal representatives unless they meet a narrow criteria. Removing this barrier upholds the principles of fairness and family responsibility, ensuring that when tragedy strikes, the right person chosen by the deceased can manage their estate without unnecessary legal roadblocks. By passing HB 1420, we honor the families of the Key Bridge tragedy and ensure that no grieving family is left struggling because of red tape. This bill is about supporting Maryland families, reducing unnecessary legal burdens, and ensuring fairness in estate administration. I respectfully request a favorable report on HB 1420. Thank you for your time and consideration. I'll turn it over to my panel.
Good afternoon, Mr. Chair, members of the committee. My name is Nicholas Katz, and I'm the General Counsel with CASA. I'm here today to express our strong support for HB 1420 and to thank Delegate Warman for bringing this important bill forward. Every Marylander felt the impact of the tragic incident that led to the collapse of the FSK Bridge, but none felt it more than the families of those 6 individuals who died that day. All of them were immigrant Marylanders. Immediately after the collapse of the bridge, CASA worked tirelessly to support the impacted families, helping to connect them to the vital social services, financial resources, and other needs that they had. That support continues to this day, and one of the families we're working with is the family of Miguel Luna, including his wife Carmen, whose testimony you'll hear later today. This was a situation where Miss Luna wanted to be the personal representative of the estate of her husband, something countless people do every day, trying to get closure for those who have passed, but she was unable to because of the citizenship requirements that we currently have under the law. HB 1420 seeks to address the issue by eliminating those requirements, and as you'll hear from my colleagues, the requirements have no rational basis for existing, and they're not part of the law in our neighboring states. This simple yet critical change can be accomplished by simply striking the current language, which is what the amendments to the bill do. And I just want to close my testimony by once again thanking Delegate Warman for the support of Carmen, of all of these families, and for helping move equity forward by removing these requirements from the current estate law. CASA urges a favorable report. Thank you.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the committee. My name is Byron McFarland. I'm the Register of Wills for Howard County, and I'm here speaking for myself only in support of this bill with the proposed amendment. I want to first express my condolences to you, ma'am, for your loss and my regret that you have faced hurdles simply trying to open your husband's estate. As you all know, when someone passes away and they have probate assets, someone needs to be appointed to open the estate and deal with those assets. The PR, personal representative or PR of an estate, is either a person named in a will or usually a close relative if there is no will. There are some restrictions on who can serve in this role, however. You have to be an adult, competent, and not convicted of a serious crime. These restrictions are common state to state, but Maryland has a unique restriction on anyone who is not a citizen or a permanent resident and also has to be a spouse, sibling, child, or parent of the decedent. This restriction can and does prevent surviving relatives here in Maryland from being appointed as PRs. What does that mean? That means that they need to find someone who can serve, which is usually an attorney. And in many of these estates, the cost of hiring an attorney is simply cost prohibitive. I worry that this barrier to access to our system may force people to dispose of those assets outside of the normal process, and we certainly don't want to encourage that. As Mr. Katz noted, I think it's noteworthy that none of our neighboring jurisdictions, Pennsylvania, West Virginia, Delaware, Virginia, or DC, has such a restriction, and we're not aware of any kind of unintended consequences for them not having that. I think as a matter of common sense and basic fairness, let's repeal this restriction, allow a PR named in a will or a close family member or someone who's appointed in an open court proceeding to handle someone's assets, follow our proper procedures, and move on. These cases come up consistently, if not frequently, and I personally believe this will not only address this specific case that you've heard today, but future estates as well. Thank you.
Okay. Distinguido presidente Clipen, miembros del comité. Mi nombre es María del Carmen Castellón Quintana. Y yo soy viuda de Miguel Luna, quien falleció hace 11 meses, el 26 de marzo del 2024, al caerse del Key Bridge en Baltimore ese día.
Dear Sharp Clip and Garrett members of the committee, my name is Maria del Carmen Castellón, and I'm the widow of Miguel Luna, who passed away 11 months ago on March 26, 2024, when the Key Bridge in Baltimore collapsed.
Mi esposo y yo éramos una pareja muy feliz. Compartíamos mucho juntos, dando nuestros sueños y esperanzas para una vida larga y feliz.
My husband and I were a very happy couple and share a lot together, both our dreams and hope to a long, happy life with our common debts and bank accounts joint.
Tanto como nuestras deudas cotidianas y cuentas bancarias, él me apoyó en realizar mi sueño de emprender mi propio negocio.
He helped me and supported me to be able to realize my dream of becoming a business owner.
Y juntos ahorramos lo necesario para comprar nuestra primera casa.
And together, we were able to save up to be able to buy our first home.
En el 2022, yo aporté para el enganche de mis propios ahorros, él de los suyos, y juntos logramos el sueño de tener un hogar compartido.
In 2022, we were able to pull together our savings to start our dream of buying a home.
Desgraciadamente, hace casi un año sufrí lo que no le deseo a nadie, la pérdida y trágica de la persona que más importante de mi vida.
Almost a year ago, I suffered an insufferable death that I would not wish on anyone, the loss of the most important person in my life.
Al empezar a reconstruir mi vida después de la tragedia y al organizar nuestras finanzas conjuntas, lo que ya era bastante complicado, dado a la falta de un testimonio de parte de Miguel, me informaron de dos situaciones inmensamente injustas y frustrantes.
As I began to rebuild my life after the tragedy and organize our joint finances, which was already complicated enough, given Miguel did not leave a will, I was informed of two immense, unfair, frustrating situations that I would have to deal with in the midst of my pain.
Que yo tenía que enfrentarme en medio del dolor que yo sentía en ese momento y aún experimento primero al no aparecer yo oficialmente en las escrituras de la casa que los dos compartimos.
That first, that I was not in the deed of the title of the house that we both bought together and shared.
Me enteré que la propiedad formaría parte del patrimonio de mi difunto esposo. Y segundo, yo al no ser ciudadana de los Estados Unidos, no podía ser identificada como representante del patrimonio ni participar en alguna decisión directa que tenga yo que ver con la distribución de los bienes del patrimonio.
I found out that the house was going to be in my husband's state, which I, since I was not a U.S. citizen or resident, was not going to be able to take a part of and be able to lead the distributions of my late husband's state.
Esto a pesar de que el patrimonio consiste casi exclusivamente de la casa que yo misma compré con mi esposo y nuestros ahorros.
To say that this state pretty much was made of the house that me and my husband bought together.
Esta injusticia es algo que fácilmente se puede remediar con el simple poder que este cuerpo legislativo tiene en declarar que cualquier persona, independientemente de su estatus migratorio,
This is an injustice that can easily be remedied by the power of this legislative body. The power that you have to declare any person, regardless of their immigration status, to be able to be the personal representative of their loved one's states.
Participar como representante personal en el patrimonio de un ser querido y así asegurar que la distribución de esos bienes tomen lugar según la voluntad del difunto. Con su apoyo y acción espero que nunca más sufra otra persona como yo la doble pena de perder a una pareja y no tener una voz en la distribución de los bienes compartidos solo por el estatus migratorio del sobreviviente.
You have the power to decide that any person, regardless their documentation status, is able to lead that last person's wishes by providing a loved one to be able to decide what's going to happen with the state. And I hope that we don't have to ever again have another family go through what my family has had to go through due to our immigration status during this very difficult tragedy.
Gracias por su atención y les pido un reporte favorable al proyecto de la ley 1420 de esta Cámara de Delegados. Dios les bendiga.
Thank you for your attention in this matter, and I urge for a favorable report on House Bill 1420. And thank you so much. May God bless you.
Thank you. Gracias. Questions for the panel. Delegate Erican.
Thank you, Mr. Chair. I just want to say I'm so sorry. We're all sorry. Wow. Sorry. I actually have a real question because I want to know, okay, obviously this should never happen. It doesn't matter. It should never happen. I just want to make sure that there could not be fraud. So your bill doesn't actually outline exactly how we can make sure that she's the recipient of her assets. Because if somebody else hears about this bill, a criminal hears about this bill, they could come in, have a couple pictures with the deceased and say, oh, this was my partner, this is my home. I just want to make sure that the actual person whose assets they are, that's where this stuff goes. So how can we tweak it? What can we do to make sure she's getting the money and not somebody else?
Thank you for the question. I'll defer to Byron to talk about the way that you guys verify already and see if maybe that's sufficient.
Yeah.
If not, I'll be very open to amending it to do that purpose.
Hi, Delegate Erican, that's a perfectly good question. So how would we verify that, we're dealing with the right people?
Yeah.
When folks come in, if someone comes in pro se, we interview them, we ask them, how are you related? We ask for, obviously they need to have access to evidence of what the assets were. And typically, so if Ms. Carmen, for example, came in and she had a copy of the deed, she had a copy of their bank account statements, things like that, we'd be able to verify that, we're dealing with the right person.
Okay, that makes me feel a lot better. So So, and that's pretty typical in other parts of the code. Does it outline those items, or is that just sort of standard operating procedure?
That's standard operating procedure.
Okay.
We're going to sit down and verify that all the information that we have is accurate, that we know who all the heirs are, that we have names and addresses for everyone, that notice is given to everyone.
Okay, so you're comfortable that this is pretty fraud tight?
Yeah. I mean, whenever we are presented, occasionally someone will come in and make a misrepresentation, but we find out about it pretty quickly.
Okay. Okay, yeah, great. I'm so glad to hear that. We really appreciate you being down here. I know how hard this must be, and we appreciate your husband's sacrifice and your sacrifice to our state.
Thank you, Mr. Chair, and thank you, Delegate, for bringing the bill. And I want to follow up on Delegate Erican's question and from another perspective to Mr. McFarland. Obviously, this is a topic that I'm not really familiar with the registers, and when I have bills in front of me about registers, I try to lean on those in my district. And I didn't see any other communication from the Register of Wills Association, so I typically try to look to see their guidance. Is this something that your association has talked about, or feedback from the other registers across the state as whether or not how this can be implemented to allay some of those fears, or where they stand as an association on this bill?
Delegate, that's a great question. We have discussed this. We have not taken a position on it statewide. I'm here in an individual capacity.
Thank you. Thank you, Mr. Chair.
Thank you, Mr. Chair. Thank you all very much for coming in and for your very powerful testimony. We really appreciate that, and condolences certainly to you and your family. Mr. McFarland, we've spoken briefly about this actually right before the hearing, and the concern that I raised was, would there be any potential for absconding with assets because you're not necessarily here legally? And your response to me, is this correct? I'm just asking if this is correct, is that really wouldn't make a difference whether you're legally here or illegally here. You have the same ability to abscond. So this bill does not in any way assist in committing, as Delegate Erican said, any kind of fraud upon the estate. Is that correct to say?
That's correct.
Okay. And in fact, the verification has to happen regardless of the status of the person coming in. It would be the same verifications, and there's no there would be no way for, or there's no reason to believe that a person who's not necessarily here legally or doesn't have legal documents would be in any way have an ability to defraud an estate any more so than somebody who was here legally. Is that also true to say?
I'd say that's true, and I'd also just add that, the person either has to be, under Maryland law, to be a person representative, you either have to be a Maryland resident, or you have to have a resident agent here in Maryland who receives notice or receives service for you. So, if there is any kind of wrongdoing, and I'll also note that every document that's filed with us is filed under the penalties of perjury. So if someone were, we've had cases in Howard County and all over the state where people have, if you make a misrepresentation, forgery or perjury it's a 20-year felony. So there are serious consequences for making misrepresentations in this process. And that goes for someone who was born and raised here or someone who may be an immigrant.
Okay. Thank you. And I've got more, but I'll leave it at that. Que te vaya bien. Muchas gracias. Okay.
Thank you, Chair. Was there any discussion with Maryland Land and Title Association? And does this, no?
No, I did not speak with them, but I can follow up with them.
Yeah, a concern would be like title insurance, right? And protecting the receiving party moving forward. And then how would this work with the Patriot Act, right? Like the identification is typically required for any type of real estate transaction. Maybe you might not be able to answer that.
I don't know off the top of my head, no,
Yep.
but I can follow up with that
Okay.
unless somebody up here knows the answer.
Yep, thank you. Thank you, Delegate.
Okay, I believe that's all the questions we have. Thank you very much. That'll conclude the testimony on House Bill 1420. Delegate Charkoudian, joined by Emerald Say, George Escobar, Rihanna Matthews-Brown, Julia Fernandez. Is Megan good on the last bill? Okay, wait a minute. Stop right. We'll be with you. And you can bring your panel up, but I've missed a person who was testifying virtually. I apologize. Too many people. Megan Good, is she still there? All right. So I'll ask members of the committee. I think the Maryland Volunteers Lawyer Service provided written testimony as well for the bill. We'll ask you to review their testimony, and I'll apologize. Would you? Yeah, that's fine. I apologize. I think, quite honestly, we were transfixed by I certainly was transfixed by the testimony here in the room, and I apologize for that. I also maybe not. Okay, we have people here, and Delegate Charkoudian, if you'd like to go ahead, we'll hear from you.
Oh, okay. Thank you, Mr. Chair, Madam Vice Chair, colleagues. For the record, Delegate Lorig Charkoudian requesting a favorable report on House Bill 1431. This is a data privacy bill. I think that we all have been aware of and need to continue to be aware of data privacy generally. There's a lot of examples right now of the federal government accessing personal data, which is concerning. But the most concerning in our own communities right now is the possibility of the federal government accessing personal data that we have in state and county agencies and using that data for the purpose of ICE enforcement. And that's concerning for a number of reasons, but one of them is that we work really hard to make sure that Marylanders can trust state and local government and that we have a relationship with our constituents that is not harmed by or changed by the policies and the processes at the federal level as they change how they choose to enforce immigration law. And so in order to make sure that our residents and our communities trust us, trust our agencies, reach out for help, get medical care when they need medical care, get library cards when they need library cards, get licenses when they need licenses, we need to make sure that we are keeping their personal data safe. And so we started this process with motor vehicle data a number of years back. It's been successful and it's been really important. And so what this bill does is it extends that protection for Marylanders' data to all other state agencies and all county and local government agencies. You'll hear from individuals on the panel, more details about both the legal aspect of that and also about the importance of it. The one last thing that I want to say, in addition to the trust that we need our communities and our constituents to have with us and with our services, is just the issue of our own resources. And Maryland resources, as we all know, are precious and are diminishing right now as we face this budget crisis. And we need to make sure that we are not using Maryland resources for federal enforcement purposes. And so for all those reasons, I ask for a favorable report on House Bill 1431, and I look forward to any questions folks might have. Go ahead, George.
Good afternoon, Chairman, members of the committee. My name is George Escobar, and I serve as Chief of Programs and Services at CASA. And on behalf of our 170,000 members, I'm here to voice our strong support for House Bill 1431. The Maryland Data Privacy Act is a critical safeguard that builds on the progress made with the Driver's Privacy Act of 2021 that will protect Marylanders from warrantless surveillance. This bill is not just about privacy, it's about protection. The Trump administration has made clear its intent to weaponize state-controlled data against immigrant communities, using it to surveil, detain, and deport families who have done nothing wrong. Time and again, we've seen federal agencies exploit loopholes to access state data, bypassing due process and eroding public trust. Without clear protections, Marylanders remain vulnerable to this overreach. When Maryland residents engage with state agencies, whether filing taxes, seeking medical care, or reporting crimes, they should not have to weigh their safety against their need for essential services. Yet our community members are doing just that. At CASA, we see the chilling effect firsthand. Mixed status families, including U.S. citizen children living with DACA recipients, TPS holders, and asylum seekers, are withdrawing from public life, foregoing health care, avoiding labor protections out of fear that their information will be misused. CASA families are not hiding from the law. They are protecting themselves from an administration that has turned immigration enforcement into a political weapon. The stakes are high. When people fear seeking healthcare, vaccination rates drop, illnesses go untreated, and public health suffers. When workers feel reporting abuse, bad actors thrive, driving down wages and protections for everyone. You will hear today about Jose Hernandez, for example, a member of CASA whose MVA records were accessed by ICE. His story is not unique. Community members are in fear right now. To be clear, 1431 does not prevent law enforcement from investigating crime, sharing data when legally required, or complying with federal mandates. This bill ensures Marylanders, regardless of their immigration status, are protected from government overreach. For these reasons, we urge a favorable report. Thank you so much.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the committee. My name is Emerald Say, and I am testifying on behalf of the Center on Privacy and Technology at Georgetown Law in support of HB 1431. This bill is crucial to ensuring that when Marylanders seek the services they need, they can trust that the information they share with the government to get those services will not be used against them. ICE is increasingly seeking access to all kinds of data held by state and local governments. For example, ICE has tried to access an extensive unemployment database in New Mexico and student records from schools in California, Georgia, and Tennessee. ICE has also sought to access millions of voter registration records in North Carolina. ICE's efforts to obtain state and local government data are part of a much larger digital surveillance program. ICE also collects or buys data that comes from commercial utility records, money transfer services, airlines, abortion clinics. Those are just to name a few examples. This implicates the privacy of everyone, regardless of immigration status. Every time ICE asks a state DMV to run face recognition searches on their driver's license photo databases, all driver photos are scanned, not just those of the people ICE is investigating. And these data practices also raise serious constitutional due process concerns, especially given ICE's extensive track record of violating civil rights laws and ignoring their own internal policies when carrying out enforcement actions. The lack of meaningful oversight has even resulted in the wrongful arrest and deportation of US citizens. ICE's digital surveillance is possible due to a broad failure at every level of government to properly regulate our datafied world. By requiring judicial review before handing over Marylanders' sensitive information to immigration authorities, this legislation is imposing the kinds of basic checks and balances that are necessary to protect individual rights and preserve the rule of law. And for these reasons, the Privacy Center urges a favorable report. Thank you for your attention, and I'm happy to answer any questions.
Good afternoon, ladies and gentlemen. Good afternoon, members of the committee. My name is Julia Fernandez, a proud CASA member from Baltimore City. I am here to share the story of Jose Hernandez, who cannot testify today. I will ask you to please carefully listen to his words. Thank you for being here today. My name is Jose Hernandez. I'm a father, a husband, a proud CASA member. A long time ago, Marylanders from Central America, and most importantly, a man who refused to stay silent while our families are torn apart. On February 20, 2020, early in the morning, ICE agents stormed my house. In front of my 3 children, still in their pajamas. They handcuffed me and dragged me away. My kids watched their father taken away from them. My wife had to pick up the pieces of our shattered life. This is what family separation looks like. As I stood there in handcuffs, one of the agents actually admitted how they found me. They used Maryland's MBA database. I trusted the government when I got my driver's license. I believed my information was safe, but that morning I learned that that wasn't the truth. ICE was using my private information to tear my family apart. I was locked away for months and months of missed birthday, months where my children went to bed without their father, months of fears, uncertainty, and heartbreak. Some of you may remember my While I was in detention, she stood in this building with our children to tell our story. She fought to stop ICE from abusing NBA data, and we won. But that was one battle. Because if ICE was willing to use NBA records, what would stop them from using data from our healthcare system, our housing department, or our school? They never should have had access to NBA data without a warrant, and they must not be allowed to access any other agency records. This is just privacy. This is my life. This is our community families. How many more fathers, mothers, sons, and daughters haven't made it home past the Data Privacy Act now? Not tomorrow, not next section.
Thank you.
Now, now, now.
Thank you.
Thank you.
Good afternoon, Mr. Chair, Vice Chair, members of the committee. For the record, my name is Rihanna Matthews-Brown, Chief of Staff for Comptroller Brooke Learman, who unfortunately could not be here today. The Comptroller of Maryland works to ensure that every Maryland resident who owes taxes pays them, and of course, only what they owe. When everybody chips in, then we have the resources we need to ensure we can build and maintain schools, roads, health services, infrastructure, and more. When Marylanders complete an employer withholding form or submit their tax returns, we want them to feel secure that their sensitive information will not be used for non-tax purposes without their consent. This is also true for some members of Maryland's immigrant community who may carry the additional fear that the sensitive information they share with the state could in turn be shared with the federal government for purposes of immigration enforcement. Maryland's immigrant community represents a major component of our state's economy. You may have seen the report our office issued last year on the state of Maryland's economy and the follow-up report on the importance of international immigration. And one of the things we reported was that although international immigrants are 17% of our population, they are over 21% of our workforce. To lose immigrants from our workforce would have a devastating impact on employers of all sizes across the state and in our state revenues because they are paying taxes. In fact, in 2022, international immigrants paid more than $5.3 billion in state and local taxes in Maryland. So I'm here today because it's so important to remove any fear that immigrants have that complying with our state tax laws could put them or their families at risk. We want to encourage compliance with our tax laws by letting our immigrant community members know that unless someone comes with a warrant issued by a court, we will hold their data safe. Last but certainly not least, at a state agency that employs 1,200 people, HB 1431 provides helpful guidance on how to react when we receive these kinds of requests. Thank you for your time, and we respectfully request a favorable report on HB 1431.
All right, questions for the panel. Delegate Erica.
Thank you, Mr. Chair. Thank you, Delegate. Welcome to the Judiciary Committee. I don't know if you had a chance to see some of the opposition testimony. Have you looked at, the Judiciary Committee, sorry, we are the Judiciary Committee, the actual Judiciary. Yeah, they'd love that mistake. They wrote in opposition because they say that it would cause them to close off public records. And then Mako wrote in to say that your bill creates essentially counter penalties. So essentially you would be penalizing counties or county employees for something that they are required by federal law to do. And one of their examples was that if there's an I-9 document request, they are required to pass that on with or without a warrant by federal law. So your bill would force them to be in violation of federal law and potentially open up their employees to penalties, financial and potential. I guess it's the civil penalties that you have in here. Is it just a fine, or I'm not sure. I haven't read the whole bill yet, but would you like to comment to that?
Yes, let me answer part of it, and then if there's someone on the panel that can answer the second part. So first of all, in terms of the judiciary, I think there's confusion about databases. I mean, at this point, for example, I think what they're probably referring to is like case search, which anybody has access to. And so we can think what we want about case search, but this wouldn't close off, or the intention is not to close off currently publicly accessible data. The intention is to close off access to data that is currently held private in general. So I think that it's possible that a clarification in the bill could make that, like, so for example, tax information is not publicly available.
Okay.
And should ICE request tax information, this bill would say.
From the judiciary?
No. I'm saying the judiciary is referring to data that's publicly available.
Okay.
Like, I think Maryland case search is what they're referring to.
I think also case files. So if we go to the courthouse and request a case file, we can get gobs of information from that case. For example, all of the evidence in a civil case you could get access to. I think their concern is that that's public information, so you and I could literally go down with a case number and get everything.
So I think we can work on clarifying currently publicly available information compared to information that's not publicly available that this bill is focused on protecting.
Okay, and then to MACO?
In terms of MACO, I think we do have an amendment around the using current. It's actually AFSCME's amendment that uses sort of current disciplinary procedures as opposed to additional disciplinary procedures. I don't know if that affects some of what MACO is raising, but I don't. Does someone on the panel have something about I-9?
I don't think so, because their concern essentially is that you're ordering them to violate federal law.
That's related to the penalty, or you're talking about the I-9?
Well, that was just their example, but apparently there's multiple types of things. Like, they also said that there would be no way for someone to know what an ICE agent or any law enforcement or any person was looking for example, if they came in and had an MPIA or something, how would they know that they were going to use that information for immigration enforcement versus any other type of reason why you might request information?
I think you can't come in, you actually with an MPIA have to have a reason behind it, because like if you were to come in and say to the comptroller, I have an MPIA request, I'd like to see everyone's tax data, they wouldn't hand that over to you, right? So the idea, when MPIAs are filed, they have to give a reason, and that reason is then used to determine if the information becomes available. So it wouldn't be a violation. They're not required to disclose based on an MPIA, because the MPIA would have to have a reason, and then that reason would be considered in determining whether or not it was going to be disclosed.
Okay, so your idea would be that an ICE agent would just write for immigration enforcement, even if they knew this law existed?
They would have to come in with a warrant signed by a judge, right? So a warrant that's signed by a judge. Was that?
Not for the MPIA, they just go online and fill it. I mean, I've done MPIAs.
Sure.
It's a little box. I mean, it's like, I said, for civil reasons. And they were like, get it, girl.
Yeah, but they're not handing over personal information. Probably you didn't ask for a hospital's Medicaid files when you asked for that, and they reply with "Get it, girl."
Yeah.
Like you probably were asking.
They just sent me the file, actually.
But you weren't asking for personalized information. I think what I'm saying is it's unlikely that anyone were to just submit an MPIA and say, "I'd like the personal information from the comptroller, from Medicaid, from SNAP, from anything like that," that agency would just turn that over, right? So because they have a process to determine if this is a reasonable MPIA and what's the public interest involved in disclosing this. So generally with personal information, I can't think of when it would get turned over, right? Okay. So I guess what I'm saying is, yes, an ICE agent could file MPIA, but without a warrant. My guess is if you or I or an ICE agent filed MPIA for personal information, none of us would get it.
Okay.
Right now,
I see what you're saying.
without this law.
Okay, so yeah. I was just thinking more broad information, like where the person lives or something like that. But you're digging deeper into information that's typically protected information.
That's correct.
Okay. All right.
Delegate Pasteur. This question is for the Comptroller's Office. How are you?
Good. How are you?
We know that this bill is about protection, but why is this bill important in terms of the documentation, et cetera, of which taxes are a part? So why is it important to us? What are the contributions, if any? Am I making sense?
You are. And I would say at a fundamental level, we want people to pay taxes. We
That you
want to make
what? I'm
sure.
sorry.
We want people to pay taxes, so we want to make sure, we take our responsibility, seriously to make sure that we are bringing in the revenue that the state needs for all of the different services that we provide. And so when you are creating a situation where people feel unsafe engaging with or sharing their information with the comptroller's office, we know that then they're going to be hesitant to file their taxes, to call and request additional information, which then impacts the revenue that the state brings in. I'll say, I think, even to the earlier question, we take the confidentiality of taxpayers incredibly seriously. And so while you may be able to get that information from other sources, if it's information that we have as a result of your tax return, we consider that confidential taxpayer information and we don't disclose it. And so it is a very high threshold, even in sharing information with other state agencies. We always have data use agreements. We have to have statute permitting it. It's something that, we really guard, with a high level, of scrutiny here, so.
Thank you.
Thank you.
Thank you, Madam Chair.
Thank you. Seeing no further questions, that concludes this particular panel. We're going to, actually, I need to call Mr. Green, but he wasn't called before on this panel. He's on panel 2. That's right. Okay, so that concludes this panel. We're going to now call Mr. Green. I see you there. Aaron Camp Mansour, Matthew Lopez. Is anyone here from the National Immigration Law? Okay, there you are. Okay. Okay. Great. And if you would start, ma'am, if you don't mind, and then then you, Mr. Lopez, and then we'll go to Mr. Green.
Okay. Good afternoon, members of the committee. My name is Erin Camp Mansour, and I'm a member of Patapsco Friends Meeting, which is a Quaker faith community in Ellicott City. I'm also an advocate for the faith-based advocacy group, Quaker Voice of Maryland. Quakers across Maryland have shared with us their serious concerns about disturbing immigration enforcement tactics and the need for stronger immigrant protections. We see HB 1431 as an urgent priority in response to increasingly aggressive immigration enforcement policies and existing state and local data vulnerabilities. You will find among your written testimony supportive statements from individual Quakers and Quaker congregations from different parts of the state. These testimonies reflect a shared desire for policies that are just, compassionate, and respectful of the inherent worth of every person. Our spiritual and social beliefs include a deep commitment to peace, community, integrity, and equality. Hunting down immigrants using private data given to schools, hospitals, food security services, and asylum courts violates the testimonies of community and integrity because it destroys public trust in government. It violates the testimony of equality because it creates a separate set of law enforcement rules and standards for one segment of society. Finally, this practice violates the peace testimony because it divides communities and sets individuals against each other, creating conflict and destroying peace. Each of us has a human right to privacy. This is especially important in an age of electronic communication and information databases, and when our federal government seems determined to pillage our private data for federal agencies for unknown purposes. We need our state government to extend data protections to all state agencies and reassure Marylanders that our safety and privacy are your priority. I urge you to issue a favorable report for HB 1431.
Thank you to the chair and the vice chair and the committee members for having us here today. All Maryland residents should feel confident that their most personal information and data, including biometric and information regarding programs like health and services, remain confidential in the absence of a judicial warrant. Erosion of privacy data in recent years has increased fear and uncertainty, especially among immigrant families. At the National Immigration Law Center, we view the Maryland Data Privacy Act as a good government type of measure that protects consumer data in a way that immigrants have the right to expect in accessing programs. It also advances the goals of state and local programs by ensuring that eligible residents are not deterred from securing critical services. Restricting access to the sensitive information in the absence of a judicial warrant is a reasonable step, and the other elements of the bill create this sort of reassurances that consumers to consumers that their privacy will be protected if they interact with government agencies. There's documented evidence of the harmful effects of deterring access to services due to fear that privacy will be compromised and that contact with government agencies will put families at risk. The chilling effect undermines state and local efforts to protect public health, promote road safety, assist victims of crimes, provide disaster relief, and perform other critical functions. By addressing these concerns that deter families from seeking state and local services, the Maryland Data Privacy Act will strengthen the institutions that are central to a community's success and improve Maryland's ability to protect and serve all residents. Thank you.
Would you mind just stating your name for the record?
I am sorry. My name is Matthew Lopez with the
you.
National Immigration Law Center.
Thank you. Mr. Green?
Thank you very much. Again, Chairman and Vice Chairman, members of the committee, my name is Jonathan Green. Again, I'm here on behalf of the Maryland State Bar Association Immigration Law Section. We have a particular expertise in how Maryland law works with federal immigration law. I'd like everybody to know that while I was waiting to testify, I received notification of 3 data breaches of my personal data. So it's something which all of us get every day or every week. And it's a significant concern. I would point out that the existing statute, Public Safety 3-529, already puts a limitation on anyone who seeks access to a database for the purpose of enforcing federal immigration law, and it already requires the issuance of a judicial warrant. I think the key point of this bill is that it also requires that a person clearly identify the record to be accessed, so that there's some specificity and not simply an opportunity to simply mine existing databases for the purpose of federal immigration enforcement. Again, we support the federal government in carrying out its immigration function. We support the state of Maryland for carrying out its law functions. And the state of Maryland is not a federal immigration enforcer. So we do want to make sure that this division created by our Constitution is recognized, and we're happy to answer any questions about anyone has about how this law works with federal immigration law. Thank you.
Thank you. Delegate Cardin.
Thank you, Madam Chair. Thank you, panel, for testifying. This is again another question for Mr. Green. Are you familiar, you said you have specific expertise in this area. Are you familiar with any attempts to, let's say, have a fishing expedition that has happened or taken place in Maryland on some of this confidential information?
Well, unfortunately, Delegate, I wouldn't have access to that information, but I see the field office director, Ellison, is still present in the room, and he might know about efforts to obtain access to databases for the purpose of gathering information to enforce federal immigration law. So you could ask him, he would know.
Right, I guess I will. But so if in fact this bill went into effect, when you say that you'd have to request the information with specificity, means you have to, about a specific individual as opposed to just gathering information about all, for example, all taxpayers in the state of Maryland in order to try and find information that may be relevant to attempting to find undocumented immigrants. Is that fair to say?
Well, the terminology of the bill is that the person has to clearly identify the record to be accessed. It's not particular with regard to any individual, but the record has to be identified clearly. That's in addition to the already existing requirement for a judicial warrant.
Okay, thank you.
Thank you. Seeing no further question, that concludes this particular panel. And now we're going to move to those who have signed up unfavorable. We have Daniel Franklin and Daniel Franklin.
Alone on the island.
Yes.
Okay.
Thank you.
Good afternoon, Madam Chair. Dan Franklin, Prince George's County, Morningside Police Department Police Chief, here on behalf of the Maryland Chiefs and Sheriffs, testifying unfavorable on House Bill 1431. After our marathon on 1222, I'm pretty sure I don't have to reiterate a whole bunch of my testimony, but I just want to point out a couple of things. First and foremost, speaking of judicial warrants, to obtain information. I cannot stress how impractical it is to take an existing practice of exchanging information, which many federal, state, local joint task forces have been built on, successful task forces for various things, and effectively attempt to throw a monkey wrench in the middle of it. That's, shutting down advances that we have made. All these databases have been collected as technological advances. One prime example would be something like the terrorist watch list. If the terrorist watch list were to crash, we should all be petrified. Newsflash, a lot of the terrorists on that watch list would also fall under undocumented immigrants. The warrant, effectively, in my line of work, I don't deal with federal warrants. I deal with search warrants. That's what we apply to a judge for. I'm assuming this would be the same thing. One thing I am sure of is that we heard testimony on both sides of the 287G program. The 287G program appears to work solely on information exchange to be the catalyst. If there is no information exchange, that program fails. We've already determined that that program removes criminals, period. Just one other thing, two other things. One is the supremacy clause of the United States Constitution, I believe, would cause superseding of any state law. And again, a law that encourages you to not enforce another law, I find that problematic. And the other thing is there are plenty of different, I'll be 3 seconds, sorry. Just one other thing is that the premise of the law, while I understand it in securing information, I don't agree with it because it certainly goes against the purpose of removing criminals from the country. Thank you for your time.
Thank you. Are there any questions? Okay, seeing none. Next, we'll have, for information, Matthew Ellison.
Thank you for having me back. Since I'm informational only, I'm actually going to read you something from the exact opposite of ICE. This is from the Immigrant Legal Resources Center from their website. And I'll quote, President Trump has threatened to prohibit sanctuary cities from receiving federal funding in an executive order on January 25th. The president directed the jurisdictions who willfully refuse to comply with 8 U.S.C. 1373, a federal statute, shall not be eligible for federal grants. 8 U.S.C. 1373 is a federal law and already binding on all states and local governments. What is 18 U.S.C. 1373? 8 U.S.C. 1373A, a federal statute that prohibits local and state governments and agencies from enacting laws and policies that limit communication with DHS about information regarding the immigration and citizenship status of individuals. The statute prohibits such policies, but does not contain any requirement for anyone to take any action. The full text is attached in the end of the frequently asked questions. What I would say as far as this bill is concerned, as the police chief mentioned, I think this is in direct conflict with 8 U.S.C. 1373. I believe this is actually the reason that New York and Illinois are currently in lawsuits with the Attorney General's office. That's really all I have for this one. What I will say additionally, we do more than just immigration enforcement in ICE. My colleagues in Homeland Security Investigations also run the student visa program. They do child exploitation. There are a lot of reasons that we always want to collaborate on information sharing, which is why Congress put this into law to not prohibit the sharing of information. Thank you.
Thank you. Are there any questions? Delegate Cardin?
Madam Chair, thank you very much for coming. You see how you guys have late nights too. This is going to be a late night for us, so we appreciate you coming in and testifying. So I was mostly concerned that there was a woman who testified from the center, the privacy center at Georgetown, I think, law school. Mm-hmm. And she indicated that in North Carolina, there was an attempt to extract information about election election law. It had to do with people, voter registration, I think it was, is what she testified to. I don't have the sources. I'm going to try and get them. And Georgia, student information, California, student information. So the question.
Sorry, I was going to say Homeland Security Investigations runs the student visa program, SEVIS. So the schools are required to share information with us as far as, F1 students who are pertaining, and that's the only way they're allowed to enter into the program.
Okay, so I certainly don't want us to be in violation of federal law. That's for sure. So and the question is, if there's confidential information that shouldn't be shared, there's a difference between sharing information and agreeing to share with information, but not necessarily sharing information that that is appropriately private or confidential. For example, if a hospital has information and they want to share it with another, another practitioner for a patient, they have to get HIPAA permission in order to not violate HIPAA.
That would apply to us also. We under federal law, we apply to HIPAA as well.
Right, so the question is, if there is, for example, tax information, I'm not sure that DHS really, when the comptroller testified that they don't want confidential tax information to be disclosed unless there is and by the way, I don't think that if they agree to release it, but they shouldn't be required to release that information. And that's, I think, what the bill is trying to do. It's not.
My understanding of the bill is that it denies all access to us for all state records. So what I would say is that's a violation of federal law. I think that especially given the Homeland Security mission that we have, collaboratively sharing information across both state and federal, which, I kind of testified to earlier about, we get a lot more foreign intelligence information than the state government does, which we then share with our counterparts. I spoke to the police commissioner of Baltimore City yesterday about a terrorist living inside of the city. It's a two-way street of information. The other thing that I would say that I would like to address, I'm unaware of any data system that I can access that is not individual in nature about a specific person that I am seeking out. Right, I don't think there's any, tax information or driver's license information or federal criminal information, criminal records at all, where I could just say, okay, I want everybody from the ages of 18 to 25 who was born in, a foreign country, give me all the information. Like, none of the systems work like that. I have to already have a target of investigation, and then I'm doing data checks to determine, who that person is, what kind of a level of threat are they applicable to the laws of immigration laws of the United States. Right. So I think the fear that we're somehow accessing a huge swath of information and using it against every Maryland state resident is wildly misconstrued.
Okay. And just one last question, Madam Chair. So if in fact you are targeting you want to get information because you have an idea of somebody or some group that you need to have that information. And you're saying that if you ask them that they believe that this information is not appropriate to be released for various policy reasons within their agency, you think that could be so they're willing to share certain information but not other information. You're saying that you believe that could be a violation of federal law?
My reading of 8 U.S.C. 1373, I'm reading it from the American Defense Coalition. What was that?
Right.
Yeah, the American Legal Resources Center and the Washington Defenders Association. That's what it sounds like to me. I'm just a cop, man. I refer those things to the Attorney General's office to sue localities. But
you've given us a little bit of homework, so that's great. Thank you. Thank you very much.
Thank you. I'm going to go to Delegate Arakan in just a second. I just want to make sure I understand federal law. Does federal law allow, federal law prohibits state or local governments from prohibiting or restricting any government agency from sending to or receiving information from ICE regarding the citizenship or immigration status. That's my understanding of the federal law.
That sounds right to me. Again, I'm just a cop. You know, I got a lot of attorneys that work for me, and you know, at the end of the day, I always ask those questions of the United States Attorney General. But to that point, I believe that is the reason that Illinois and New York are under federal lawsuit now, is because of the lack of sharing of information.
Okay, but what I'm getting at is, and I think where Delegate Cardin was going with this, is that it's not, and as you said, it's not against, if the bill is not against sharing information, but if it's stating that there needs to be some level of particularity in the request so that it actually complies with this issue of citizenship or immigration status.
Well, yeah, so what I would say is, you know, if my officers are doing an investigation on someone's immigration status and they're reaching out for information, it's on a specific person, then yeah, I think the bill would do the exact opposite and prohibit us from doing that, which is where I think the federal law kicks in.
I see what you're saying, but what I'm getting at is, for instance, asking what I did on Monday, let's just say I was undocumented, and what I did on Monday, Tuesday, and Wednesday doesn't necessarily go towards my immigration status. But if you're asking, you know, do I have a driver's license? Can you have a copy of my driver's license? Can you have a copy of, you know, even my insurance form, maybe, you know, my insurance card or something, my insurance information could possibly go to my immigration status. But just blanketly, my activities of the day, I think that's where some discretion needs to come in, and that's kind of what the bill is asking for.
Yeah, so what I would, you know, just my own 2 cents, I would probably say we should see how the lawsuits shake out in Illinois and New York.
Oh, definitely.
You know, before enacting new laws that could possibly be in the same violation.
Oh, why? What's the fun in that?
You know, yeah, that's true. I got to keep the Attorney General of this country gainfully employed. So I mean, yeah, you know, let's, you know, as a representative of the federal government, I would hope that we just all comply with federal law. But you know, again, it's up to the state on what they want to do, and you know, hopefully that you know it's within the bounds of the Constitution.
Thank you so much.
Thank you,
Delegate Arikan.
Thank you, Madam Chair. Yeah, that's very true. Where's the fun in that? We like to get ourselves in court sometimes down here, especially on this committee. We enjoy that. So I just want to read to you from the actual bill. It says a law enforcement agency or unit of a state, local government operating database shall, number 1, line 26, deny access to anybody who appears to be seeking access to information for enforcement reasons for immigration. So that sounds to me exactly like a violation of 8 U.S.C. 1373.
I would agree. I think the other thing that I just don't know, because I've never been put in this position before, I don't know if that would preclude us from issuing student visas to the universities here.
Right, I'm sure it would.
Because in order to participate in the CVIS program, you have to share immigration with ICE.
Right.
So I don't know if that would preclude that.
Right, which is a terrible loss because it's a really great avenue for bright minds to come into our country legally and contribute to the betterment of our whole country. And you probably don't have an answer to this, but I'm just thinking if we do violate this executive order and this law, can you imagine the amount of money Maryland's looking to lose?
I really don't know how much federal funding comes into the state.
Oh, it's a boatload.
Yeah. I would hope that something like that doesn't happen. I'm here too.
Yeah.
I want potholes fixed.
Right,
exactly.
Like
I want police officers funded. We want all these things together in a mutual assurance. I just am here, again, just as an informational that I would suggest that we look at the constitutionality of this law before making any decisions.
Yeah, okay. Well, we really appreciate you being here. And since we're in a $3 billion deficit, maybe now's not the time to jump off of a cliff financially.
Thank you. And I just have to make sure that we complete the comma in that sentence. And there's an unless. So let me ask you now, how do you get whatever information you need to, whatever data you need? How do you get it now? Or your agency get it now?
Like any other law enforcement agency, we use a variety of resources that, state information, federal information, international information, commercially available information. There's anything available to our disposal that would help us, perform an investigation.
I shouldn't have asked that question that way because I get it. You are law enforcement and I get that. So let me just ask it this way.
I'm trying to answer it the most polite way I can without, divulging secrets.
I got it.
Yeah.
I didn't catch that. I'm sorry.
It's okay.
So do you ever, or does the agency ever request a warrant?
So depending on the case, yes. However, I will say that even in the case of today, where we arrested the number 2 MS-13 member in the United States, Mexico, and Europe, we arrested him under a civil immigration violation. Civil immigration violations are subject to administrative warrants that are issued by supervisory immigration officers. There is no judicial process. I cannot go to a judge. Even an immigration judge doesn't have the authority to issue a warrant for arrest. Congress placed that in the hands of supervisory immigration officers, and then we put those people in front of an immigration judge who ultimately decide that person's fate. But I think that's something that a lot of people, and it's just so strange, the way the civil immigration process works compared to a regular criminal process. There is no judge for me to go to. Right? This is not like out of laziness that I'm not getting, deportation warrants. Congress has given the power to supervisory immigration officials and not to the judiciary.
I see. Okay. Thank you. Delegate Boucher.
Thank you, Madam Vice Chair. It's been clear, thank you, Mr. Ellison, for being here. It's been clearly established that illegally entering our country is a federal crime. Therefore, can this bill be considered by the courts as obstruction of justice to harbor criminals?
So, well, a two-part question, because there's an additional statute for harboring aliens as well. I, not being a lawyer and just being a cop, I wouldn't want to comment either way. I will say 8 U.S.C. 1325, which makes illegally entering the United States at anything other than a port of entry a crime. Or 1326, where if you've been deported before and you re-enter, it becomes a felony. That would be up to whoever the new U.S. attorney for the District of Maryland is going to be. But I would not want to comment either way.
Okay, thank you very much.
Thank you, committee. That ends the panel, and that ends the testimony for House Bill 1431. We're going to move on now to Delegate Wilkins. House Bill 1006. And Delegate Wilkins. Let's see. Oh, this is a thick file. Oh my goodness.
I do. Madam
Okay, so we're so who I have for your first panel is Mr. Escobar, yes. Mr. Lopez, yes. Brianna Matthews. And I have Matthews Brown, I'm sorry, and Carrie Wright. That's the first panel. And then we have another panel. Okay, delegate, whenever you're ready, you'll have 3 minutes, and everyone else will have 2 minutes.
Thank you so much, Madam Vice Chair, and thank you to the committee for accommodating me. I was in the BRFA hearing. For the record, I am Delegate Janelle Wilkins. I'm pleased to present House Bill 1006. Increased immigration enforcement has devastating impacts on our state and the communities that we serve. Fear, erosion of trust, and residents foregoing essential services like healthcare or seeking justice creates a burden that has rippling effects beyond the federal government's intended targets. Immigrants are welcome here in our state. That is why it is important for Maryland to do all we can to protect our safe spaces from immigration enforcement by limiting our participation. Hospitals, churches, and schools should be safe spaces and off limits when it comes to immigration enforcement. Since 2011, Federal Immigration and Customs Enforcement, ICE, policy has implemented guidance that discouraged ICE from making arrests, conducting interviews, and searches in these sensitive locations. Unfortunately, the current federal administration rescinded this long-standing ICE guidance on January 25th, 2025. All Marylanders should be able to carry out basic activities and access crucial services without fear or hesitation. These spaces are the heart of our neighborhoods and our communities, and these are areas and institutions that individuals, families, and children rely on for basic services and survival needs. While we know that immigration enforcement is a federal power, we can act to ensure that our state takes every action possible within state and federal law to protect our residents, especially at sensitive locations. HB 1006 requires the Attorney General to develop guidance for entities operating in sensitive locations outlined in the bill to limit immigration enforcement consistent with federal and state law. State agencies that operate at a sensitive location must adopt policies consistent with the Attorney General's guidelines. I want to thank the Maryland Superintendent of Schools, who is here on this panel, ready to testify, for her leadership and responsiveness in issuing guidance to schools earlier this year. I also would like to thank Attorney General Anthony Brown for his leadership on this issue and for the guidance on law enforcement and healthcare facilities that he has already provided. I am in direct communication with the Attorney General on amendments to this bill, and we are working together to make sure that we have strong amendments to come back to this committee on and move forward with the passage of this legislation. I urge a favorable report on House Bill 1006.
Thank you. And whoever's ready to go next can go next.
Thank you for the opportunity to testify here. I'm Carrie Wright, State Superintendent of Schools. I appreciate the opportunity to speak in favor of House Bill 1006. It is critically important that state agencies protect children and families in sensitive locations, particularly schools, from immigration enforcement actions. The Maryland State Department of Education is committed to ensuring that all schools are safe havens for all children to learn, grow, and build a future without fear. The U.S. Supreme Court's ruling in Plyer v. Doe established that all children, regardless of immigration status, have the right to access public education. The threat of immigration enforcement at or near schools creates an environment of fear, preventing parents from engaging with teachers and discouraging students from attending school. Already, schools are reporting drops in attendance amongst immigrant students. Increased absenteeism will lead to lower student achievement and severely limit students' abilities to pursue higher education and careers. This will impact our state's economy for years to come. Education is a cornerstone of opportunity and should never be compromised by fears of deportation. Today, children across our state are living in fear of coming to school to find their parents have been detained and may be deported. The threat of immigration enforcement creates anxiety among classmates of family members or family members that are targeted for deportation, and it is incredibly traumatic. Schools must remain safe places of learning for every child, regardless of their immigration status. School staff should not be forced into the role of immigration enforcers, as their job is to educate and support students. School staff need guidance about how to respond appropriately to immigration enforcement while also protecting children and families. Since January the 30th, the Maryland State Department of Education has been issuing weekly guidance to local education agencies regarding the rights of immigrant students and strategies to encourage their attendance and keep them safe in school. We are prepared and eager to adopt policies consistent with the Attorney General's guidelines as required by House Bill 1006. Thank you.
Good afternoon. Again, thank you for allowing me here, Chair. Members of the committee, again, my name is George Escobar. I'm Chief of Programs and Services at CASA. Of course, on behalf of our members, I want to urge your strong support for House Bill 1006. And thank you so much to Chair Wilkins for your leadership. Thank you so much for your voice, Superintendent. The Protecting Sensitive Locations Act is about dignity, safety, and ensuring that every Marylander, regardless of immigration status, can access critical services without fear. For over a decade, federal policy restricted ICE activities in schools, hospitals, and other essential spaces to prevent intimidation and protect access. But that policy has been rescinded as of January 20th. Today, ICE has the green light to operate in places where families seek health care, where children go to school, and where people practice their faith. Some may point to recent ICE statements claiming that they won't enter schools, which is great. That's reassuring for now. But the reality is we cannot rely on verbal assurances. Policy changes with administrations, and without protections in place, sensitive locations remain vulnerable to enforcement actions. Maryland families deserve certainty. As one of the largest multi-service providers in the state, CASA has firsthand knowledge of the chilling effect that this fear has had. Parents are afraid to take their children to school. Parents skip doctor's visits. Worshipers hesitate before entering their places of faith. Through our ICE raid hotline that we heard a lot about earlier today, we have documented surveillance near workplaces, schools, and courthouses. Collateral arrests that we heard testimony on of individuals with no criminal history detained simply for being in the wrong place at the wrong time. Targeted enforcement against people engaged in everyday activities. To date, CASA has also trained hundreds of teachers, social workers, and faith leaders who are desperate to protect their communities from these escalating enforcement actions. But training isn't enough. What we need is clear, enforceable policy, and there's no doubt, so that there is no doubt, no fear, and no question about where ICE authority stops. For that and many other reasons, we urge your favorable report.
Thank you, and thank you to the chair and members of the committee. My name is Matthew Lopez. I'm an attorney with the National Immigration Law Center. As you've heard, in the first days of the Trump administration, the Department of Homeland Security changed a policy going back to 2011 that identified certain places where activities taking place there are so important and essential to the entire community that the agency would not conduct its immigration enforcement actions in those places because of values of health, education, and the administration of justice that we hold so essential. With this lack of clear direction from agency leadership, places like hospitals, schools, and domestic violence shelters have no official assurances that immigration officers will not show up at their door. And this is at a time when ICE is facing intense pressure from the administration to increase deportations, which is not really a condition in which to expect continued restraint. But although this policy has changed, it's important to know that the fundamental constitutional protections that govern these locations remain. It is within the rights and responsibilities of any of these sensitive locations to invoke their constitutional rights, and that's what this bill is about. Communities across the country have been left confused and unsure about how to proceed in this new environment. State governments like Maryland can play an important role in helping their residents and the staff at these kinds of sensitive locations to understand what their rights are. And it's also within their role to ensure that these agencies within their jurisdiction conform with the Constitution. That's why states have passed laws, why attorney generals have released similar guidance across the country, and Maryland has already begun providing guidance in certain areas. The Constitution and the Bill of Rights are the foundation of our legal system. We should celebrate efforts to understand those rights and be concerned about any agency that thinks it is a threat for people to know and invoke these rights.
Good afternoon, Madam Vice Chair and members of the committee. For the record, my name is Rihanna Matthews-Brown, Chief of Staff for Comptroller Brooke Learman, who unfortunately could not be here today. Comptroller Learman stands in strong support of HB 1006, the Protecting Sensitive Locations Act. Maryland has some of the nation's most robust international communities. 17% of all Marylanders were not born in this country, and yet they've chosen Maryland as their home, and we're honored to have them. However, if our immigrant communities cannot feel safe in their schools, in their playgrounds, in their hospitals, or their places of worship, we could lose them. And on behalf of our elected CFO of Maryland, our comptroller, I'd like to talk a bit about why such a loss would be devastating for our great state. Last year, our office released a first-of-its-kind report that assessed the state of Maryland's economy. And while we face many challenges, one consistently positive note was the role international immigration plays in keeping our state running. We then did a follow-up report that further explored the impact of immigrants in our economy. I'd like to share some figures from that report. First, let's talk about workforce. Immigrants in Maryland make up over a fifth of our civilian labor force. The benefits of our strong immigrant communities can be felt in almost every industry, from healthcare, where immigrants make up over 24% of registered nurses and over 55% of home healthcare aides in Maryland, to our crab processors, almost all of which would need to shut down without immigrants. Second, and this is especially relevant given the budgetary concerns we've all been following, our state revenue is dependent on the taxes paid by our immigrant community. In 2022, immigrants in Maryland paid over $5.3 billion in state and local taxes and contributed over $6 billion to social services programs such as Social Security and Medicare. If our immigrant community cannot feel safe in their most sensitive locations, and the places where they learn, where they worship, where their children play, many will choose to leave Maryland, which will have a devastating effect on our economy. For that, we urge a favorable report on HB 1006. Thank you.
Thank you. Now we're ready for questions. Delegate Kaufman?
Yes, Delegate Wilkins, it's good to see you, my friend. While you're in the BRFA, Mr. Ellison, who's the Director of ICE for the state of Maryland, testified on the record that that despite the rescission of that order, that his team is not going into schools, churches, and he said he had only been into a hospital just once to get a detainee to the hospital. So some will argue, based on his assurance, that the law is not necessary because he said the bill is not necessary because he said he's not going into those sensitive spaces. But isn't there something to be said for, regardless, I always give people the benefit of the doubt, regardless of what he says, isn't there something to be said for mitigating anxiety and fear and just having it on the books? Even though Director Ellison said he's not doing that, the fear is such that, don't you think to ease anxiety, this legislation is still necessary? And then I have a question for Dr. Wright, if that's okay, Madam Chair.
Thank you so much, Delegate. That's a great question, and thank you for giving me the opportunity to address that issue. I think that as legislators, hearing from ICE, no, we don't plan to do that, is certainly not the assurances that our constituents need, especially our immigrant communities that are depending on us to act and do what we can as a state to put in place policies and laws that protect them. And the fear as well in our communities around the national call for increased immigration enforcement. Whether or not ICE is doing that now in terms of approaching schools and hospitals in those locations, that can change at any time. We know if we watch the news that there are people who are not happy with the rate of deportations that want to see more. So what happens when ICE decides to ramp up and potentially begin to intrude upon our safe spaces here in Maryland? We want to know that we've put this policy in place, that we've ensured that there's strong guidance for our sensitive locations, and that our people on the ground know what to do and what not to do under state and federal law when it comes to ICE enforcement. So I think that the bill is still extremely necessary. Thank you.
Thank you. And may I ask a question of Dr. Wright? Dr. Wright, it's nice to see you again. You were the head of special ed when I was in MCPS. My question is, you talked about higher absenteeism as a result of the fear and the anxiety. Like, do you have data that says, I'm just making this up, but like 10% fewer are going to school, or particularly in MCPS, or just statewide data to back up your assertion? Because I'm sure some of the opponents of this legislation will ask for data.
So right now, at the top of my head, no, I cannot give you that figure. But do we collect that data? Yes, we do. All schools and all districts collect absenteeism data, and this is what I am hearing anecdotally from the superintendents and principals that I've been speaking to.
Okay, well, when you have firm data, if you could share it with the committee, that'd be awesome. Thank you.
Delegate Arikan and then Delegate Williams.
Thank you, Madam Chair. Thank you for being here, Delegate, and thanks for your work on the budget, the BRFA. I just have my copy sitting right here. It's a delight. Montgomery County has been working with ICE for a period of time now. The director testified to that on the record today. He also testified that your county is enjoying a 50% decline in violent crime since that handshake MOU has been in place. Were you aware of that?
I wasn't present for that testimony, and I'm not going to be able to comment on that, unfortunately. Okay. I'm not sure.
Okay, I wanted to correct another thing. Quotas were mentioned. He also testified on the record that they do not have quotas. The ones that have been mentioned are up to 75 people a day. He's said he's never arrested 75 people in one day, and that's not reasonable. And I just wanted to get your opinion on the economic impact if we continue to attempt to violate federal laws. The President of the United States has already said that he will take federal funding away from us if we pass bills like this. Do you have any comment on what the fiscal impact might be?
I think we should look at the economic impact of what fear in our communities brings. The comptroller's testimony just brought a little bit of that to light. When our immigrant communities who contribute so much, including whether it's to the businesses that they own and run, whether it is the sales taxes and just other ways that they participate in our economy and society, what happens when a huge swath of our communities stay home due to fear and how that has an economic impact. I know that other witnesses on this panel can also speak to and respond to statements by the president, but I think that the economic impact of our immigrant communities should also be a really important factor in this bill, and more importantly, making sure that we as a state take the actions that we can to help reduce fear and to make sure that our folks on the ground know their rights and what they can and should not do when they interact with ICE enforcement.
So if we lose Medicaid funding, for example, that would you think would be a worthwhile loss to make sure that we battle fear?
I have a couple responses. First is to address sort of the concept here, because nothing in this law would be contrary to federal law. All that this bill does is call on the Attorney General to explain what constitutional rights are, and those constitutional rights are the bedrock of federal law. So there is no violation of federal law to inform and follow constitutional rights. And furthermore, as it relates to the idea of withholding funding, the administration's been trying to tie funding to all sorts of things: DEI programs, inclusive transgender policies, and in the past, courts have overwhelmingly found that it's impermissible to impose immigration requirements, even in federal criminal justice grants. And in fact, just last week on the idea of connecting to federal funding, a federal court in Baltimore prohibited the government from imposing certification requirements or threatening funding for the defendants who are challenging the legality of anti-DEI executive orders. So I think that there's both reasons why this doesn't really apply to that question, and why, even if it did, there's a lot of reasons why these attempts to connect it to funding are unlikely to be successful.
And really quickly, Delegate, I do want to point out that the bill language literally says under state and federal law. This is not a bill that's directing us to violate federal law or any of our state laws. And because we have the Attorney General leading this effort, he is very well aware of what our state and federal laws are to make sure that we stay within them as well.
Well, with all due respect, he's been wrong in almost every case he's brought, but I appreciate it.
Delegate Williams? And then I'm going to circle back around. I see new lights.
Okay, thank you, Madam Chair, and thank you, Dr. Wright. I've been hearing anecdotally the same things that you've been hearing with regards to our schools. I apologize, I had to step out. And my understanding, Delegate Wilkins, you had mentioned that you guys are working on some amendments with the Attorney General's office. And so I think we had this conversation previously. I know I had received some requests and concerns from our library system, for example, in Prince George's County, that would love to have some additional guidance as to what they should do. We had a situation where ICE was across from our local library in Prince George's County. And so as you're working through amendments, just hope that's one of them.
Thank you so much, Delegate. Yes, we are in receipt of that request, and there are numerous requests to add additional sensitive locations. As we get them, we are requesting amendments for consideration. So I'll definitely make sure I follow up with you on that one.
Okay, thank you.
Thank you.
And since I'm still looking this way, we're going to go to Delegate Sample Hughes.
Thank you, Madam Chair.
Thank you for being here, panel. Dr. Wright, I just have a question for you. I know we talked about absenteeism in the school system, but what I have learned from some constituents is absenteeism in the workplace from the parents who work in Dorchester County at a particular facility are leaving to try and go get their kids from a school in Delaware, which is right there on the border. We border Delaware. So have you had an opportunity to talk with your colleagues from Delaware, Virginia, or Pennsylvania, for that matter, about those things occurring where their kids are having to be pulled out of school? I was just curious because I know that's what was, shared with me regarding Delaware, and
So I've not specifically heard that, to be honest. The state chiefs all belong to the Council of State Chief School Officers, or CCSSO, and they provide a lot of information to us directly, as all state chiefs get this. We get a weekly newsletter basically from them updating us on the newest things that have been coming out on the EOs, et cetera. We've also been listening to, we get advice from Ed Council, which is a national organization in DC, advising around the issues that we're talking about today. We've also been in close partnership with the Attorney General so that if he's hearing something or we're hearing something, I know he's meeting on a daily basis with his leadership team, and we are meeting on a daily basis at the department. So we've got a lot of people whose eyes are out there looking for these kinds of things, but that particular situation has not arisen. But I can certainly take that back and find out even internally with the other 23, 24 school districts if that is occurring across the state.
Sure. Yeah, that would be appreciated because not only, we talk about schools a lot, but, we also talk about the workforce.
Absolutely.
And when I'm hearing from employers and employees of these departments, they're saying this is what's happening. They're running to Delaware because they reside in Delaware, but they work in Maryland and having those challenges. So I was just wanting to get a better understanding. But if you do happen to have that at some point, feel free to share.
Will do.
Thank you.
Thank you. Delegate Valentine.
What triggered this question was the good delegate to my left was talking about, and you mentioned, delegate, about adding additional via amendment other locations. I'm looking at page 2 of the bill at the bottom, any other location deemed appropriate by the Attorney General. I'm trying to think what other possible locations could we add to this list?
I think one of them that was mentioned was libraries potentially. There have been other requests that I'm trying to recall that have come in, but as you can imagine, as people have seen this bill, they think of places where immigrants gather, where community spaces are, and wanting to make sure that we cover every location possible. I do think that we're going to have to figure out with the Attorney General, and that's why we are working together directly with him, what is feasible in terms of his office and how we encompass. Some of these might have overlap, right? Like it's possible that a food pantry and a library, that the guidance may be similar. And so figuring out and making sure that we're streamlining to cover as many places as possible, but also to not overburden the Attorney General's office with trying to identify every single space.
It does seem like a pretty comprehensive list.
Thank you, I appreciate that.
Thank you. Thank you, Madam Chair.
Delegate Pasteur.
Thank you, Madam Chair. I'm thinking, and I guess I want some feedback on some specifics. When we early on talked about some of the people who would be at risk with all of this in terms of movement, we talked about agriculture, we talked about the things of that nature, and what would be missing in terms of those who would be supplying some of the work, some of the positions. But as someone up there just pointed out early on, when you look at who the people are in colleges doing medical services, who are in nursing homes, who are in hospitals, et cetera, that's another large group of people that we will be impacted. So when we're looking in our schools, in our public schools who then go to our colleges, we are doing the preparation. And I know from one of my own bills that we are asking that those students, as they go to college, are given tuition waiver in-state for in-state fees, so it makes it more affordable. So there is a very large impact here in terms of our workforce on a very different level, our very professional, our very white collar. And I remember, so I want to know, there's a question somewhere in here about what is being said, by the administration, because I do remember at the beginning, all right, let me mess up his name, Ramaswamy, okay, remember, who was with Elon Musk at the very beginning. They were going to do the effectiveness. And I remember him talking very specifically about the impact of what we do with immigration on the brain trust, if you will, in this country. So where are we with that? Because we know the risk we're running here, but where are we with the government? Any of you had any thoughts about this or conversations with anybody, with Congress folks, about just where we are, where the president is right now in his thinking about how we protect people who are on different work levels? That's a long piece, but it's a critical one. And it has been out there for conversation. So there was that differentiation about who we're going to send out and who we're not going to send out. Where are we with that conversation? Ooh, silence.
I could just add, and thank you so much for that question, Delegate, right? Because I think it is important to look at the entire context, right? And especially the language and the verbiage that's coming out from the federal administration, right? We have seen this broadcast on television, the President of the United States and his cabinet officials calling immigrants dirtbags, saying that Haitians eat dogs, right? These are just some examples of the disdain and the demonizing that the federal administration has labeled our entire immigrant community, regardless of whether they're engineers, regardless of whether the fact they're students, or regardless whether the fact they're an agricultural worker or a fisherman working in the eastern shore of Maryland, right? This is why we're bringing this to your attention, because at this point, there are no federal protections. The federal, we referenced this in our testimony earlier, right? Previously, the federal administration had dictated to ICE to limit their enforcement actions away from these sensitive locations, hospitals, schools, churches. That's all gone now. ICE and these officials and the ICE director here in Maryland could do whatever he wants. He's promising all of us here today that that's not what he does, right? That he does not want to go into a school. He might lose his job tomorrow, right? Whoever replaces him may not come to you with those guarantees, and those are nothing but verbal guarantees. So the only thing we have to protect our community right now are the actions that this state has the power, this legislative body has the power to enact, right? You all, in your authority, have the power to make those guarantees, because there is no federal administration right now that we can trust that can provide those guarantees at all. And so that's why we urge your support on these types of bills.
Okay, may I, Madam? Okay, so I guess I'm still stuck on what I said this morning on the floor. I refuse to just give in and give up. So what I like about this is that it is steeped in whatever the law of the state is at this point and how we map out protections. But we also need to be very clear about speaking up in a very different way and infusing what we're are saying in the language of our bills so that we are.
Just, I didn't want to, I'm sorry to interrupt you, but I am timing, I am doing a 3-minute now.
So we are protecting our folks. So my real question was, what are we saying in this that maybe I'm not seeing? What are we saying in this in terms of the positive? What are we asking for to make sure that we are still educating folks on all levels who are going to still be able to give us those brain trusts or those services that we need?
To clarify, are you saying, what are we saying to the federal administration?
What are we asking the state's attorney to,
Understood.
The Attorney General to put into the bill and as the sponsors of the bill that will give some direction, not just say we're covering them, whoever the them happens to be, that we're making sure that we have a roadmap to protect those that we really know we need.
I think what this bill is saying to the public and to our residents and our constituents is that Maryland is going to step up and do its part. We know that we don't control ICE, we don't control federal immigration enforcement, but we do control our social service agencies. We do control our actions on the state and local level, and that within federal and state law, we are going to make sure that we are not fueling and participating in ICE enforcement that harms our communities and sows fear. So I think that that is the message and that is what this bill is saying and doing. In terms of what it practically, substantively does is that it does direct the Attorney General to issue that guidance. I don't know about you, Delegate, but I received many calls from hospitals and healthcare workers and emails who were saying, what do I do? As soon as this guidance was rescinded, the first day of the administration, what do I do? I'm hearing from my patients. They don't want to come into appointments. They are scared. They are canceling. I don't know what my rights are and what could happen. And I think it was very wise and very responsive of the Attorney General in that case to issue guidance. And it's very detailed, very helpful guidance that he issued to healthcare professionals and healthcare workers. And we want to see more of that, and this bill helps to create more of that so that our communities and our folks on the ground have a better sense of what to do.
Thank you. That's what I wanted to hear.
Thank you.
I wanted to hear that those strategies and guidelines are included. Thank you.
There we go. All right. Delegate Simmons.
Madam Chair, and welcome everyone. We've heard a lot of testimony here today, a lot of it around public safety. Does this bill in any way prevent ICE officer from doing their job if the person is deemed a threat to society?
No, it does not. It maintains the same restrictions on ICE that existed before the bill, that if an ICE officer believes a person to be somebody that they are able to pick up, then they can go to a judge and get a judicial warrant signed by that judge, and they're able to enter that location. The other thing is that it also, this isn't where people really live that often.
Okay.
Delegate Simmons, did you have another question?
Sorry.
All right, Delegate Phillips.
Thank you, Madam Chair. And thank you for bringing the bill. One of the comments was made that the ICE director in Maryland indicated there were no quotas. What was not said is he did say they were goals. I wonder the difference. Anyway, let me ask my question. There was a case, I believe last week, where the federal judge entered an injunction as it related to churches and houses of worship. Would the actions that we are taking today assist the Attorney General if we have laws in Maryland that talk about sensitive places? Would that assist the Attorney General in ensuring, even if we got in a district court with a judge that is sensitive, as we see here, with making the argument that these sensitive places should not be infringed upon? That's for the AG. Anybody? Can I answer that?
The AG as reference to the comments by the judiciary.
Say that again.
But in courthouses, you're saying?
No. This isn't about courthouses. This is about should we have to, should there be litigation on the sensitive places, right? Because we say people shouldn't go there. Don't we need this on the books if there are challenges between the feds and the state?
I'm not an attorney, but I do think that us having a policy on the books as a state of Maryland that says that we are working to limit that participation at courthouses, at houses of worship, like you mentioned, it seems like those would be facts that in a future case would come up and be relevant, and I hope helpful in those types of cases. I can't say for sure, but I would assume that they would take a look at what we have on the books, what is the policy and the laws of the state of Maryland, and that would be a factor when there is litigation or cases coming down.
Okay. And because these places you've identified in many instances have some type of constitutional grounding, right? If it's a religious place of faith, First Amendment, health.
Right.
Correct?
Correct.
All right.
In addition to that, Delegate, they're also state-funded activities, right? So, for example, places that provide public benefits that are under state control, right? In even places like community-based organizations or in your DSS office, for example, those are all covered within these. Within this bill, and that's the vision, right? And I think to your point about the lawsuit, I think it's also reassuring in that lawsuit, right, was contesting the loss of this executive of these limitations on these protections of these secure locations, but looking only specifically at houses of worship. Now, that is very reassuring for this body if they were going to enact this legislation, because those are the exact types of things that you would interpret into these other sensitive locations. So you know that at least in the District Court of Maryland, right, you're on solid legal footing to enact this and expand upon that finding.
Thank you.
Delegate Grammer and then Delegate Taylor.
Thank you, Madam Chair. This might be the biggest he said, she said battle I've ever seen. So I actually do believe there are certain protections we need to place at sensitive places. Delegate, were you here earlier in the day when the gentleman from ICE talked about why these guidelines were adopted federally?
I was not present, no.
So the guidelines your panelist mentioned, the ICE gentleman said what they would typically find is when they had violent criminals they were pursuing, they would find refuge in some of these places. And those were the deviations they needed to make to pursue these people. And I asked him 3 questions, which Delegate Kaufman alluded to. I said, do you enforce at schools? And he said, no. And I said, do you enforce at churches? And he said, no. And I said, do you enforce at hospitals? And he said, no, unless I need to take someone to a hospital. So this whole argument, as we've talked about this today, is that we really have zero evidence that this happens at all. This is kind of like a hypothetical future thing that might happen that we're going to terrorize everybody about. Like, I get it. If I was an immigrant and I'd listen to you, I'd be terrified too. But the problem with the way this bill works, it essentially does 2 things. It allows the Attorney General to make a guideline, not about sensitive places, but about any place. Like, I like that you've listed some things here, but at the end it says, and any other location deemed appropriate by the Attorney General. Like, literally, the Attorney General can make a guideline about anywhere under this bill. And then it requires that state agencies adopt policies to conform to those guidelines. So based on a he said, she said of something that the federal government is totally in disagreement with the Attorney General on, he can adopt guidelines and every state agency must comply with that based on no evidence.
So you've got to get to your question. You've got 1 minute.
I would be amenable to it if we were adopting a policy, but this is essentially, you're literally letting the Attorney General have some kind of pseudo-regulatory authority over every state agency based on no evidence. Why should we do that?
So I think I take a little bit of exception to the he said, she said, because I think what you're almost suggesting is, I don't know about your constituents, but at least for mine, going back to them and saying, hey, trust ICE. ICE says they're not going to do this, so it's all good. Everything is fine. You're all good. We heard from ICE that they won't be enforcing at these locations, and we've done our job. For my constituents and for the immigrant communities that I know, is not going to be sufficient. So that's first and foremost. Also, where they might be some he said, she said, is that we're hearing on the news that perhaps there is a dissatisfaction with the numbers when it comes to how much enforcement has been happening. And what happens when those numbers decide to be ramped up? And at any time, ICE is able to, without this guidance in place, decide to do enforcement at these locations. That guidance was rescinded for a reason. If ICE has no intention and no interest of ever enforcing at these sensitive locations, why did President Trump decide to rescind it? Keep it in place then.
Yeah.
So I think that those are some of the pieces why I think that this bill actually is important. We need policy at the state level, and I'm glad to hear that we have agreement, at least it sounds like, that there needs to be some type of policy around sensitive locations in the state of Maryland. I'd love to talk with you more about maybe where we might have further agreement on what that looks like. But I think that us just taking ICE for their word when that can change at any moment is not sufficient for me or for my constituents.
I wouldn't say trust ICE or any part of the government. I love not trusting the government. But the burden of proof to pass this bill is kind of on you folks. And there is zero evidence that, other than these rare cases where they have to pursue someone who is clearly violent, that there's zero enforcement in schools. There's zero enforcement in churches. You know, the bill itself is a lie. It says sensitive location. It should say every location. It quite literally allows the Attorney General to issue an opinion on any location. So,
Is there a question? What's your question?
No, that's okay. I was trying to formulate it, but I get the sense we want to move on.
I do want to move on because I think what I'm hearing is that, is the bill preemptive? Is that part of the reason why the bill exists?
It's a hypothetical.
Yes. Okay, so I just want to make sure we get to the bottom, to the bottom issue.
Thank you, Madam.
Okay, I said Delegate Taylor next, so then I'm going to go to Delegate Simpson, and that'll be the last question for this panel. Delegate Taylor.
Thank you, Madam Chair, and thank you, Madam Vice Chair, for bringing this bill. And a bill that we know that will probably be massaged a little bit more as we go along. My question kind of follows up on Delegate Simmons, who asked, well, let me say this. Maybe more he say, she say, but our director said that, what if there was an active shooter in a school or a church? Would this bill preempt ICE's ability to work, to do their job in an active shooter situation in any one of these safe places that we've identified in this bill?
So the state cannot preempt federal immigration law. We know that when it comes to immigration law, the federal government takes precedence. And when it comes to an active shooter and some type of targeted enforcement that ICE is trying to make, and I guess we're assuming that it's an undocumented immigrant, there's a judicial warrant, there's nothing in this bill that would prevent that from happening. And that's why we need this guidance. We want our schools to know what to do in those situations. If ICE does come knocking on their door, whether it's a case like that or another case, we want guidance from our Attorney General, which our Superintendent of Schools has issued to help support our administrators, our principals, our leaders to know what to do. So that is really the basis for the bill, and it would not prevent ICE in that situation or any of these situations where they have a judicial warrant. We cannot preempt the federal government.
So can you get is it time for a judicial warrant in an active shooter situation though? I think that's part of this, was part of his.
So I think my question would be, in a situation where there's an active shooter, I would expect a police response.
Yeah, maybe the
and I
word
think that
comes
that would be the
faster.
priority.
Right.
So I would just assume that we would want our officers to respond, and we'd have to deal with any immigration issues maybe later after apprehending and making sure that the students are safe.
Thank you.
And I would say, like, even beyond the active shooter scenario, I know that's really scary, but still, they're still law enforcement officials. They're allowed in their hot pursuit to pursue somebody they're actively engaging in, regardless of where they go, right? So yes, we could have the sensitive locations mandate, but if they're in hot pursuit of a suspect, that goes above and beyond, and they could still do that.
Thank you.
Okay, Delegate Simpson for the last question for this panel.
Okay, so thank you very much for bringing this bill. Appreciate you. So just walk me through how this is going to work. You know that my husband is a pastor, and you know that our church offers several different services. So, you know, sometimes it's a school, sometimes it's a church. So how does this, you have someone, they're dressed in their, you know, their ICE gear, they say they're just there to worship with everyone, or they're just there to drop off their kid. How does this protect? Like, how as my husband or somebody who's working, you know, the director of the school, how does this work?
Thank you for the question, Delegate. And colleagues, I want to use this as an opportunity to really make crystal clear the provisions of this bill. This bill directs the Attorney General to develop guidance. It's a concept that is really important for our people on the ground, like our pastors. The Attorney General has already developed guidance when it comes to healthcare workers and when it comes to law enforcement. So I literally have a copy of it and was reading through it. In those situations, the guidance is very detailed and shares, here's what to look for, here's what to do. Here's the type of questions and things that you should be thinking about if you are in that situation. And for places of worship that are huge gathering places for many of our constituents, and definitely for immigrant communities, having guidance that a pastor would be able to look at and say, here is what I have to look for. Does the person have a judicial warrant? What are the questions and things to look out for in those situations is something that would be really important for our folks on the ground who are interacting with and supporting and working with our immigrant communities. So to be really pointed with your question is that our pastors and other communities on the ground who are leading and interacting with our constituents would have specific guidance from our chief legal officer of the state of Maryland to know what to do and what not to do under federal and state law.
Thank you very much.
Okay, great. That concludes this panel, and we're going to move to the second panel. And what I'm doing is essentially, I know the chair said 3 minutes, but I'm nicer than the chair. I'm giving you all 5 minutes, so please let's keep that in mind. On this particular panel, we're going to call up Viviana Westbrook, Stephanie Wolf, Matt Hornbeck, Reverend Dr. Kevin Slayton, Laura Garcia. You all get 5 minutes. I'm sorry, I'll explain that. Okay. Okay. No, I was getting ready to tell them. Okay, so let me make it clear. Members, I'm timing you all for the 5 minutes to ask your question and to get an answer. For witnesses, I'm sorry, you only get 2 minutes. Okay, so let's just make that clear. 2 minutes. And members, if you want to take 2 minutes, that's fine too. All righty, so I think we have, there's one more person from CASA. I don't have a name, I just have a impacted community member. Do we know who that's going to be?
Yes, she's right here, Michelle.
Michelle Espinoza? Yes. Is that who it is? Okay, could you come on up? We're going to just do a tight squeeze for this panel, and then we'll move to those who are on our virtual. We're going to hear from this panel first. And then I think what I'm going to do, in the interest of time, we're going to hear from this panel, and then we'll move to virtual as a separate panel altogether, because you have quite a few people on virtual. So let's start, if you would start, sir, and then we'll just go down the row, 2 minutes each. Thank you so much.
Thank you so much, dear Honorable Chair Clippinger, Vice Chair Bartlett, and members of the committee. My name is Matt Hornbeck. I'm the proud principal of Hampstead Hill Academy in Baltimore, a build leader, and I'm here today in solidarity with CASA. I strongly support HB 1006, the Protecting Sensitive Locations Act, because it establishes essential uniform guidance to protect the integrity of places that serve our communities, schools, hospitals, courthouses, and places of worship. Every day I see the impact of fear on students and their families. Hardworking parents fear they'll be taken from their children simply because they're dropping their kids off at school. I recall a first grade student whose parents provided his teachers with copies of his U.S. visa, desperate to ensure his safety if an immigration raid were to occur, no matter how rare or impossible that sounds after hearing some of the testimony today. No family should live with this level of anxiety, especially in spaces dedicated to education and community support. At Hampstead Hill, we believe that school is the opposite of fear. It's a place of love, kindness, respect, and protection. A mother, a DACA recipient, shared her exhaustion. People think DACA gives us security, but it does not. It's a work permit, not protection. I live in constant fear. Another parent described how ICE's recent and increased presence has changed their lives. We used to go to church and then to breakfast as a family. Now we don't feel safe leaving home. This legislation is about fairness and humanity. It ensures all essential service locations remain places of safety where people can seek education, healthcare, and justice without fear of enforcement actions. Schools should be places of learning, not fear. Hospitals should be places of healing, not hiding. Courthouses should be places of justice, not intimidation. Maryland must set a clear, uniform standard that guarantees access to essential services. I urge a favorable report on HB 1006 and that this committee uphold the dignity and security of our communities. Thank you so much.
Good afternoon. My name is Michelle. I am 18 years old. I'm a senior at Damascus High School in Montgomery County. I'm here today because instead of focusing on graduating high school, getting good grades, my college applications, and currently having prom, I have to worry about whether people in my family and community may be torn apart by ICE. Growing up with family members and neighbors with different immigration status fear has been a constant part of my life. Now it is scarier than ever. I spent years wondering if one day when I come home from school, someone I love won't be home. It's even scarier when I hear about ICE agents waiting outside of schools or following families from hospitals. I've seen firsthand how racial targeting plays a role in immigration enforcement. My friends and I, students from immigrant families, are always the ones who feel watched. Meanwhile, my white classmates never have to worry about that basic doctor's visit or a trip to school could lead to their parents being taken away. It's completely unfair. When ICE operates near school, it doesn't just harm undocumented families, it hurts entire communities. It disrupts classrooms, silences students, and makes kids feel afraid to dream about their future. All of us kids and students, we just want to go to school and we just want to learn. That's why I support this bill, and I ask the community to please keep the places meant for learning, healing, and faith safe for me, my family, my friends, and my community. Thank you.
Good afternoon, members of the committee. My name is Laura Garcia, and
Ma'am, the mic is flexible. Can you just, there you go. Perfect, thank you.
My name is Laura Garcia, and I am a nurse practitioner, primary care provider, and the chief medical officer at Healthcare for the Homeless in Baltimore. Thank you for the opportunity to speak for House Bill 1006, the Protecting Sensitive Locations Act. I have worked at HCH for the last decade, and over my tenure have delivered care to many immigrants, both individuals and families who are unstably housed. Since the rescission in January of the previous policy protecting specific sensitive locations from immigration enforcement, we are already seeing significant consequences, especially in terms of patient behavior and their concern for safety. The anxiety and fear that immigrants are feeling is considerable. This only compounds already complex physical and psychosocial health issues for these unstably housed patients.
We have seen higher no-show rates, fewer scheduled visits, and more reliance on telehealth since January. That reflects a sense of instability and lack of trust in the system. When call center staff speak with patients, they only affirm this concern. The fear of deportation outweighs the need for care, non-urgent and urgent. When patients delay care out of fear, they're much more likely to end up in emergency situations that are more costly and difficult to treat. Increased ER utilization is not only taxing for the healthcare system, but also creates worse outcomes for patients. The guidance the Attorney General has given to medical clinics like mine has been invaluable, and all potential sensitive locations would benefit greatly from similar guidance. This would allow for a more standardized and hopefully broader interpretation of the protections across these locations we can and should afford these individuals and families. Many of my patients access services at multiple locations, such as hospitals, schools, houses of worship, and social services establishments. Having all of these service providers following the same rules allows for fear to be mitigated. I urge a favorable report. Thank you.
Thank you. Good afternoon again, members of the committee. Vice Chair Bartlett. The Maryland Office of the Public Defender respectfully requests the committee issue a favorable report on House Bill 1006. Maryland courthouses must be safe and feel safe for everybody if real justice is going to be done there. If some of us have to fear that any appearance in a courthouse carries the threat of deportation, detention, family separation, and exile, then we are not offering safe and equal justice for everyone. Over the last couple of weeks, between the rhetoric of mass deportation and the reality of new immigration enforcement policies, our institutions have begun to feel increasingly dangerous to our immigrant clients. I have received inquiries from public defenders around the state wondering how and whether they can honestly reassure their clients that it is safe to appear in court. And these inquiries came not only on behalf of our clients who are facing criminal trials, but also on behalf of juvenile respondents and their parents, clients who wanted to pursue post-conviction relief based on constitutional violations, but worried it was too dangerous to risk coming to a hearing, clients facing minor traffic charges, and more than one client who badly wanted the help that they could get in drug court or mental health court, but were concerned that regular courthouse appearances would be too risky. And it's not just undocumented Marylanders who are afraid. Children with special immigrant juvenile status, temporary protected status holders, people granted humanitarian parole, and the U.S. citizen children of non-citizen parents, as well as at least one lawful permanent resident, have all expressed to us fear of coming to court because of ICE. These examples, which include people who are not legally subject to an ICE arrest, illustrate that the perception that courthouses are unsafe can spread throughout a community and broadly chill engagement with the legal system. We urge a favorable report.
Good evening, Madam Chair. I am Reverend Slayton, Baltimore's Northwood at Pole United Methodist Church. And I've come before this committee to share the cry and the unified voices of some 130 faith leaders around the state in our respective roles and faith traditions as we are all in support of immigrant justice. Together we are focused on a shared principle of faith, which calls us to stand with the stranger and to love our neighbors just as much as we love ourselves. So we've signed a letter that's gone to the governor as well as this body urging your support to protect immigrant communities. And while we believe in the moral and ethical laws that govern our daily lives, we also are ill-equipped to handle the legal challenges that so many will face. So to Delegate Simpson's question, this bill will provide the guidance that we so desperately need, not only to ensure that we don't jeopardize our tax status or our nonprofit status, but also to ensure the safety of those who worship in our spaces. Marylanders should know that all places of worship are protected from the adverse advancements of ICE enforcement. I'll say this in closing. The First Amendment of the Constitution protects one's right to practice their religion. Well, we've been practicing it since it was ratified in 1791. Damn it, we ought to know how to do it by now. That you should do unto others as you would have them do unto you. I'll leave you with this, Deuteronomy chapter 24, verse 17. You shall not deprive the resident immigrant or the orphan of justice. Remember that you too were a slave in Egypt, and the Lord your God redeemed you Therefore, I commend you to do this also. I read that because as an African American, I have memories and histories that we have gone through the same incidents before. We urge your support. House Bill 1006.
Thank you. Good evening. My name is Viviana Westbrook, and I'm the state and local advocacy attorney at Catholic Legal Immigration Network, otherwise known as Clinic. And we have a vast network of affiliates who are nonprofits that provide immigration legal services to migrants. And well, I'm here today because I also work with the Catholic Conference and a lot of different Catholic groups and also others. So I wanted to respond to some of the questions I heard. So I did submit written testimony, and so I will refer you to that. But I know that there was a question about what examples have we seen either in the past or currently. And I do want to say that in the past, previously, as an immigration attorney who was practicing under the first Trump administration, I did see during that time, I had clients who told me, that in Maryland, what would happen is that people were coming to bus stops, right? Kids were getting picked up, getting on their buses, and as soon as the bus turned the corner, ICE would descend and, do some enforcement actions there, right? And so those things were not listed under the sensitive locations policy, which that's what was enacted in 2011. We've had some form of it since 1993. But in 2021, it was, I'm going to say upgraded. It was changed to protected areas, and it became more inclusive. And I think it was something that was very much needed. And the reason that we needed this inclusion was because we were seeing violations in many different areas. We were seeing enforcement actions in courthouses, in places of worship, and many other places. So I think it's really important to understand that this is something that is needed. We worked to get this expanded in 2021, and so we really want to see Maryland protecting and upholding its values. So we urge a favorable report. Thank you so much.
Thank you. Are there any questions? Delegate Grammer.
Thank you, Madam Chair. Couple questions. Young lady from the Healthcare for the Homeless. Have you seen an enforcement action in your healthcare facility?
I have not.
Okay. Young lady from OPD, have you seen an enforcement action in a courthouse that's not part of a detention or correctional center?
So I personally have not. I have had reports from public defenders around the state. Yes.
Reports. Reverend?
Yes.
Have you seen enforcement actions in the church?
No.
Okay. Young lady on the end, you seem to have seen enforcement actions on school buses, churches, and hospitals. Per your testimony, is that correct?
Right. This was prior to 2021.
Prior to 2021.
Yeah. And we do have instances now that have also been reported. And I think it's really important to note that even though if honestly, at the end of the day, it doesn't matter if these are happening or not, because the chilling effect is the most real thing that we are seeing. And unfortunately, this is something that is often, overlooked and just minimized, but I think it's really important to know. And the reason that they even did away with it, like what was the reason, right? We have tons of exceptions. There were so many exceptions to the protected areas policy that the reasons that the government gave for doing away with it weren't real. They were already covered under the exceptions. So they were already going in there. They were saying that, oh yes, well, people are hiding out in churches and schools, and that wasn't happening. They were allowed to go in there and get people for many safety reasons.
Right.
So.
And I actually agree with that. I think it's the perception, it's the chilling effect that is important. But as leaders, I think the important thing to do is not to scream about it as if it's chronically happening everywhere, because that's what you see in the public sphere. It's what you see in the news. It's what you see from the Attorney General. But you have professionals here, and I appreciate your advocacy, but per your experience, it's not happening in a healthcare setting or any kind of firsthand incident in a courtroom or a church. And we get, I'd love to see it if you had examples. We can't rely on reports.
Can I give you one example?
Sure.
And I don't want to scream. It's grammar, right?
Yes, Mike, please.
I don't think that
Speak
in
into the mic, please.
1960 there had.
Sir, Reverend, could, yeah.
Yeah, I was going to argue that. I don't think in 1960 there had been any examples of 4 little black girls being blown to smithereens in a church service. There hadn't been any examples yet. Nobody was arguing about it yet. But the shit happened.
Right.
Because somebody made a threat. And folks are making threats now to remove children from classrooms without their parents. And we don't have to be too intellectual about it. We don't have to be too political about it. I'm going to ask you, if you're Christian, even if you're not Christian, to tap into compassion, tap into consideration.
What I'd like to
those things that make society better for all of us. Just because there's no evidence of it happening does not mean it will not happen.
What I'd like to tap in is compassion and justice for immigrants. And as we know, most impacted communities by illegal crime in illegal immigrant communities is immigrant communities, because we've heard that over and over in this committee, and we've passed bills to deal with that. And my point is, I think the gentleman from ICE, he made some pretty reasonable justifications for why they made those changes. And why they made those changes were not to expand ICE into churches or classrooms or courtrooms or any of these places that we're so fervently screaming about. But I think the public safety that they offer serves my communities, serves your communities, and serves immigrant communities. And I think public safety is important too. But I appreciate the exchange today.
I'm sorry. May I respond?
Actually, the bell is getting ready to go off in 57 seconds. You got 57 seconds.
Okay, I just wanted to say very quickly that I heard what I heard from ICE before. We did a Know Your Rights presentation through the Maryland Catholic Conference and the different archdioceses, and ICE was presenting there, and it had just been after the protected areas was rescinded, and they asked, what are you going to be doing enforcement in our schools and our churches? And ICE said, well, we couldn't before, but now we can. And so when you hear something like that, what do you expect to happen? Like, what do you expect for a society to feel?
And I'll reinforce today, that guy was the Maryland ICE guy. He said, we don't do churches, we don't do schools, we don't do these sensitive places unless we have pursuit in that area, which 99.9% of cases are not that. Well, if you have examples, please share them with the committee. We'd love to see it.
All right, I think Delegate Conaway, I'm sorry, I was getting it all wrong.
Panel for coming in. So for the sake of the Reverend, what he said, as I understand it, shit is the root of beresheth, which it means in a new beginning. But anyway, what about we upon the threshing floor, and the wheat shall be allowed to grow with the chaff until the day of the sickle? What about that? Thank you. Oh, whatever, so motive be whatever.
As it relates to the bill?
To his question.
Okay. Okay.
No answer, Reverend?
No answer.
Okay. Delegate Cardin.
Thank you, Madam Chair. In response to the colloquy between you and Delegate Grammer, first of all, thank you all very much for coming, and your testimony was wonderful, and the young lady in high school really, really was terrific, as well as the headmaster from the school, or the principal. Delegate Grammer asked you if any of these things were taking place, any of these ICE trying to come into schools or to libraries or to, and the young lady from the public defender said, or all of you said that not my church, not in the, as far as you know, not in the public defender's office, not in court, not in schools. But the fact of the matter is that there's nothing stopping them at this point from doing that. Is that correct?
Yes, that is correct. What ICE has instituted now is something that they're calling the common sense approach. And, we have seen that there is plenty of bias in this world. We all have our biases. Like, common sense is not the way to go with this. That's why when we even had we at least had the sensitive locations, we still thought it was insufficient because it wasn't taking into account all the chilling effects that they were having by just even being near sensitive locations, even if they weren't going into them.
So, and by the executive order, change the federal policy, as the delegate, the sponsor said, change the federal policy. And then the ICE gentleman who spoke earlier said, well, we're not changing our policy, but he now has the ability to. And so what this bill is going to do is going to limit what his ability is based on what we believe state policy should be. Is that fair to say?
It is, exactly. I think this is the way we're going to protect our essential services in Maryland.
Thank you.
And just as a follow-up question, the bill does not place any limitations. I thought the bill just asked for an attorney general opinion. Is that correct?
That is correct.
Okay. All righty. That concludes this particular panel. We're going to go now to everyone who's virtual. And Mr. Green, I appreciate your patience. You were here from the beginning of the first panel, but we had it already kind of laid out on how we were going to, how the sponsor wanted the witnesses to be called. So I'm going to call Mr. Green. I'm going to also call Elaine Wilson, Abby Sharofsky. I see you there. Is Elaine Wilson? Yep. Okay. Okay, great. And I guess that's probably, how many can I get on the screen? 4? Okay. So let's get Krish Omara Vinara. Not here? Okay. What about the mayor of Greenbelt? Okay. Let's call him. All right, so we're going to start with Mr. Green, and please stay muted until I call your name. Thank you so much.
Thank you so much. Again, my name is Jonathan Green. I'm from the Maryland State Bar Association Immigration Law Section. I want to point out that this bill is particularly timely, and maybe it's the most important bill that is being heard today, because the federal government has acted. The president has already rescinded the sensitive location guidelines. So the timing is right to ask the Attorney General to create guidelines for all of our state agencies to identify sensitive locations. And this is really important because we want to have a central source of guidelines. We do not want every state agency in every sensitive location simply adopting their own policies without this guidance. Having central guidance from the Attorney General is absolutely critical. And he's the chief law enforcement officer for the state of Maryland. So he's the right person to actually do this. So far, and again, we've heard, well, you know, nothing's happened yet, right? So it's not a big deal. So it's only been 33 days since the rescission of the policy. We've got 4 years to go. The president, in his actions, he doesn't just do stuff that he doesn't intend to act on. So we have every reason to believe that ICE and other federal agents are going to enter into sensitive locations for immigration enforcement. No one's talking about you stopping them from their other law enforcement capacities. This is just about immigration enforcement. And today, the reports are the governor of Virginia has indicated that law enforcement there will now become federal immigration enforcement officers as well. So Virginia law enforcement can cross state lines here in pursuit of people who are not criminals, who are merely undocumented with civil violations in order to seek this. There are reports across the country already of actions going on at schools, outside schools, and we are very worried about courthouse actions in terms of people being summoned and subpoenaed to testify and then being picked up by ICE. That would be a due process issue and litigation would ensue. Thank you.
Thank you, Mr. Green. Ms. Wilson?
Yes, thank you, and good evening, and thank you for allowing me to testify on this very important bill. I am the co-clerk of Friends Meeting of Washington, which is a Quaker meeting in Washington, D.C., which is a member of Baltimore Yearly Meeting, the umbrella organization of Quaker meetings in this region. While the meeting address is in DuPont Circle, Washington, D.C., I live in Silver Spring, Maryland, as do many members of my faith community. In my letter to the Washington Post published on Tuesday, February 5th, I declared my objection to the new presidential administration's policies on immigration as being at odds with the core ethics of the prophetic Jewish tradition and the teachings of Jesus. Friends meetings all over the state of Maryland regularly welcome anyone who chooses to come worship with us. We recognize that there is a divine light in each person. And so each life is sacred and worthy of our care. We are a community with no clergy. Every member present at a meeting for worship is in effect clergy to each other. There are several members of our meeting who are no longer comfortable coming to worship with us in light of the new presidential actions on immigration. This means that we as a community are deprived of the ministry that they offer us when they are present with us. I am in support of the House Bill Protecting Sensitive Locations Act. No one should hesitate to go to an emergency room, attend worship services, or go to school or college for fear of immigration enforcement. Schools, houses of worship, hospitals, and courthouses should be able to establish policies that limit immigration enforcement on their premises. We at Friends Meeting of Washington are developing such policies for our own building and will not allow ICE or other federal agents to enter the building for enforcement work. As a faith leader, I feel called to speak on behalf of those who cannot speak for themselves.
Thank you.
Our faith community, I urge a favorable report on House Bill 1006.
Thank you very much. Catherine Kinley, actually don't see Ms. Kinley. No, I see her on the screen, but I don't see her on the list. That's what I'm looking for. Let's go to Mayor Jordan, and then we'll work out what's going on with Ms. Kinley.
Hey, thank you very much. Good evening. My name is Emmett Jordan. I'm the mayor of the city of Greenbelt, and I'm speaking today in support of House Bill 1006, the Protecting Sensitive Locations Act. House Bill 1006 is crucial for safeguarding our community by managing immigration enforcement at sensitive locations such as schools, healthcare facilities, and places of worship. We ensure that all residents can access essential services without fear. This bill will enhance public safety by fostering trust between local communities and state agencies. When individuals feel safe accessing critical services, it strengthens the overall health and well-being of our community. In Greenbelt, in our municipality, we've seen firsthand how fear can deter residents from seeking essential services. Well, for example, we've noticed our multilingual storytime reading program in one of our recreation centers had seen a recent drop in attendance. So this bill will help ensure that our local schools, healthcare providers, and social services can fulfill their missions without interruption. The legislation, it does align with my city's values as a respectful, welcoming community that's open, accessible, safe, and fair. So the emergency status of the bill underscores the immediate need for swift enactment to provide timely protection for vulnerable populations and guidance for state agencies. House Bill 1006 strikes a careful balance between the need to preserve the integrity of our public institutions and immigration enforcement. It allows for the development of guidelines that are consistent with both federal and state laws. So we strongly urge the committee to support House Bill 1006. This legislation is a critical step towards building a more supportive and safe community for all residents of Maryland. Thank you very much.
Thank you. Ms. Kendi, please.
Greetings, Chair and members of the committee. My name is Catherine Kindy. I'm a social work student at the University of Maryland, Baltimore, and I'm currently interning at a community-based health center that offers medical and behavioral health care to low-income, underinsured, and uninsured people. To protect the clients and the agency I work with, I, Catherine Kindy, testify in support of House Bill 1006. Studies have shown that increased ICE activity near sensitive locations correlates with decreased healthcare utilization among undocumented and documented immigrants. In one study, patients with tuberculosis delayed seeking care due to the fear of immigration enforcement, compromising individual and public health. At a free medical clinic in Chicago, nearly 30% of patients didn't show up or canceled their appointments within the first 2 weeks of the current Trump administration. Immigrants across the country are delaying necessary life-saving medical care out of fear. As a social work intern in Maryland, I'm witnessing this firsthand. Whether or not ICE is actually making arrests at these sensitive locations, the possibility alone is frightening enough for immigrants to avoid social services necessary for their livelihood and to compromise individual and public health. House Bill 1006 would increase trust in Maryland's undocumented and documented immigrants, leading to improved access to health care and a healthier Maryland overall. It is vital that the Maryland General Assembly limits immigration enforcement at sensitive locations to protect all Maryland residents and prioritize health and well-being. I urge a favorable report of House Bill 1006. Thank you.
Thank you. Abby Sharofsky.
Good evening, members of the Judiciary Committee. I am Rabbi Abby Sharofsky, Director of Intergroup Relations and Rabbi in Residence for the Jewish Community Relations Council of Greater Washington, the JCRC. The JCRC serves as the public affairs and community relations arm of the Jewish community, representing over 100 Jewish agencies, synagogues, and schools throughout the region. The JCRC is strongly committed to cultivating a society based on justice, mutual respect, equity, and safety. I am testifying today in support of House Bill 1006, the Protecting Sensitive Locations Act, which requires the Attorney General to establish guidelines for immigration enforcement, including the protection of houses of worship from immigration raids. This Shabbat, this Saturday, Jews throughout the world will read from the book of Exodus and hear this verse from chapter 25. Ve'asu li mikdash v'shachanti b'tocham. And let them make me a sanctuary that I may dwell among them. We are commanded to build a sanctuary, a holy space dedicated for worship and being in God's presence. The word sanctuary holds so much meaning for so many, but first and foremost, it is about being in a holy space. This holy space cannot be one of fear or intimidation. The sanctuaries in our communities, the synagogues, churches, mosques, temples, gurdwaras, are holy and cannot be used against the people who seek to go there and fulfill their religious obligations. True religious liberty is ensuring that all people are able to worship safely and peacefully without fear of intrusion, upholding the dignity and sanctity of holy spaces. Delegates, I urge a favorable report on this bill, ensuring that our sacred spaces continue to be revered and treated with the sanctity they deserve. Thank you.
Thank you. Are there any questions? Delegate Conaway.
Thank you, Chair. Thank you, witnesses, for coming in to testify. To the person that spoke about Jesus, what about Matthew 22:21? Render therefore unto Caesar the things which are Caesar's, and unto God, which will be Jehovah Elohim, the things that are God's, Jehovah Elohim. What about that?
I would say that I'm not certain I know what to say about that.
I'm sure, I understand. Let every man carry his own cross. Have a good day.
Okay, thank you very much. That concludes the questions for this particular panel. Thank you all for signing up to testify virtually. Now we're going to move back to in-person. We have Aaron Camp. I'm just going to go down the list now. Aaron Camp Mansour, Robert Nunez, Lila Stevenson, Rena Shaw, Sophia Baralone, and I think that's everyone. Let's make sure we've got everybody. So could you tell me your name again?
Aaron Mansour.
Aaron, okay, and Rena Shaw, Robert Nunez, Bob Nunez, Robbie Nunez, nobody? Okay. And Elijah Stevenson, or Lila Stevenson? No? Ma'am, could you give me your name?
Sophia Baralone.
Okay, all right, well, great. Let's start here and we'll just work our way down. Thank you so much.
Thank you. Good afternoon, members of the committee. Again, better? Okay. Good afternoon, members of the committee. Again, my name is Aaron Camp Mansour, and I am a member of Patapsco Friends Meeting and a faith-based advocacy group called Quaker Voice of Maryland. Quakers across Maryland have shared with us the deep concern they have for immigrant protections. We see HB 1006 as an urgent priority in response to the recent rollback of the federal policy of protecting sensitive locations like places of worship from immigration enforcement actions. Testimonies are what Quakers call the ways we have found to live and act based on our beliefs. We embrace the knowledge that all persons are children of the divine and brothers and sisters of one another. Our spiritual and social testimonies, including those of peace, community, integrity, and equality, lead us to submit this testimony supporting HB 1006. In addition, a coalition of Quaker meetings recently filed suit in Maryland federal court to block the change in federal policy. On February 24th, the U.S. District Court of Maryland issued an order blocking the Trump administration's policy that enables immigration officials to enter houses of worship indiscriminately. However, the order, which outlines the ways in which the Trump administration policy is likely to violate religious freedom and expression rights, applies only to the plaintiff's houses of worship. And none of these protections include schools, healthcare facilities, or state agencies. We need additional protections for all the sensitive locations previously covered by the Biden administration's executive order. The Attorney General needs to issue guidance limiting immigration enforcement access to these essential spaces. State agencies must develop clear policies to enforce and communicate this guidance. No one should be afraid to go to school, seek medical attention, or practice their faith because they lack immigration documentation. We urge you to issue a favorable report for HB 1006.
Good evening, Vice Chair Bartlett and members of the committee. I am Reena Shah, the Executive Director of the Maryland Access to Justice Commission. We support HB 1006 and request a favorable report. We strongly agree that a courthouse should be designated as a sensitive location and that ICE arrests should not be permitted in and around courthouses. The courthouse is a place where the law is interpreted, applied, and justice is meted out. Access to the courthouse and therefore access to justice, safety for crime victims, and equal protection under the law must be preserved. We know that judge and attorney safety and security has been something this committee has addressed recently due to the death of Judge Wilkinson. In the same vein, we must ensure that people using courts, the litigants, perceive courts as safe, neutral, and accessible. Here's some data. In 2019, my organization published a report that documented over 70 ICE arrests that happened inside courtrooms, hallways, parking lots, often in public view, which undermine the perception of courts as places of safety and justice. At that time, because of these ICE arrests in state courts, people did not pursue legal remedies, with almost 500 survivors of domestic violence and sexual assault who did not seek protection, and witnesses avoided testifying, opposing attorneys threatened to call ICE as a tactic, and detained individuals missed court appearances, resulting in bench warrants. We have seen this in the past and expect it to escalate now that federal protections have been removed. ICE arrests in state courts erode the very foundation of access to justice. They impede equal protection under law. They undermine fair and efficient administration of justice. They affect the safety of litigants, and they impact public trust in the impartiality of the justice system and the existence of the rule of law. For the reasons stated, we don't find this to be anywhere controversial. It is simply guidance, and we strongly urge a favorable report.
Thank you. Good evening, Chair and members of the committee. My name is Sophia Baraloni. I'm a Deputy Director for Victims' Rights at Maryland Legal Aid, and we support this bill wholeheartedly. This bill is essential to ensuring that survivors of violence and other vulnerable individuals can seek help without fear of deportation and retaliation. Our legal advocates represent immigrant survivors of domestic violence in a lot of civil cases throughout the state of Maryland. Currently, however, the fear of immigration enforcement deters many from accessing resources like domestic violence shelters as well as going to court. Just this month, we represented a victim of domestic violence in a protective order, and she was brutally assaulted by her abuser. And after that, she went and filed for a protective order. After she filed for a protective order, he went to the commissioner's office and filed a frivolous and retaliatory criminal case against her, and then informed her that if she went to court on that that protective order, he was going to have ICE go there and pick her up. He was going to inform ICE and have her go there. And so the threats of immigration enforcement at sensitive locations to immigrant survivors pushes them further in the shadows. That client decided not to go to court, and she did not pursue a protective order and get that extra level of protection from the state. Committee members, all residents of Maryland, including immigrants, deserve the right to go and access unrestricted access to essential community services, including medical care, schools, courthouses, domestic violence shelters, victim service programs, and places of worship without the additional fear of immigration consequences. This bill would uphold those fundamental protections. This bill will quell those fears that are going on right now in our immigrant community. And so for those reasons, we ask that we urge your favorable report to quell those fears in our community. Thank you.
Thank you. Are there any questions for this panel? Seeing none, thank you all very much for coming in to testify. That concludes the hearing on House Bill 1006. We're going to move now to Delegate Rosenberg. House Bill 868. And Delegate Rosenberg, let's see here. I'm going to call up a few folks. Yeah, you just bring up who we want. I have Sandra Johnson, Jennifer Johnson. Lanice Stevenson?
Yes.
Yvette Langford? Irene Henderson? John Morris? Could you nod, wave, or blink if I'm, okay, good. Okay, thank you. That's good. All right, I'm gonna call one more person. We're gonna call, well, we'll wait on those two. Okay, so tell me who I have. Who's present? I see Mr. Morris. Who else do I have?
Sharon Jones Eversley.
Oh, I didn't call your name, but thank you. Okay.
Jennifer Johnson.
Jennifer Johnson.
Lanice Stevenson.
Okay, great. Delegate, whenever you're ready.
Thank you. The core principle of trust in estates is that the will is to be carried out in accordance with the intent, the wishes, the desires of the decedent, provided with the only exception, from my understanding, being if what is proposed is contrary to state law. Because the Supreme Court threw out a will that said that the money would be used for a segregated swimming pool in a southern town. That is certainly not the case in the will that brings us here, that prompts this legislation here today. Because the purpose of the bequest was to deal with the health disparities in Maryland society, in our society. Not only this is part of the public policy of the state as reflected in the code. And the bill before us is called Granny's Law because it was Miss Johnson, the will of Miss Johnson's grandmother that was not carried out consistent with what the family wanted because of the interpretation of the will by the Orphans Court. So we're here today to try and correct that mistake for future families who wish to have a bequest go to address the problem of health disparities in the state, and also to go to the language should deal with other instances when the family has a specific request for the bequest to ensure that it is carried out by the court. So I would urge a favorable report.
Thank you, Delegate. And I'm going to ask Mr. Morris to start. I'm going to go down the row. Thank you so much.
Okay. I'm John Morris. I'm, I guess, an advocate supporter. The aim of this bill, as the Delegate Rosenberg has indicated, is to make sure that the law gets right the thing this whole structure of courts and legal premises is created to do, to effectuate the intention of the decedent. And in a case where, let's say, the state has articulated what public policy is, the decedent's will may proceed on the assumption that a bequest to a health provider will be compatible with the public policy. And while certainly the public policy is aspirational, the reality in many instances is that many of the healthcare providers don't proceed compatible with the public policy, and the disparities persist. And you'll hear from other people today as to how those disparities do persist. And I think it's useful to think about this kind of disparity as the price other people pay for institutional comfort with the way they go about doing things. And because those within the circle of familiarity and convenience are taken care of, nobody spends a lot of time paying attention to what happens to those who are unlike those who frame those policies, who are different. And I think in many ways, it's this kind of, I mean, there are many biases, but it's this bias that frames this bias in favor of familiarity and convenience. The aim here is to make sure that that familiarity and convenience doesn't apply to the law, and we go the additional step to get the evidence of the decedent's intent right.
Thank you. Ma'am.
Hello, good evening. I'm Dr. Sharon Duncan Jones Eversley, and thank you for the opportunity to have a favorable endorsement of House Bill 868. I am a professor emeritus and a social epidemiologist in the Family Science Department at Towson University. However, my testimony does not represent Towson University, but rather it reflects my over 40 years in human services and public health. In the early 2000s, under the leadership of Dr. Carlicia Hussein with the Maryland Department of Health, I conducted research in analytical data and published 4 reports for the state to guide them in their elimination of health disparities. And while Granny's Law addresses the interpretation of wills, it has significant implications. We are facing the nation's largest transfer of wealth, an estimated $125 trillion from older generations to their intended beneficiaries. Granny's Law safeguards Maryland aging residents' probate intentions, and it also complements Maryland's longevity ready initiatives. Because the Maryland Code mandates eliminating health disparities, Granny Law also has implications for Marylanders that are 60 years of age or older. Sadly, Marylanders, particularly Black Marylanders, are dying sicker and younger from heart disease, cancer, stroke, diabetes than any of their other aging counterparts. Their low life expectancy at 72, their high poverty rates are very concerning. And yes, Maryland has made progress in addressing social determinants of health, but we have to elevate it to address social determinants of death. Let's pass this law so we can give the justice and dignity for Marylanders to make sure that their intents of their deceased loved ones are upheld. Thank you.
Thank you. Next.
Good evening, Committee Chairwoman
and committee members. My name is Jennifer Johnson, and I ask for your full committee's favorable support for House Bill 0868, Granny's Law. What happened to me was a direct violation of my grandmother's written will and of my human rights. I have never been through anything so horrific in my entire life, and Granny's Law seeks to make sure this never happens to anyone else again in our state. My grandmother was leaving a large charitable donation to 4 major health-related charities with the goal of positively impacting African-American lives, as we are disproportionately affected by health disparities. While all of these organizations document that African Americans are disproportionately affected by all of these disease states, a Baltimore County judge thought she knew better than me, knew better than my grandmother, and in fact stated she did not care what Maryland state policy was. The judge forced me into jail when my best friend was dying of cancer and allowed 2 attorneys she preferred to bill almost double all of your annual salaries. Almost double. As members of the House of Delegates, for work I completed, the judge's order forced me to give over all my grandmother's information to these lawyers, or I could not get out of jail, something that should have cost me around $3,000 max in a matter of weeks to complete had the courts never been involved. This bill will correct historical wrongs of health-related charities not supporting Maryland state policy to work towards eradicating health disparities, historical wrongs of the Orphans Court ignoring people's wills and allowing lawyers to make large profits off deceased people's estates, historical wrongs of the Orphans Court overriding the decedent's families and trusted personal representatives, historical wrongs imposed on caregivers who are dying 30 to 40% of the time taking care of other people, and this bill will help honor my granny and anyone else's loved one and whose will and estate is being grossly misinterpreted by the Orphans Courts in Maryland. I ask for your full committee's favorable support for House Bill 0868, Estates and Trust, Interpretation of Wills, Evidence of Intent, Granny's Law. Thank you.
Thank you for your testimony. Next. Yep.
Good afternoon, Chair, Vice Chair, and esteemed members of the committee. My name is Dr. Lenise Stevenson, and I'm here today in strong support of House Bill 0868, legislation that ensures bequests intended to address health equity are used as the donor envisioned. I come before you not only as a complimentary healthcare provider and researcher, but also as someone whose life has been profoundly shaped by cancer. I am a survivor of thyroid cancer, and I carry with me the struggles, the stories, and legacies of my grandmother, my mother, my aunt, my cousins, and close lifelong friends, all of whom lost their battles with breast cancer. Cancer is not just a diagnosis, it is a generational burden that too often weighs heaviest on marginalized communities. House Bill 0868 is a necessary safeguard to ensure that the resources meant to fight health disparities are not diverted away from their intended purpose. Too often, funding designated to advance health equity is lost in bureaucratic redirection, leaving patients, survivors, and families without the support they desperately need. For families like mine and so many others in communities disproportionately impacted by cancer, these funds could mean access to critical screenings, life-saving treatments, culturally competent care, and survivorship programs. When my mother was diagnosed with breast cancer, she fought to access the best care. Yet she faced systemic barriers that made an already difficult battle even harder. She, like many other people of color, desperately need equitable treatment and resources that would have given her a better fighting chance. Health equity is not a luxury, it is a right. House Bill 0868 honors the intent of those who bequest funds for this purpose, ensuring that their legacy is not diluted or misused, but instead fulfills its highest potential, which is to save lives. Thank you.
Thank you. Thank you for your testimony. And I see questions. I'll start with Delegate Phillips and then Delegate Simmons.
Madam Chair, thank you very much. This seems very specific to a very specific set of facts. And so I just need to understand it so I'm clear. There was an interpretation, well, there was a will, and that will contained a bequeath to health equity related charities. Is that correct?
It contained a bequest to charities. The intention behind that request was that it be for health equity.
Okay, but it was not clear. So it was left to the interpretation of the personal representative.
How to deal with that.
How to deal with that.
Yes.
Okay. And then the personal representative indicated how they wanted to deal with it.
Yeah.
And the judge questioned that.
That's correct.
Interesting.
The aim here is simply to find a vehicle by which the court is justified in looking at how we dispose of these funds. So what you had that Ms. Johnson didn't say was her grandmother spent a lifetime working to eradicate disparity in various places. In fact, she was instrumental in helping to desegregate the Naval Academy. So you have somebody who spent a lifetime working for equity, who has the courts interpret their will to apply the fruit of their life's work to perpetuate inequity. So this is a bill essentially to not allow the law to make a mockery of somebody's life.
And I'm just trying to figure out why the court made a determination that the bequeath should go to something other than what the personal representative interpreted.
Sir, you would have to ask the judge that. It's nothing makes sense about the entire situation to me. And what in fact you don't hear is the fact that there was a clause specific in my grandmother's will that is specific in many people's wills that specifically says her power of attorney does not sit under the adjudication order or direction of the courts and can do any and all things just as fully if she were alive. The judge said I was to ignore that. It did not mean what I thought it meant. And if I didn't follow her orders, she was going to throw me in jail. Well, her orders were to give over all of my grandmother's information and allow her to seize my grandmother's money. And she allowed two attorneys she preferred to bill almost $100,000 against my grandmother's estate for something that would have cost me $3,000. I have an MBA from one of the best business schools in this country. And there was no reason for this to have happened.
Okay. All right. I'm sorry, Madam Chair. This is just disturbing.
Yeah.
Very disturbing.
But again, sometimes the law has its own inertia that doesn't necessarily lead toward justice. And this is a way of trying to correct that.
I'm concerned, and I have just to say this, I'm concerned that we're now legislating around a particular set of facts. And that's the only thing that concerns me. My question is this a matter of facts, or is this a matter of kind of an inappropriate or interpretation that maybe then should have been handled by going to the circuit court?
It's both. And it went up to, John, correct me if I'm wrong, circuit?
Yeah, there was an appeal.
There was an appeal. We had 8 expert witnesses testify to the disproportionate needs for African Americans in the areas of cardiovascular health, Alzheimer's, cancer, and mental illness. And the judge yelled at the people who were trying to cause additional harm to me and basically said, you absolutely cannot charge her. She was the caregiver. Charge me for what is still the question, because all I was doing was, in fact, executing my grandmother's will. The language is in my grandmother's will. And I was told repeatedly to ignore it, and I refused because that was the thing that allowed my grandmother's intentions to be made whole.
And once again, so it did go to circuit court?
Yep.
And the ruling in circuit court?
That I was not fit to serve as my grandmother's personal representative.
That's different, but that's different than kind of the fact.
This was the issue of what the intent of the decedent was not addressed. So this legislation opens up that question and provides a process for doing it.
But this is not isolated. This is a trend. And it should never have happened. My grandmother should have been honored for what she was giving to these charities. Instead, it was total disgrace.
Thank you.
Thank you. Delegate Conaway.
Chair, and thank you, delegate and witnesses, for coming in to testify. To the person that was just speaking, that language that you used that was in the will, where did you get that language from?
It's straight from the will, and it's in many people's wills.
No, I was asking, well, see, I'm familiar with sometimes certain groups like Moorish American use different languages. So is this standard American legal language?
As far as I know, yes.
They didn't challenge that language?
No. Well, I guess you can say they challenged it because they said basically it is to be disregarded. But understand this. No, my grandmother was not Moorish science. She was Episcopalian.
Okay.
And this language, I have been told by many lawyers, is in most people's wills.
Okay. All right. Thank you very much.
Thank you. Okay, that concludes the testimony for this panel. We're going to move now to our next set of witnesses. I'm going to call Sandra Johnson again, Yvette Langford, Irene Henderson, Paul Langford, Eleanor Thompson. Let's go ahead and bring up virtual too, Toy Nelson and Shani Babius. Okay, thank you. Okay, you'll each have 2 minutes, and if you would state your name, please, because I was looking down as you were coming up. Thank you.
You want to start here? Good evening. My name is Sandra Johnson, and I am speaking today in support of, are we having a problem?
Yep, could you, there you, and it'll bend, if you want to bend it down to you, that'd be perfect. There you go. Thank you.
Yes, as I was saying, I'm speaking today in support of House Bill 0868, Granny's Law. I'm Jennifer Johnson's mother, and I lost my husband, Jennifer's beloved father, to a heart attack several years ago. I have also lost many friends and family members to Alzheimer's, cancer, and cardiovascular diseases. Additionally, I spent a good part of my career working for the state of Maryland and the Department of Juvenile Justice, so I've seen firsthand some of the mental illness that is affecting the African American community. I'm proud of my daughter for taking a stand and trying to honor her grandmother's wishes. However, I was horrified at how the court handled my daughter, and I did everything in my power to quickly get her out of the situation that should never have happened. It goes without saying that my daughter has never been in trouble with the law in her life. As the mother of Jennifer, who was incarcerated per the judge's orders in September of 2022, while Jennifer's best friend, Kim, was dying of cancer, I spent several days searching my daughter's home, trying to piece together information to satisfy the judge's court order. I also visited the bank where my mother-in-law kept her accounts, but to no avail, as the bank would not provide any information due to privacy laws. Jennifer's lawyer asked me to search every possible source to locate any and all financial information available to provide to him to satisfy the court's orders. In my search for the required information, I probably didn't find everything, but I did follow the court order and tried to find any and all information. When I was searching for said information, I was sad and feeling depressed and extremely concerned about my daughter's welfare. Jennifer had never been in trouble before, never been in court before, never been incarcerated before. This was a horrible situation, and I did my best to get her freed, and in a certain amount of time, because I didn't want there to be any lasting impact.
Thank you. Ma'am.
Yvette Langford.
Thank you. Can you pull the mic over to you? Thank you so much.
Thank you for having me here, Chair, Vice Chair, and members. In January of 2024, my one and only child, Patrice, was diagnosed with cancer. On May the 22nd, 2024, I woke up to the horror of losing my one and only child. My baby girl was only 43 years old and passed in her sleep. Jennifer Johnson and my daughter have been friends since high school. Both graduated from one of the only girls' school in the country, Western High School for girls. Patrice passed away at 43. It's not the way things were planned. She left behind my precious grandson. We lost Patrice's grandmother at the age of 53 to the same cancer. However, with technological advances, early screening, etc., we did not expect to lose Patrice, especially not so soon. In fact, what happened to my child is the exact opposite of what any of us had ever hoped or imagined. I would never, ever have imagined that I would have to bury my only child. It is not the nature of things of life. I am still grieving and trying to put the pieces of my life back together and try to create a new normal for my grandson. Bill 0868, Granny Law, should be passed into law. And Jennifer's grandmother, my child, and all those caregivers and those suffering with health disparities should be honored, and more targeted programs should be provided, especially to our youth, to hopefully prevent death in the future generations in our communities. I ask the Judiciary Committee be anonymously favorable, support estate and trust interpretation of wills, evidence of intent, Granny's Law, honor Jennifer's grandmother, my daughter, and all the other caregivers who love one affected by this health disparities.
Thank you, ma'am. I appreciate your testimony, ma'am.
Dear Judiciary Committee Chair, Vice Chair, and members, my name is Irene Sims Henderson, and I was married to my beloved husband, Dr. Roland Henderson, for 56 years and 4 months. He had cancer 3 times, and the 4th time he got cancer, unfortunately, he lost his battle. He was treated at Memorial Sloan Kettering Cancer Center for 21 years. My grandfather was a cancer survivor, but lost his battle. And then my mother had cancer along with each of her 4 brothers. All but one passed from cancer. And the last sibling who survived cancer passed from a heart attack. My only sibling, my brother, has been living with cancer for well over 5 years. I too had cancer, but thankfully it was a mild case. When I hear about the startling statistics for African Americans and cancer, I don't need to see the numbers. And I have unfortunately experienced this personally right in my own family. I knew Jennifer's grandmother, and I know what happened to her estate and to Jennifer is not anything that she would have ever wanted. The court's treatment of Jennifer was beyond disturbing. My mother was a minister, and as many say, but God. I thank God for protecting and keeping Jennifer in spite of the horrid court system. I support Granny's Law, HB 0868, and I highly suggest the Judiciary Committee do the same. Thank you.
Honorable Chairperson, Vice Chair, and esteemed members of the committee, thank you for the opportunity to speak before you today in strong support of HB 0868, aimed at securing more funding to address the devastating health disparities and disproportionate impact of African Americans and other minority communities. This issue is not abstract to me, it is deeply personal. My name is Dr. Paula Langford, and I come before you as a dedicated social worker, neuroscientist, working with and in communities of African American and minorities. I stand before you not just as an advocate, but as a witness of the unrelenting loss and suffering caused by systematic healthcare inequities in the Black community. My maternal grandparents, my niece, my brother, a proud United States Army veteran, lost their lives due to cancer. And on April the 11th, 2024, after fighting ovarian cancer, breast cancer, my beloved mother untimely succumbed to lung cancer, leaving me the only living child. Health disparities do not only affect individuals, they tear families apart, leaving behind vulnerable children, often ending up in child welfare systems. My soror Jennifer's grandmother dedicated years working in the juvenile justice and foster care systems and directly witnessed how children in foster care are often there because their parents could not access adequate healthcare systems. I urge you to vote in favor of Granny's bill. This is not only necessary, it is imperative. Thank you.
Shanae Fabius, please, for 2 minutes.
Good evening, committee members, Thank you for the opportunity to testify today in support of Granny's Law, or House Bill 0868. My name is Cheney Fabius. I'm an assistant professor in the Department of Health Policy and Management at the Johns Hopkins Bloomberg School of Public Health. I'm a gerontologist and health services researcher with expertise in racial and socioeconomic disparities and long-term services and supports for older adults, their family caregivers, and the direct care workers that help them. I have professional and personal experiences in family caregiving. In 2021, there were about 760,000 family caregivers from diverse groups in Maryland whose unpaid care was valued at $12.5 billion. These estimates will likely increase as the older adult population diversifies and grows in size, a trend that has been well documented both across the country as well as globally. The proposed bill, Granny's Law, directly addresses disparities that impact caregivers from low-income backgrounds, women, and minoritized communities. And I would like to highlight 4 points that are relevant to the proposed bill. First, my own work has demonstrated that Black family caregivers often provide over 40 hours of care per week to older adults with significant needs and limited financial resources and experience financial difficulties related to caregiving themselves. Second, caregivers from marginalized communities often spend a higher percentage of their income on caregiving experiences. Third, many caregivers from minoritized groups have less inherited wealth to support caregiving costs, leading to increased financial instability. Fourth, and finally, family caregivers from minoritized groups face legal barriers in managing their loved ones' estates, particularly if they lack access to legal resources or face discrimination in legal systems. Family caregivers are the backbone of the long-term care and medical systems, and enabling them to have a recognized role in interpreting their loved ones' wills empower them and ultimately reduce the disparities that they and others are impacted by. Thank you for your time and your consideration.
Thank you very much. Questions for this panel? You've all spoken, I think, at this point. Or no, you have not spoken? Yes, okay. Delegate Simmons.
Thank you, Mr. Chair, and thank the panel. You know, it's very hard as you grow older, and especially in our communities, to look and see for advocacy, whether that's family members or agencies. Ms. Johnson, you was talking a little bit earlier on your testimony, and you left off by saying lasting impact. Can you tell me what was the rest of that you were saying on your statement?
No, I don't know whether it was obvious, but Jennifer actually had to go to prison because of this. And so my only thing was that, you know, I was sorry that happened, but, you know, it's just the penal system just doesn't work.
Sure. Can you also, can anyone on the panel talk to me about wills and trusts? And is that something, how do you get to that stage? Is somebody approach you about wills and trusts? How's it explained to you, and at what point of your life is that presented to you?
I would have to say that in the African-American community, it is oftentimes what I'm learning is that is addressed later on. most times a lot of families don't even address that. I do have a sister who is working on making sure that a lot of families know about how to address what is happening long before we get to a point where our family members are either at that last stage, that final stage, or they have passed on. Making sure that they know where things are, know where documents are. She has created a business where those documents are placed and people know what to do so that they are not in a position where people are taking advantage of them, particularly when we have attorneys who are using legal ease to take advantage of people who don't know what these things mean. And they don't take the opportunity to explain, particularly to people who don't have the education or the understanding of what does this mean if I sign this document. And it is only later on that they find out that they have paid way over what their white counterparts have paid. Or they have signed over things that they did not even know that their families really have, that are valuable to those families later on. So what is now happening, particularly I can say in Baltimore, we're having those kinds of conversations. As a social worker and a clinician, I'm having those conversations in larger organizations so that Black people know, and I'm being specific, Black people know where their money is going. We will not have the same thing happen when you promise 40 acres and a mule and then you turn around and take it back.
Delegate Sample Hughes.
Thank you, Mr. Chair, and thank you, panel, for being here. I do appreciate that. I want to say, give my condolences to each of you and your family members, and then also thank you for the work that you're doing to educate us. My question is, and it probably should have been for the previous panel, but has there been any work that you may be aware of that the Orphans Court Association may have had training for language and working with persons so we don't have this challenge again?
I was just at the Orphans Court maybe 3 months ago addressing my father's estate. I am not aware of any of it.
I can tell you in Baltimore County, there is now the first African-American female Orphans Court judge. She just took the bench probably within the last 6 months.
Okay, thank you. I was curious if that would be a path to start educating members of the Orphans Court. And because I have seen disparities, in particularly in Dorchester County. Now they have their first Black, he served on the bench for a while, but now he's, the head judge. But that was challenging even to get that, so I understand that. My next question is, are you aware of our Commission on Health Equity? It's through if you remember, Senator Shirley Nathan Pulliam from Baltimore. Mm-hmm. And that, I'm thinking that might be a path as well to begin dealing with the health disparities and the education that's not happening as rapid as it should be. Anybody familiar with that, or maybe think that could be a path?
I'm aware of various different champion agencies, if you want to call them that, that are dealing in health equity matters. But right now, this has to be settled and this needs to be corrected before I can give anything else. I've given too much. Me going to jail, I've never been in trouble a day in my life. And that happening when my best friend was dying of cancer, me having to beg a judge not to throw me in because my best friend had just been placed on hospice, not okay. I've lost, since that time, Patrice and another girlfriend from cancer, all under the age of 45 years old. So this is something that has to be corrected because we are dying, and we are dying disproportionately, and we are dying much younger.
Oh, I agree. I'm with you wholeheartedly. But I also understand state government, that all the people are at, all these agencies are at the table. And with this commission, there can be a path forward to educate these other entities, all these agencies, and make some action happen. I feel that is one path. The second path is to right the wrong here, and we've got to educate those orphan court judges so we're not in this situation again. So that's where I'm just really coming from, and I know your bill sponsors here is really kind of directed to what we can do there, but I wanted to, of course, had to ask it in the form of a question as well, because that's what we're required to do here.
Thank you.
So I'm struggling, but I want you to understand that there may be some paths, but certainly, you know, this legislation is one of them. But just wanted to put it out there.
Thank you. Just to further answer your question, this was blatant. This was intentional. All of these charities knew that and are well documenting that African Americans are disproportionately affected in the areas of cardiovascular health, mental illness, cancer, and Alzheimer's, and they did not care.
My one last question for you, and I'm finishing, Mr. Chair. So the monies that you had to pay for all these lawyers, I saw the fees was like up to like almost $400 an hour. So that took away from all of your grandmother's estate?
Yes.
And it depleted it how much?
By almost $100,000 for something that would have been $3,000 if I was able to finish what I started. When they did this, we were at what you call the third accounting. There was only one accounting left to go. My first lawyer that I had billed me $25,000. He gave me all that money back because he knew that I had done all the work. And then these court-appointed attorneys billed almost $100,000 against my grandmother's estate for work I did that I had to hand over to them, else I could not get out of jail.
And the judge is the one that appoints those?
Yes,
Okay.
and the judge was also the one who made the order.
Okay, I got it. Thank you so much.
Delegate Conaway.
Thank you, Chair. Thank you, panel, for coming in to testify. I have to be a little delicate here. I'm in the area that I'm not familiar with too much. But in each of these cases, was their will prepared before the person became ill?
Yes.
Was the will registered with the register of wills before they became ill?
No, and typically a lot of people don't do that until it is actually time to probate.
Well, maybe you should tell the people that that's what they need to do. You can call the register of wills office and get information about it, but I can't go further into that.
I can go further into that. Yes. That would not have made a difference at all.
Because?
Because they violated the will. So what was in writing is what they violated. So whether it had been registered with them or not, they violated it.
Well, I don't know. That's not my area, but I offered what I could. Thank you very much.
Seeing no further questions for this panel, thank you all very much. I just want to make sure, I think I saw Toye Nelson, who was on there. Okay, so we'll hear from her in a moment. And just making sure, Eleanor Thompson was part of that last group, I think. Eleanor Thompson? All right, we're going to hear from Toye Nelson, and then we'll hear from those three in opposition. So please go ahead.
Good evening. Are you able to hear me?
Yes, go ahead for 2 minutes.
Good evening, Chair, Vice Chair, and members of the committee. My name is Toye Nelson. From 2008 to 2009, I was living with chronic pain. I was seeing a physician for months with no clear answers. After being told by this physician that I was seeing that I was psychosomatic, I was given Cymbalta, a drug often just prescribed to people with depression, with instructions to increase my dosage from 30 milligrams to 60 milligrams if needed. I was hopeless at that point and began believing that I indeed was not experiencing the pain. In May of 2009, I began seeing a new physician. Within a few weeks, I was diagnosed with stage 3B Hodgkin's lymphoma. The cancer was sized as the size of a baseball. I was 33 at the time and my own best advocate. However, I think of my maternal grandmother, my maternal grandfather, and the two cousins I have lost to cancer. I think of the cousin who was diagnosed with the same form of cancer that I had at the same time in the same year, but he did not survive. Here I am 16 years later, and I'm in the fight to advocate for my parents who are experiencing cognitive decline. Monthly, I'm trying to coordinate their medical care, and I often struggle to get a return phone call from physicians to establish a clear pathway to support their care. According to NIH, for racial and ethnic minorities in the United States, health disparities take on many forms, including higher rates of chronic disease and premature death. Given what I have endured and what I witnessed of Jennifer as she cared for and made decisions on her grandmother's behest and behalf, and based on what I'm experiencing now with my own parents, I am in full support of HB 0868, Estates and Trust Interpretation of Wills, Evidence of Intent, Granny's Law. Thank you so much.
Thank you very much. Are there questions? Seeing none, thank you very much. That concludes the people in favor of the legislation, and we'll hear now from those who are opposed. I think they're they're taking the table right now, so just to get there. Michelle Mankulik, Alexis Burrell Road, Laura Thomas. Whoever would like to go first. Start on my right.
Hi, good evening, Chair Clippinger and Vice Chair Bartlett. I am Alexis Burrell Rohde. I am the Register of Wills for Baltimore County, and I'm also the president of the Register of Wills Association, and I am here on behalf of the Register of Wills Association. And I have to tell you, after hearing the testimony in favor of this law, I really am sad that I have to be here against in opposition of this legislation, because it's really clear to me that a lot of heartbreak happened with under the facts of this particular case. And health disparities are real. There are racial health disparities, and we really do as a state need to work to eradicate them. Also, and what is evident from the testimony in favor of this legislation, there's a lot of disparities in access to quality legal resources for people when they're drafting wills, particularly in traditionally disadvantaged communities. And I have spent a lot of time since I've been in office doing a tremendous amount of outreach to all kinds of community groups to try to get the word out about the importance of estate planning and making sure your will is clear. The problem with this case, and I'm very familiar with it because it was a case pending in Baltimore County, was that the will was poorly drafted. It was not clear that the money was to be used to to address health disparities. Instead, the gifts were made to charitable organizations without a specific designation that they be used to address health disparities. So if that had been done, this wouldn't have been an issue if the money had been left in trust that gave a trustee authority to make distributions as he or she saw fit. This wouldn't have happened. So I urge, unfortunately, an unfavorable report for the Granny's Law 828. My colleagues will address some more substantive issues with it.
My name is Laura Thomas, and I'm here on behalf of the Estate and Trust Law section of the Maryland State Bar Association in opposition to House Bill 868. As Alexis said, and health disparities are real and they need to be addressed in the state. Unfortunately, we do not believe that this bill is the way to address those health disparities. First, Maryland law has long allowed people who create a will to specify exactly what their bequests can be used for, especially those bequests to charities. They're called restricted gifts. If a restricted gift is placed in a will, I give $5,000 to a charity to support cancer treatments and research, for example. The charity does have to follow that restriction on that bequest. And so we have a way under Maryland law to address and to specify how a charitable bequest is to be used by the charity. Second, under Maryland law and the law of most jurisdictions, it is hundreds, decades at least, but at least 100 years of well-established law that when you are interpreting a will, the only time you are allowed to bring in evidence from outside of the will is when there is what is called a latent ambiguity in the will. For example, if you say, I leave $5,000 to my cousin Mike, and you have two cousins named Mike, that is the only reason when the court is allowed to look at extrinsic evidence in order to determine what the testator's intent actually was, which cousin Mike that they meant. The other thing that we have our written testimony submitted with kind of 5 different things, but in summary, we believe that the bill is so narrowly tailored, it will not have any actual impact on health disparities in Maryland, which need to be addressed, that the will provision included in the statute has been interpreted under Maryland law, and there are legal inaccuracies within the bill itself as well.
Thank you. Please.
Good evening, Chair, Vice Chair, and this very distinguished panel. I feel the sentiment for this law. First, though, I am Michelle Mansulich, and am here today on behalf of the Maryland State Bar Association Estates and Trust Section Legislative Committee in opposition to House Bill 868. The proposed legislation is limited to a specific instance concerning legacy planning, transferring the decedent's assets, values, and principles to a provider or a charity in the health sector. This proposed legislation allows the personal representative to introduce extrinsic evidence to convey what the personal representative believes was the decedent's intent, address health disparity. However, it may be the personal representative's intent and not the decedent's. The statute does not address what happens if the personal representative is supplanting the decedent's intent. To make the legislation retroactive is backward thinking. Not only can the personal representative read the mind of a dead man, but the personal representative can hold the healthcare organization accountable for its past actions, penalizing the organization with extrinsic evidence introduced after the fact. Instead, the personal representative can petition the court for permission to act in any manner pertaining to the administration of the estate, per Estates and Trust Section 7402 as it currently exists. If an appeal is necessary, they can appeal. The Maryland Court of Appeals has ruled the courts are bound to look to the intent as expressed in the will, and where the language of the testator is plain and unambiguous, such language must govern. Thus, extrinsic evidence is inadmissible if the language in the will is clear. Passing Granny's law closes the door to judicial intervention. I respectfully oppose this legislation because it allows a personal representative to interpret the intent of a dead man's will through extrinsic evidence without court oversight.
Thank you, Mr. Chair. And I know my colleagues are ready to go, but this is challenging for me. And thank you for being here to my Register of Wills.
Of course, pleasure.
Let me ask this question. And it seems to me this turns on a specific set of facts, right? And I know part of the challenge was that there was a mention of power of attorney versus personal representative, so I know that's a challenge with the law. Did this will contain some language that actually designated a charity? Is that part of the issue?
So we can pull its public record, the will in question here, and from my recollection, I do not have the will in front of me, but it left bequests to 4 healthcare related charities.
And I'm sorry, that's.
I'm sorry, no. You have to get up. It's my grandmother's will.
I understand.
Panel, this is a panel of opponents. I'm sorry.
I'm sorry.
So but I don't have it in front of me.
No, I understand.
My recollection was that it was 2 healthcare charities, but there was no additional language to say that it needed to be used specifically for addressing health disparities. And the language that that also was at issue was, it's actually in this legislation. The language from that will is actually in this legislation, which does appear boilerplate in a lot of wills as to what the personal representative can do with respect to administration. And because this law is so specific to the facts of this case, the actual language from the will in question appears in the statute. And it says, in addition to the powers conferred upon the personal representative and trustees by law, my personal representative and trustee or any duly appointed successor shall have the authority without adjudication or order or direction of the court to, and then it lists the provisions in the will, and you can read along.
Right.
But those were the provisions in that will. And
which is not unusual.
No, it's not unusual, but the issue turned on disagreement between the parties with respect to the interpretation of that language, where one party thought that gave the personal representative the authority to interpret the gifts to charity based on the intent of her perceived intent, or maybe the actual intent of the testator. But again, I believe that the will should have been changed to take those specific restrictions into account, and unfortunately it wasn't, and that created a very bad result in this estate and caused a lot of heartache for this family.
Who was the personal representative?
I believe I think at first it was the granddaughter, Jennifer Johnson, and then because of this disagreement, she was removed. And
the disagreement was between what parties?
Because the court ordered her to turn over documentation of financial records, and she refused. She was found in contempt and put in body attachment and put in jail. I'm not in control of that. That's the Orphans Court. I had nothing to do with that. That is a terrible result. Terrible result for this family, terrible result likely for this decedent. But unfortunately, when we're interpreting laws and the court act, and I guess that's where this law comes from, it wants to give a little more wiggle room to the personal representative to alter how a will is interpreted after death.
But let me ask this. I'm sorry.
Yeah, no.
I'm sorry. No.
Mr. Chair. It's a really important. Thing.
Let's assume that whomever was the PR remained the PR, and that PR made a decision based on the four corners of the will that they were going to give all of this money to, I don't know, Johns Hopkins Maternal Health to deal with health disparities. Without this contempt and without the PR being removed, whoever that PR was there an issue ultimately with the interpretation, or did that occur after the PR was removed and there was a difference between the new PR and the old PR? So
my recollection, and again, the will left money with no restrictions to various healthcare charities. And I guess later in her life, closer to her death, and maybe throughout her entire life, she believed that the money was going to be going to charities to specifically address health disparities. The problem was the will did not specify that restricting language with those gifts to charity. And the will was interpreted by the court that there were no restrictions on those gifts to charity because the will didn't say so. And so the gifts were given to the charities, I guess, without those restrictions. So my feeling with this is that in addition to there being health disparities with different communities, there's also disparity in access to quality legal representation, that if that will had been properly drafted, or if I was drafting the will, I'm a career estates and trusts attorney before I became register, I would have made clear that the restrictions were placed in the plain language of the will, so you wouldn't need to introduce all of this other evidence of intent after death. Or you could leave it in trust, or she could have given lifetime gifts, specifically giving it to certain programs within certain institutions. So there was a way to resolve this, and I think the problem with this and what happened and the bad result in this was that the legal representation was inadequate for the situation, and this family unfortunately has paid the price for that, and it's caused a lot of heartache. But I think that the law, the way it's drafted, is so specific for the facts to address this one family's plight, that, and then the rest of people who die in Maryland whose wills are clear, there's a potential for extrinsic evidence after death to be introduced that might disrupt their clear intents that are in the will. So that's why I'm here, and it's a horrible position to be in because this family has suffered a great deal, and I am sorry to be here testifying against this legislation.
And that's fine. I've got a, I'll have a follow-up conversation with my register later.
Okay, I'm sorry, everyone.
Thank you, Chair. Thank you, panels, for coming in. To the register that just spoke, are you from Baltimore?
Baltimore County.
Baltimore County, okay. So can, while you were talking, I wrote up a little will. Can I register this with you if I'm a Baltimore County
Yes,
person?
you can register it. It has to be signed by you and 2 witnesses, and we can register it. I have to tell you, in my experience talking to groups, that although you can write your own will and it can be legally valid, it's not best practices. The best practice is to have an attorney draft your will.
Oh, okay. Well, I've talked to some people like the register. Well, I don't want to get in trouble with that. But anyway, so I might not be a legal expert, but some will registered with you would be better than no will. Is that correct?
Most of the time, sometimes they can do more harm than good if they're so inordinately
Or sometimes
unclear.
they can do more good than harm too, right?
Correct.
Like if you have a divorced spouse or something like that, isn't that correct? And you don't want the money to go to the divorced spouse, and you want to specifically leave it to your children, isn't that correct?
So under Maryland law, if you draft a will and then later get divorced, the provisions relating to your ex-spouse are deemed as if they had predeceased you. So
Yes, but if you get divorced and then you rewrite your will, and your ex-spouse doesn't know about it, now when they come to challenge it, and it's registered with you, you say, well, it registered after you were divorced, right?
Correct.
Yeah, I know I'm correct. So anyway, how much does it cost to register with the registry?
$5.
How much?
$5.
$5 deal. Thank you very much.
I'm not that animated. Thank you, Delegate. Okay, so register wills. You're an elected official, right?
I am, correct.
What in your ability are you able to do to educate the public?
So I do a lot of outreach. So I've gone to every single senior center in Baltimore County many times a year. I speak at churches. I speak at community groups. I've spoken at the YMCA. I've given Zoom calls to fraternities and sororities. I do whatever I can to get out there. And I also have on my website a list of legal resources that include programs that give free or pro bono legal services, Maryland Legal Aid, the Maryland Pro Bono Resource Center, St. Ambrose Housing. It's all on my website, and every time I go out and talk to community groups, I make sure I say, you should have a lawyer draft your will, and here is a list of lawyers, their hourly rates, and if you don't trust them, move on to the next. So I do all of that, and I explain the probate process, wills, trusts, gifts, and I spent a lot of time doing that. It was like a personal mandate when I took office that I wanted to do my part to educate the public about the importance of estate planning, and I particularly tried to do outreach in historically disadvantaged communities.
Okay, so in your experience of being in this position, how many poorly written, as you referenced, this is your language, wills have you come across and that have been specifically say blacks?
Well, there's a lot of disparity in the populations that actually have wills. And if you're African American, you're more than twice as likely not to die intestate. That means without a will. And there's just a huge disparity in the quality of estate planning services in the African American community. And so if you look at it, and I did, and there's, I don't have the the demographics off the top of my head at this moment, but I do have them, that there was a Pew Research study from, it's been about 5 years now, but you're more than twice as likely to pass away without a will if you're an African American in the country. I don't have specific to Maryland because that study didn't address Marylanders specifically. It was a nationwide study, but I can get you that information because there is a huge disparity in estate planning.
Right, I get that, I understand that. I'm just curious, within your time and your position, your county specifically, what are you seeing on a regular basis as far as disparities? And that's something that you don't have to answer, but that's where I was going with that.
I fully understand, and I do see a lot of poorly drafted wills. I see a lot of people that avoid hiring lawyers and draft their own wills and do a horrible job. And I give examples all the time in my talks about examples of people who have decided to draft their own wills and have made errors and have caused all kinds of litigation and hardship among family. So, yeah, we see that, but it's the biggest thing is the lack of estate planning or a lot of poorly drafted documents that are done on LegalZoom, for example.
Okay. My last question for you: the extrinsic evidence. When is that introduced? When is that allowable? I know we have the example of Mike such and such versus Mike such and such. I get that, but just tell me exactly when does that come to play?
So, do you want to?
I mean, we can both speak to it, but under Maryland law, you aren't supposed to look at extrinsic evidence. The interpretation of a will is supposed to be contained in the four corners of the document, and that is black letter law going back to the ecclesiastical courts in England. It's just so bedrock because there's such a worry that people are going to second guess a decedent's intentions with using extrinsic evidence, that when you die, you leave a will, and the will is supposed to have your clear intentions in the document that aren't supposed to be questioned by introducing other evidence. And that's the way decedents are able to communicate their wishes and make sure they have the force of law after death. So the problem if you have a poorly drafted will is that the intention isn't clear. And this law is seeking to invite outside parties, the personal representative, to come in and second guess a decedent's wishes. And that might have been the right result for this family, but most of the time it would not be the right result for most families and most wills.
Okay, thank you. Thank you, Mr. Chair.
Okay. Thank you for coming in and for the clarification. For a little bit more further, so is there no wiggle room, no best interests of? So if I leave everything, I make my daughter is the person who is my representative, and I want $500,000 to go to charities, I can't just put it that vaguely. I have to specify the charities or specify specifically the organizations, because, I work for the retirement agencies. Charities, particularly now, can come and go. So
you can put provisions in there in your will. So when you're drafting, if you say, I want to leave it to the Maryland Heart Association, if that agency exists when I die, if that agency doesn't exist, then I want my personal representative to choose another agency that has a mission most similar to the American Heart Association. And that's how you would do it if the charity was no longer in existence. Or if you wanted to leave it.
But it would have to, so you're saying it would have to specifically specify, if this is not here, then this.
Yes.
And you all would not honor any wiggle room of, like I said, my daughter, I'm saying, would be my representative and would get X percentage, and then I want the rest to go to such and such. She would not have the ability to.
Unless you added that provision in there. You could say, I leave this money to charity for my personal representative to decide which charity it goes to. You could add that in there and give her full discretion, but you just have to be clear that that's what your intention is. So if you want something to have a lot of wiggle room, and like you could leave it in trust, and then the trustee could make distributions based on a private memo or something. But if you're using a will to make charitable distributions and you want wiggle room, you have to specify that wiggle room.
We have 6 bills to go. It's 7:40. You have a wrap?
No, I just wanted to make, you know.
We can talk later if you have more.
Well, I just want to know where the trouble is. If she didn't do it specifically to, and she did make a specification.
The charities come and would.
Because I hope she's grieving me. I may not be thinking straight. I mean, I'm just kind of hoping that she wasn't happy and whatever, and so therefore she may make a mistake. Or think that I would want something, or I may have said something and not run back and give you the $5.
All right, Delegate Williams with a very brief question.
Can you send that report to all the members of the committee? I think it would be helpful. And then if you do have statistics with regards to your office about the disparity with regards to African-American communities in Baltimore County and other communities as it relates to wills, that would be helpful as well.
The figures I have are nationwide because we don't keep that data, but I will give you everything I have to illustrate this really important issue.
Okay, thank you.
Thank you very much. That concludes the testimony on House Bill 868. Delegate Buckle now for House Bill 903. With him is Darrell Barnes. He'll come up right now. We'll hear from him. There are only 2 people testifying on this bill. Delegate Buckle, you get 3 minutes. Everybody else gets 2.
Thank you, Mr. Chair. I'll do my best to go as quickly as possible. As you can see, I've brought in the big guns here with the former chair of the Legislative Black Caucus, my friend, your friend, everybody's friend, former Delegate Darrell Barnes. Very happy to have him with me. I've sat here for a little while this evening. It feels like I had a terrible flashback to my first year of law school and a lot of, you guys have very interesting conversations. House Bill 903 would essentially prohibit governmental entities within the state of Maryland from filing lawsuits attempting to claim specific or specified damages relating to global climate change. Why would you suggest that that's necessary? 2 entities, Baltimore City has attempted to do this, and a circuit court judge in Baltimore City has said, nope, you can't do that. That's not how we do things. Deciding the policy of climate change, the policy of how to mitigate it, and the policy of who's responsible for it is not subject to civil litigation. The city of Annapolis and Anne Arundel County last year tried to do this. About a month and a half ago, a judge just right over on Church Circle said, nope, you can't do that. Other courts across America have said that these are not appropriate forums for judicial and civil actions. They are policy decisions. We are policymakers. They are not for the courts to decide and juries to decide and take the position that, gee, I think that Maryland has suffered X amount of damages, and I can somehow impugn that back to a variety of fossil fuel companies, energy distributors, whatever it may be. What the legislation would do is put finality to that. These things have tremendous costs. I'm an attorney. I kind of enjoy it sometimes, quite frankly, when legal matters cost money. But I understand. I listened to that very nice young lady that talked about $100,000 in legal fees for sorting out an estate dispute. That's obscene. That's ridiculous. Middle-class folks can't afford that, and I tell you who else can't afford it. We can't afford it as a state to be spending these types of resources in these cases. Companies don't want to come here if they think, hey, I'm always going to be sued here. Our circuit courts have already determined, I believe our appellate courts will reinforce, that there's no grounds and no legal basis for these types of actions. We should take a strong policy statement now and say, hey, if you want to come in and you want to look for ways to tax people or fee people about climate change, you come to this body. We have lots of bills every year for climate change taxes, climate change fees, environmental remediation fees. It's not an appropriate venue for juries and judges to make those types of decisions, and that's what the bill would do. Thank you, Mr. Chair.
Thank you so much. It's good to see you, Mr. Chairman, Vice Chair, and committee. For the record, my name is Darrell Barnes. I'm with Barnes International. I'm here to support House Bill 903. Listen, I can't say more than what Delegate Buckle has already said, but there is a growing trend across the country of states, local governments filing lawsuits against fossil fuels and other energy-producing entities attempting to hold them liable for the use of climate change. Lawsuits like these could be led to higher energy prices, hurting Maryland residents and small businesses. The ratepayers in the states are already begging for help with skyrocketing energy bills. This is ahead of the rate increase that will take effect in June and is estimated, according to BGE, to increase by $18 per month due to power plant closures and other aging power grids. Lawsuits such as these will only make things worse. When a state has a reputation for suing industries for illegal productions of legal products, businesses trend to view these as hostile. With Maryland's myriad of other challenges, attracting businesses and behaviors like this is unacceptable. Listen, I think we have an opportunity to do the right thing here in the state of Maryland. I think we have an opportunity to look at this bill more broadly, and I think we have an opportunity to ensure that we pass this bill with a favorable report. I'm here to answer any questions that anyone may have.
Questions? Delegate Conaway.
Thank you, Mr. Chair. Thank you, Delegate and panels, for coming in to testify. In specific, were any of the entities in Baltimore City?
I think if I'm getting your question correctly, Delegate, were any of the defendant entities present in Baltimore City? Is that what you're looking for?
Any of the sources of the, I guess, pollution that might be causing the climate change?
You know, I'm not as familiar with the four corners of Baltimore City's complaint as to whether they were suing for specific emitting sources, something like an incinerator or something like that, or if they were suing. I think to be fair, and if I'm wrong, I apologize. I think they were suing more broadly for all of the effects, all of the alleged effects of potential global climate change and attempting to apportion liability among essentially all fossil fuel and energy, not all, but all of the major fossil fuel and energy producing companies. It wasn't a lawsuit specifically directed to one particular facility or entity that existed within the city that may have produced some kind of a very segregable, identifiable harm. That's a great lawsuit. If you have something that says, hey, you operated a facility that's in my neighborhood and it caused very demonstrable harm to my group of people, you can sue on that all day long. You can't come in and say the earth is getting 1 degree warmer this year and I'm part of the earth because I'm Baltimore City and I want to sue ExxonMobil down to the gas station in, you know, Tahiti and bring them all in and claim they're responsible.
Well, I'm glad I didn't have to pay for that. But anyway, so it could be the incinerator and Bethlehem Steel and several entities packaged together. Is that correct?
I think that if you had a very defined nexus between the alleged harm that the city claimed that it was suffering and a particularized activity, that would still be allowed. This is about suing for global climate change and basically saying that because you produced fossil fuels anywhere in the country, they may have come in, you know, you may have driven your car through Baltimore and that could have caused some harm. We can sue you across the board. That's the lawsuit that the Baltimore City Circuit Court has already thrown out.
Thank you very much.
Thank you.
Further questions? Seeing none, that concludes the testimony on House Bill 903. Now at House Bill 860 with Delegate Buckle, and he's the only person to testify on this bill.
Thank you, Mr. Chair. House Bill 860 is a bill the committee has seen before, and I will be blunt. It is a bill that I will continue to file until the last moment that I exist in this chamber, as long as particular common carriers do not fix the harm that they have caused. This bill essentially would create an ongoing public nuisance for common carriers, including railroads, other operators, things like maybe tugboat companies who hit public roads, public bridges, public conveyances. They destroy public infrastructure, and then it takes forever to fix that public infrastructure. And it would continue on, basically create a continuing nuisance that extends the statute of limitations until such things are appropriately fixed. It would apply, for example, to what happened at the time I had the bill hearing last year, the Key Bridge disaster. I don't believe had occurred. It is something that would apply to that. More importantly, the reason why I drafted the bill, if you remember from last year in my hometown, the city of Cumberland, almost 7 years ago now, on several different occasions, CSX trains, while traveling through the town, hit. They either double stacked or inappropriately had cargo stacked. They hit 3 separate roads/bridges. They're technically little railroad bridges that are also roads that convey major arteries, frankly, through suburban neighborhoods connecting to downtown Cumberland. They hit them. They rendered them unusable for public use. They create significant challenges for us in getting fire apparatus and hospital apparatus through those neighborhoods. They are not fixed. They are still not fixed this year. I swear to goodness, I think in the United States of America, you know, we couldn't fix a bridge sooner than what our forefathers could put a man on the moon. It is reprehensible how long these things take and how long they are affected. And CSX is a large employer in our state. Cumberland is actually the second largest basis, at least to my knowledge, for employment of CSX outside of the city of Baltimore. We want CSX, we want other common carriers to succeed here. But when they do something and they cause problems to public infrastructure and they just sit and they sit and they sit because, oh, well, we don't have the money, we're only gonna pay a little bit, you gotta go through the government. We know how hard it is getting money from the government to do anything these days. They should be continually liable for those instances and continually on the hook to get them fixed because they are public infrastructure, public roads, and you cannot damage them and then just say, oh, whoopsie, we'll have to go back to the government and we'll see if we get that road fixed 10 years from now. That's what the bill does. I intend to file the bill forever if necessary.
All right. Questions for Delegate Buckle? Do you? Just good. Yes. Delegate Valentine.
Thank you, Mr. Chair. Thank you, Delegate, for bringing the bill. I remember specifically with the bridges. Has that process even started on any of those 3 bridges since you were last here?
Two of the 3 bridges, there is a process in place. One of the 3 bridges, they were both 2-lane roads/bridges. One of the 3, you can use 1 lane. You can go in either direction. You just have to slow down and let one through. The other 2, there is no traffic on. And as I said, 2 of the bridges, there is a process. It is a very, very long process because you're trying to get federal funds and state funds to rebuild. The other through what's called Washington Street, which is a very major thoroughfare, because of some particular engineering issues, they don't even have a plan. And quite frankly, it's absurd. I can tell you that if it happened in many, many communities across this state, people would cry high bloody murder until it got fixed. And we have to do something to try to facilitate that where I live too.
Delegate Queen is here from Economic Matters.
I'm sure she has many questions.
It's both ECM and Judiciary. Just in case, do you have any
I hope I did not pull you out of a very nice dinner this evening or something, Delegate Queen.
They really mentioned dinner.
They really did mention dinner.
Listen, you guys are on a pizza diet here on Judiciary. You know that when you come in.
We're gonna try and forget that part. All right, any other questions?
I sent you some questions though, but I'll get you.
Okay.
All right.
I didn't think you would still be here when I came.
They kind of make you be, so.
All right. Seeing no further questions, that concludes the testimony on House Bill 8.
Thank you, Mr. Chairman. Have a good evening.
Thank you very much. All right, Delegate Solomon. House Bill 686. Eric Lopez, Emma Fringpong, Viviana Westbrook, and Amanda Rodriguez. Quite a few people signed up. Lopez is virtual. On the other hand, now there are more people than I called out, but hey, we'll find out who's here. Have a seat, let's go. All right, go ahead, Delegate Solomon.
Thank you, Mr. Chair, and I will try to be brief. So I know you have another U visa bill on a similar issue from the good Delegate Embry. Very supportive of that, so I'm sure there'll be an even more robust conversation on that as well. Basically, the Stand With Our Neighbors Act is to make a couple of tweaks to the U visa process that is already on the books here in the state of Maryland. For those of you who don't know, the U visa is a federal program to provide essentially protection protection for victims of crimes who are not citizens, who have come forward and are working with law enforcement. Again, it's really a public safety tool. And so what our bill does is take some of the best practices that we found from other places around the country. Obviously, in a really difficult environment for immigration enforcement, we want to make sure that folks who are not citizens in our communities feel comfortable when they've been victims of crimes to work with law enforcement. And I really appreciate our amazing sheriff from Montgomery County, Sheriff Wee, being here, sticking it out the whole day with us, because this is really important to him, and you'll hear from him in a second. But our bill does a couple of things. One, it reduces the standing processing time. Current law is 90 days for overall processing and 14 days if you are in removal proceedings. Obviously, if you're in removal proceedings, it is even more important to expedite that. So we cut those times down from 90 days to 30 days, and then from 14 days to 7. There's a number of states that have improved their processing times, as diverse as Arkansas, California, and Illinois. We require that the certifying law enforcement agencies, so the way that a U visa works is the local law enforcement agency has to essentially certify that you've been helpful, and then you can then apply to the Department of Homeland Security for the actual U visa, which obviously, again, is a federal process. But we want to make sure that our certifying agencies here in the state have protocols in place for people with limited English proficiency. And then lastly, we tweak the helpfulness standard that is in statute, again, from the 2019 law that's on the books here in Maryland that established this process for our state. And we create essentially a new helpfulness standard. We make it a little bit easier. We create a rebuttable presumption, which basically means that a victim is considered to be helpful to law enforcement until they have done something that is not helpful. So it just makes that burden a little bit easier. The other way to think of it is it's a rebuttable presumption as something assumed to be true until proven false. So again, it makes it a little bit easier for that victim or the folks who are supporting the victim to be able to get that certification from local law enforcement. And that is, again, pretty much our bill. It's, again, really about public safety, making sure that folks who are not citizens feel comfortable going to local law enforcement to help with crimes, knowing that this process is there for them as well, for their protection.
Yeah, do you want to go? Okay. Well, good evening. Honorable Committee Chair Clippinger, Vice Chair Bartlett, and Judiciary Committee members. My name is Maxwell Wee, and I'm the Sheriff of Montgomery County. The Sheriff's Office is the oldest law enforcement entity in Montgomery County, having been established in 1777. Today, the Sheriff's Office is the law enforcement arm of the court system and complements the mission of our allied law enforcement agencies throughout the county. I appear today to support House Bill 686 as introduced by Delegate Solomon and others. As a law enforcement professional with over 30 years of experience, I offer my support for the proposed legislation that would streamline the U visa process by reducing processing time for law enforcement certifications, requiring the development of protocols for petitioners with limited English proficiency, and creating a rebuttable presumption of helpfulness. Each of these procedural changes will undoubtedly serve to enhance the U visa process and ultimately serve to protect victims of domestic abuse. As a sheriff in Montgomery County, I oversee the Family Justice Center facility, or FJC facility, that provides comprehensive support services to victims of domestic violence. The U visa process has served as an invaluable incentive to protect otherwise vulnerable immigrants that rely upon the FJC services. Given the uncertainties of the current immigration enforcement initiatives of our new federal administration in Washington, these procedural changes in the U visa process should allay fears that vulnerable immigrants have about U visa processes by requiring all expedited certification process and by requiring that such certifying entities provide assistance protocols for those individuals who lack English proficiency. I would like to thank the members of the committee today for their time and attention and urge for a favorable report for House Bill 686. Thank you for your consideration in this matter.
Hi, good evening. Chairman Clippinger, Vice Chair Bartlett, and the rest of the Judiciary Committee. My name is Viviana Westbrook. I'm from Clinic, Catholic Legal Immigration Network, the state and local advocacy attorney. And today we are urging a favorable, excuse me, sorry. We support HB 686, but we are asking for amendments. We are in favor of everything that's in here. Everything's very important for victims of crime. I have been representing survivors of gender-based violence for many years and can say how important the U visa law is. I testified before this committee many years ago when we were looking to pass the bill and then actually passed it. But now, we are seeing some issues that we want to see, addressed, because unfortunately, there have been some amazing certifiers. I do want to make that very clear. They are doing things that are just helping victims of crime in so many ways, and that's wonderful. But we need to make sure that there is language access, that the turnaround times are quick, but also that they're being enforced, that they are getting us those U visa certifications quickly. And also the rebuttable presumption, I think this was actually technically supposed to be inferred from the original law, but nobody has been inferring it. So it's really great that they're asking for it to be, to specify it. Our amendments are, what we're asking for is to have some sort of prohibition of blanket policies around when the crime happened and when the immigrant is seeking certification, a reporting mechanism, so certifiers report what they're doing, some accountability mechanisms, and the ability to appeal denials, to also state clearly that multiple certifiers are allowed, and also language around just the purpose of the U-cert. So thank you, and favorable with amendments.
Good evening. My name is Ama Frimpong, and I am the legal director at CASA. I'm here to express our strong support for House Bill 686. In my over 10-year career as an attorney, I have come across hundreds of cases where survivors of crime were concerned about their cooperation with law enforcement due to their immigration status. The U visa process is critical to protecting immigrant survivors of crime and ensuring they can safely cooperate with law enforcement without the looming fear of deportation. House Bill 686 further adds to this critical process by establishing a rebuttable presumption of helpfulness, ensuring language access, and providing a speedier timeline for certification. Truly, the most recent U visa certification my team requested, it took us 7 months to get it back from law enforcement. In particular, the rebuttable presumption element of this bill allows for a trauma-informed approach that shifts the burden away from survivors, many of whom face language barriers or are navigating the aftermath of severe trauma. I have personally witnessed the trauma experienced by immigrant crime survivors, individuals assaulted at work, mothers whose children face gun violence, and women who suffered sexual abuse. Without the increased protections provided under House Bill 686, many of these survivors of crime will continue to remain silent, fearful of interacting with authorities due to their immigration status. By passing this bill, we build trust between immigrant communities and law enforcement, fostering safer neighbors for everyone. For these reasons, I respectfully urge a favorable report on House Bill 686. Thank you.
Good evening. My name is Amanda Rodriguez. I am the chair of the Legislative Committee of the Maryland Human Trafficking Task Force. And I wanted to just start by thanking the delegate for bringing this bill on this very important issue, and for the proponents of the bill, ensuring that victims of crime are treated equitably across the state. The Maryland Human Trafficking Task Force strongly supports the intent of this bill and the efforts to create a fair and consistent process for law enforcement certifications. We are also in support of HB 579, which you will hear about in a moment, and we feel like the bill is collectively effectively address the real-world barriers victims face when seeking certifications. To ensure meaningful change, we urge the committee to amend the bill to merge the two proposals, creating a stronger and unified approach. Victims deserve a system with real accountability, one that doesn't allow critical decisions to be made in the shadows, but without transparency or recourse. And if we truly want to ensure equity, consistency, and access to justice, we must take the strongest possible approach. We ask the committee to support this bill with the amendments that I just stated to incorporate the critical provisions of HB 579. Thank you for your time and commitment to supporting survivors.
Let's hear from Jonathan Green, because he's been staring at the screen all day, and I think Might as well. He's sitting here, and I know he's not supposed to be on this panel, but I'm making an executive ruling that I don't care. Jonathan Green, please, for 2 minutes.
Thank you so much, Chairman Clippinger. I appreciate that. Again, my name is Jonathan Green. I'm from the Maryland State Bar Association. I see many of my hardworking colleagues there, and my great appreciation to them, especially Delegate Solomon, for introducing this bill. Back in 2018, I worked with Delegate Pena-Melnick to actually create the amendments to bring this into law. And I will just say that if these changes, if this bill had been proposed then, I would have been extremely happy. These changes to the existing statute are needed desperately. With the enforcement agenda of the current administration, there is no time to simply sit around and wait for certifications to occur for days, weeks, and months. And I cannot applaud Delegate Solomon and the other delegates on this bill enough. This is just tremendously wonderful. The one thing I would point out is that the Maryland State Bar Association Immigration Law Section hasn't seen any of the proposed amendments out there, but we would be willing to consider them if they're falling in line with these changes to the statute. We would probably support them as well. I personally have filed many petitions requiring certifications. I have been rejected time and again by certifiers across the state of Maryland without reason. I've sat for months of delay, and on the state bar, we have a U status committee, and we try to help our attorney members who are having problems with certifiers across the state, even in Montgomery County, Sheriff. And I'm sorry, but everywhere we have problems. This bill's going to go a long way to really help things, and we appreciate it tremendously. Just one last thing. This is not really a visa. It's about having status in the United States. So the administration wants to remove people with U status. They can't get a visa to come back in. That's why this is so critical. It's got to happen here. Thank you.
All right, thank you very much. Before we take questions, I just want to make sure, I want to see who's still here. Nick Katz is from CASA, but I think he's gone, right? So he's not here. All right, and Ms. Hoydra? Right. Okay, why don't you come up, pull up a chair, and we will get you to be a sixth person to testify here. And so virtually, we don't have any of these people, so basically I'm going to announce them, and if they show up, we'll put them up. It's Jesse Bennett, Edna Yang, Veronica Thronson. Any of those three people, if they're listening in, they could join in. And I see Eric Lopez, so we'll hear from Eric Lopez was on the last. Oh, he was supposed to be on this panel too. We'll hear from him in a minute, but let's hear from you right now.
Thank you.
And then we'll go to Mr. Lopez on here, and that might be everybody, so go ahead.
Distinguished members of the committee, my name is Sherry Hoydra. As you've heard previously, I'm chair of the Maryland State Bar Association's immigration section, private immigration attorney, resident of Howard County, and business owner in Baltimore County. I'm telling you, this bill has real world implications. My clients come to me and they ask, how long is it going to get how long is it going to take to get this certified? Some of these people are under tremendous pressure from for different reasons to get the certifications quickly. From 90 days to 30 days has real world implications. The sooner you file and you can get your certification, the sooner an individual who may have no documentation whatsoever can obtain their Social Security card and what we call an EAD or employment authorization document. If there's a real claim there, these are processes that really give people a sense of safety. And the sooner that you can get the process started, the better. From 14 to 7 days for those in proceedings or subject to a final order, that's significant as well. Those who have a final order who get deferred action may not necessarily be protected 100% from removal, but at least it gives them some sense of frame of mind of safety while the process is playing out. For those reasons, we actually support this bill. The MSBA immigration section supports this bill without amendment, which I'm sure would be a relief to hear. Thank you.
All right, Eric Lopez, please, for 2 minutes.
Chair, Vice Chair, committee members, my name is Eric Lopez. I'm a Deputy Program Director at the Amica Center for Immigrant Rights. I provide free legal representation to U visa eligible immigrant survivors of crime, and I have seen firsthand how flaws in the current system create unnecessary obstacles to their safety and access to justice. House Bill 686 introduces critical reforms to promote fairness, consistency, and accountability. One key reform, the rebuttable presumption of helpfulness, addresses unjust U visa certification denials caused by misunderstandings, by trauma, or the arbitrary exercise of discretion. This presumption streamlines the process and ensures that victims who have not refused to cooperate are protected from inconsistent and subjective certification practices across jurisdictions. This bill also confronts the urgent problem of certification delays, which can have devastating consequences for victims. For those facing deportation, a delay can mean losing their chance to apply for a U visa and effectively strips them of its protections. This not only puts victims at risk, but also undermines law enforcement efforts by discouraging cooperation. Finally, requiring certifying agencies to develop protocols for individuals with limited English proficiency is essential. It ensures that language barriers do not prevent eligible victims from understanding and navigating the certification process. No victim should face additional hurdles simply because of the language they speak. Without House Bill 686, Maryland's system will continue to leave victims unprotected and weaken criminal investigations. This bill provides practical and necessary solutions. I urge you to support its passage. Thank you. And thank you, Delegate Solomon, for proposing it.
So, thank you very much. We now, I think, have had all the witnesses who are going to testify on this bill. I've announced the additional virtual people. None of them have come on. So now we're taking questions. Delegate Graham.
Thank you, Mr. Chair. Mr. Green, I have a couple questions for you. So we just loosened this code a couple years ago to help deal with this problem. And I think at that time, the argument was we couldn't get people to communicate with even crimes in their communities. We need to put this in place so we could get folks to work with law enforcement to, frankly, help prosecute legitimate criminals. But you're telling me that all jurisdictions seem to be denying these certifications. Can you give the committee like a percent, like how many are making it through in general?
Well, I can tell you from my personal perspective that we're probably getting about 50 to 60% through without difficulties in a speedy fashion. Of the remaining 40 to 50%, about half of those are just matters of just taking a long time, like 3 months, 4 months, even longer. And then probably 20% of our cases, we're just getting outright denials without any explanation. The rebuttable presumption will really help that. So Delegate, I appreciate your asking about this. It's a really important point. These things are real and they're happening. And I will tell you, our association hears from other attorneys that are also having these problems all across the state. I mean, every part of the state.
Yeah, and that's the kind of, that's really the point I want to get at. The rebuttable presumption, we're just kind of saying, we're going to assume that they were helpful. You know, someone's at the scene of a crime, the law enforcement officer asks, do you know anything here? Can you help me? And they say no. Under that case, that person would be assumed to have been helpful. Correct?
The actual federal law enforcement guide refers to the fact that if a person files a police report and works with the police, that's being helpful. They're reporting a crime and they're allowing for an investigation to occur. So that action by itself ought to entitle someone to get a certification. And all the certification says is they started the process. They're being helpful, then they're not refusing unreasonably to continue to be helpful at every step of the process that they're asked.
Yeah, but there are a lot of other circumstances other than filing a police report. You know, working with police, answering questions, all these types of scenarios could allow a person to apply for one of these, right?
Well, typically you can't get it unless you're starting out with filing a police report. I mean, that's the initial threshold requirement, unless, and again, that's if the initial engagement is with police. Sometimes the actions start in court proceedings, and you can ask a judge in some proceedings or the Department of Labor. But we're talking about law enforcement certification here. So we're talking about our police agencies. The key step in almost all these cases, filing the police report or working with the commissioner to initiate a proceeding directly with the commissioner at the courthouses. All of those things are those initial steps. But I will tell you that the USCIS, the federal agency that's reviewing these petitions, they want to see paperwork. So we always submit the police reports along with the certifications. It's very important to show the cooperation that way.
So what percent of these cases are cases where the person applying for the U visa is the victim? Because it sounds like that's what you're alluding to.
100%. These are for victims of crimes that are identified under federal law. So, and again, it's not the visa, it's just status in the United States. And it's a really important program. It encourages people to come forward to report crime. It's very important for community policing. And I don't think anybody here today doesn't want that to happen. We want to make sure that our police have people who will come forward, victims, witnesses, to help them to be able to catch people who are committing crimes.
And for those denials, you never receive a response as to why they were denied.
They just simply say denied. Or sometimes they don't bother responding at all and we have to follow up. And then we're just told over the phone, they're not going to certify. It's really very frustrating.
Okay, thank you.
I was going to say, just to follow up Delegate Grammer, Delegate Embry's bill addresses a lot of those sort of broader, they're really good 1-2 punches. And I should have neglected to say, we worked really closely with former Delegate Morales, who authored the original U visa bill, as well as with Delegate Pena-Melnick, who is the author of the 2019 bill that established the process. So just grateful for their help.
All right, seeing no further questions, we thank you all very much, and that concludes the testimony on House Bill 686.
Thank you.
Thank you.
Now, members of the committee, please be aware that there is one of my district mates here, and she's incredibly difficult to work with. But Delegate Robin Lewis is here. Oh, wait, she is here. She's not difficult to work with. House Bill 1440. Wonderful.
Mr. Chair, thank you. Mr. Chair, may I bring my panel?
Yes, of course.
I have Megan Wagner and Rachel Wagner and Megan Jones. And I believe I may also have a virtual witness.
We have Ms. Gilbaud as well. That's fine. So we're going to hear from all of you. Ms. Jones is favorable with the amendment, but whatever. It's fine. 3 minutes for the delegate, 2 minutes for everybody else, and we'll hear from you. Go ahead.
Thanks so much, Mr. Chair, Madam Chair, esteemed colleagues. I'm Delegate Robin Lewis here on behalf of House Bill 1440, the Parental Accommodations Bill. Thank you guys for working so hard and staying awake so that you could hear about this amazing piece of legislation. This is the best bill you'll hear today. So this bill does two things. First, it requires circuit court buildings that are being renovated or newly constructed to provide a lactation room. That lactation room has to meet certain requirements, common sense, basic public health requirements, but again, renovated or being newly constructed is circuit court buildings. The second thing the bill does is it creates two new justifications for jury service excusal. First, the right to be excused if you are breastfeeding. Second, the right to be excused if you have a child under the age of 4 for whom you are legally responsible for caring for. That's all the bill does. Now you might ask, this seems really common sense. How is it possible that we aren't already providing this standard of basic human dignity and basic accommodations for people who are caring for children? In my view, our failure to provide these types of accommodation are a relic of our long history, our long unjust history of treating women's work as of no value, of treating child rearing as an afterthought. This bill is one small way to set right what women, parents, and little kids deserve. And that's really all the bill does. So of all the bills you'll hear today, this one's pretty simple, hard to resist. And I ask, I knew that would wake you up, Delegate. But that's really all that we ask in this bill. It also behooves me to mention feel-good aspect of this legislation is that it was brought to me and to your chair by one of our very own constituents. This is an example of a fantastic idea that came from the people we represent, and it's my honor to sponsor the bill and bring it before you. The last thing I'll mention is, that constituent sitting next to me here, and her name is Rachel Wagner, and you will hear from her. The last thing I'll mention, I'm aware of unfavorable testimony from the Maryland Judicial Council of the Maryland Judicial Council's Legislative Committee. I have an answer for the committee, and that is I would love to work with them on their concerns. With that, I ask a favorable report. Thank you.
Rachel Wagner, please.
Hi, my name is Rachel Wagner. I'm here today in support of House Bill 1440. I'm a mother of 2 who breastfed both children. I'm a leader in my Baltimore City community and have owned and operated a small business centered on maternal wellness for just over a decade. I've interacted with hundreds, maybe thousands of parents, and I've heard far too many upsetting jury duty stories. At 4 months postpartum, Carrie was called to appear for jury service on a hot August day. She had insufficient access to water throughout the day due to courtroom rules and empty water coolers. Carrie also found it difficult to take a lunch break, having to spend most of it trying to access the lactation room and pumping breast milk. A lactating mother needs her own nourishment in order to make food for her baby. Carrie was deprived of her basic needs and ended the day dehydrated with a migraine. Another friend, a stay-at-home mother of 2, asked to be excused from jury duty due to lack of childcare. Denied, she brought her children with her and was told to come back without them. Many single-income households cannot afford for the only working parent to take off. Hiring a babysitter can be costly, and in the absence of their primary caregiver, children may cry incessantly, make themselves sick, refuse to eat, or withhold bowel movements. The stress this puts on a family unit is completely unnecessary. The most upsetting stories I've heard are those similar to that of my friend Anjali, who will testify soon. Mothers who have only ever fed their children at the breast have been forced to attach a breast pump to their bodies for the first time, sometimes painfully, and then leave their child for the first time, knowing their child is not likely to drink from a bottle and will instead cry out of hunger in her absence. House Bill 1440 wouldn't statutorily exclude identified groups. Rather, it would require jury commissioners to universally grant exclusions to those who request them and meet agreed-upon criteria. This uniformity is necessary to prevent discrepancies across the state where mothers in Baltimore City have been subjected to the aforementioned experiences, while a friend in Frederick was excused simply because she had to perform school drop-off and pickup. Since 1994, at least 30 states and Puerto Rico have adopted similar laws. This will cost Maryland nothing. I'm asking the committee for a favorable report in 2025. Thank you.
Good afternoon, or good evening, sorry, Chair Clippinger and members of the Judiciary. My name is Megan Jones. I'm a mother, a resident of Baltimore City, and an attorney. I've submitted written testimony that details my personal experience serving jury duty while breastfeeding a 4-month-old. I was initially called for jury duty 2 weeks after my due date and was granted an extension to 4 months later. When I showed up, I was pumping every 3 hours when my daughter ate, and so when I served jury duty, I needed to pump 3 times, meaning according to the CDC, I should have washed my pump parts in between the first and second use, but I only had 1 pair, and so I had to go against CDC, FDA, and breast pump manufacturer recommendations and reuse used pump parts in between because there is no sink available for lactating mothers to use, even though there is a lactation room in the Baltimore City Courthouse. I'm here to reiterate concerns with the lactation rooms that do not provide these sinks. As new courthouses are built, House Bill 1440 would require sinks, but the current facilities do not offer parents a safe way to express breast milk while serving jury duty. Breastfeeding parents need to be excused through a blanket exclusion uniformly, as Rachel said, throughout the state. Until courthouses can meet their needs to safely express breast milk. And for context, my daughter continued to need multiple feeds throughout that 9 to 5 jury duty window until she was a year old. With regard to my recommendation that the bill be amended, my recommended amendment would be to include a definition for breastfeeding. As Rachel mentioned, parents like our friend Anjali have had to learn how to pump. For me, even though I knew how to use a pump, I wasn't able to safely express breast milk because of the lack of a sink. And I just want to make sure that parents in a similar situation are included under the bill's definition of breastfeeding. I'd urge you to support House Bill 1440 with such amendments.
Ms. Gilbard, for 2 minutes, please.
Thank you. Hello, my name is Angelique Guilbeault, and I'm a homeowner and resident in Baltimore City, Maryland. I'm here in complete support of House Bill 1440 and to share my experience. I want to start by saying that serving on a jury is a privilege citizens of this country hold, and it is crucial that those serving on the jury do so with the utmost attention, commitment, and respect. As a nursing mother and primary caregiver, it is not always possible. I was 6 months postpartum when I received my summons. I was exclusively breastfeeding, had never used a pump, and had only spent 1 hour away from my daughter. As a stay-at-home mom, we could not afford childcare. I was furious and anxious. My husband, a Baltimore City public school teacher, used a sick day so that I could serve. I practiced pumping for 2 days to have milk for when I was gone, while also breastfeeding, which resulted in a painful overproduction. I was leaking and in so much pain when waiting in line to use the lactation room in the courthouse that I had to embarrassingly announce to all why I needed to cut ahead. If one does not nurse immediately, one can quickly develop blocked ducts that can lead to mastitis, a painful infection of the breast tissue. The lactation room stated no eating or drinking, 2 things necessary when nursing. I felt dehumanized, a machine painfully sucking milk from my breasts as I read a poster that stated the benefits of breastfeeding. There's no sink to clean up, I had to use a water fountain. Were I to be called to serve on a jury, I would not be able to have my water, something medically necessary when nursing. I would be a distraction, needing to stop and nurse right away, a request that would disrupt the court and may not be granted, which again could result in pain. I would not have been able to focus on the case in front of me, which is a great disservice to all. My child had refused to take a bottle that's 8 hours without milk. I had no choice but to leave my baby against my will. It felt like this city did not care about families. These protections and exemptions already exist in certain counties in Maryland. It is time to protect all of Maryland's citizens. Thank you so much for your time and your consideration.
All right, questions for the panel? So I'll go ahead and go to the judiciary's letter. The judiciary says that they don't have a problem with the part of the bill that requires lactation rooms in future construction and in renovations. Fine. The second part is where they have a problem. They suggest that the excusals be handled by the jury commissioners and that individuals request an exemption in such circumstances as opposed to statutorily excluding certain groups. And of course, their concern is that it will shrink the jury pool significantly. How do you respond to that?
Thank you, Mr. Chair. Do I have permission to make a few remarks and then pass it on to my?
Yes, that's fine.
Okay, thank you so much. So as mentioned, I'm more than happy to take up the Judiciary Committee's concerns. And I think it might help to clarify for them that they're assuming the bill's proposing a blanket excusal. And in fact, it's really not. It's just creating 2 new categories for excusal. But I'm happy to talk with them always. Next, I would turn to one of my panelists, Ms. Jones, who has some great thoughts on that question as well.
Go ahead.
So the bill as written would allow for an individual to show on a juror questionnaire during an interview or by other evidence that they're a breastfeeding mother or that they have legal custody and are personally responsible for the child under 4. So it's not, they still have to respond. They still have to send that questionnaire in, but if they meet that criteria, they would be excused. And it's necessary to explicitly say that because Anjali still got called when she was nursing a 7-month-old. I got called at 4 months, even though I've been told the policy in Baltimore City is 6-month automatic exemption. So there's not uniformity across the state with the way that jury commissioners are interpreting it right now. And the reason it explicitly needs to be stated in the law is so that it can be applied in a uniform manner to keep parents and children safe.
But is your point that that should be a reason why they could excuse someone, not necessarily that they automatically be excused, correct?
Correct.
So you're okay if it's a reason why they could give, but it doesn't automatically mean you're done.
Right.
Correct.
Okay. Now, I think that addresses the judiciary's issues. We'll find out. The rest of the committee is about to fall asleep and kill me, and that's fine. But having said that, it's an issue that has come up multiple times, and so I just wanted to make sure we had that on the record. Does anyone else? Delegate Conaway.
thank you, delegate panel, for coming in. I have a problem with the refrigerator part. And I mean, I don't have a problem with the exempt for you not to come in, but if they have a refrigerator, it'll be several different mother's milks in the, no, okay, I have a problem with that. So I'd rather for you to be excused, personally, I'd rather for you to be excused than to commingle the milk in the refrigerator. But thank you very much.
Thank you, delegate.
Any other questions? Rachel knows where I live, and she's been here long enough, and so please don't blow up my house because you had to be here till 8:30. Thank you very much.
Thank you.
That concludes the testimony on House Bill 13, right? Which one? House Bill 1440. Sorry, 1420. Which one? 1440. We'll get there at some point. Thank you all very much. We'll go now. Delegate Embry, please. Sorry to my friends, the Registers of Wills. We're going to do, well, only to a couple of them. Amanda Rodriguez, Ms. Hoydra, Ms. Westbrook, but I don't, and Mr. Green is back, so we'll take him. Ms. Yang and Ms. Stronson, no and no. Okay, so we've got the people who are going to testify. Delegate Embry, please go ahead.
Thank you all. I just want to say thank you to Delegate Solomon, both for his bill, which is terrific and I think complimentary, but also because he explained or reminded the committee of the U visa, U status, U immigrant status. So I'm just going to go through quickly the things that are in my bill. One overlaps with Delegate Solomon's, but consistently, and say also that there have been 3 sets of friendly amendments, and we're going through them. They all seem great, but just need some time to process them. So what does the bill do? It really, again, as Delegate Solomon explained, there's inconsistency across the state, so we're trying to create consistency, and it's all based in federal law. So a lot of what we're doing is just reinforcing what federal law and guidelines already say. So what the bill does, 1, clarifies who can certify. Often it's police and prosecutors think they're the only ones. No, there's lots of other entities. If they have knowledge of the matter, they can certify. It specifically includes the federal guidelines as applicable, so that we're hoping the certifiers will look at the guidelines, or if victims or their attorneys are referring to them, it will be reinforced by this statute. It says that an attorney, a victim advocate, or other representative, they can request on behalf of a victim. It expands helpfulness to include both current and predicted helpfulness. It clarifies that the victim can demonstrate helpfulness at any stage of the proceeding, from the point of detection or investigation all the way through to the end of prosecution, which is sentencing, or even post-conviction, which we were talking about. It says if a victim is a victim of multiple crimes, the certifier should include the details of those multiple crimes. Similarly to Delegate Solomon, a little differently, it defines helpfulness as existing as long as after the initial helpfulness, the reporting of the crime or being part of the investigation, as long as the victim has not unreasonably refused to cooperate or provide information, they should be presumed to be helpful. It clarifies there is no statute of limitations, so it is not a reason to deny certification because of an older case. And finally, it requires that the certifying official, if they refuse to, or not refuse, if they decline to certify, that they have to give a reason so that at least the victim and their representative can respond and try to persuade them, or at least have something to know to base their response on. So with that, I know it's late, so I'll stop 30 seconds early and turn it over to my panel.
Who would like to go first, please?
Mr. Chair, Madam Vice Chair, members of the committee, again, I'm Amanda Rodriguez, the co-chair of the Legislative Committee of the Maryland Human Trafficking Task Force. Thank you for the opportunity to testify in support of this critical bill, which ensures that victims of crime receive equitable treatment across the state when seeking U visa certifications. Under current law, law enforcement agencies control the procedures for issuing these certifications, leading to significant inconsistencies across jurisdictions. A victim in Montgomery County might have a very different experience than a Baltimore County victim simply because of where they were harmed. The disparities includes what crimes qualify for the certification, how quickly a victim must file, and whether victims are even notified if their certifications were denied. Because the requests are entirely discretionary, victims have no recourse if they are denied. There's no appeal process, no transparency, and no opportunity to correct or clarify information. Without certification, victims are effectively denied their federal right to immigration relief, leaving them vulnerable and without protection. This isn't a hypothetical problem. It's happening right now. Just last month, Turnaround started working with a survivor of a brutal domestic violence incident. Years ago, she did everything right. She reported the crime, she cooperated with law enforcement, and pursued legal avenues to protect herself. Her attorney submitted a request for her U visa certification only to have it denied because too much time had passed. But time does not erase the violence that she endured. Time does not take away her right to safety. This bill does not change federal law. It simply ensures that all victims, regardless of where they live, have equal access to the relief that federal law already provides. Justice should not be determined by geography, and I urge you to support this bill to create a fair and consistent process for victims across our state. Thank you.
Distinguished members, Sherry Hoydra, again here on behalf of the Maryland State Bar Association Immigration Section. We urge that you vote favorably on this bill. We provided written testimony with our technical amendments. Much of that involves just reclassifying or re-identifying that it is U status, not a U visa. Of course, we use that colloquially, but that's not really what it is. We also identify that we want to strike including sentencing as part of the subparagraphs provided because they're not a requirement of the federal statute. We don't want to confuse people to make them believe or think that they have to go all the way to sentencing in order to qualify for a U visa. Also, we ask that you strike inclusion of the T visa in reference to the language because it's not a part of what we're involving here. A T and U status are very, very different. Based on those reasons, we're asking that you go ahead and vote favorably on the bill. As you heard previously from my colleague, Mr. Green, the MSBA immigration section has had to compile from all different jurisdictions, from hundreds of immigration attorneys, what types of certifiers are, who's not certifying, which jurisdiction is giving time limits on certifications. We're hearing stories and rumors. Baltimore City doesn't certify past 10 years, and you can't get a certification out of Frederick County. We hear a lot of stories, and this type of bill provides us an opportunity to just have an even playing field so that we know what to expect when we send out a certification. Thank you.
Hi, good evening. Thank you again, Mr. Chair, Madam Vice Chair, and members of the committee. I'm Viviana from Clinic, Catholic Legal Immigration Network, and we're urging a favorable report with amendments for House Bill 579. And the amendments, most of them are just, making sure that we are following the actual wording that's in the federal law. If that's what we're trying to do, there was some discrepancy there that I saw. And then also I agreed about taking out the T visa because I didn't see anything else, like there's nothing else about T, or we could include it if we wanted to. Other states have done that, but we'd have to do a more full process. We just can't, throw it out there. But where we're really wanting to see some amendments, is that we want to make sure that when we're talking about, that you cannot deny a certification or take it back unless, there's been a refusal to cooperate, with a reasonable request. That there's talk of, this is a totality of the circumstances test, but there's no specification about what that looks like. And we really need to lay it out there because if left to their own discretion, we will not get the leeway, and the grace that we need, that our victims, survivors of crime, really need to see. And I think this is something that we have definitely been running into. I will mention, I also added the other amendments that we asked for on 686 with that, and those amendments are based on a coalition that we congregate every so often, and it's with the Maryland nonprofits that do immigration legal representation, and that's like the Catholic Charities Baltimore, Catholic Charities DC, Tahrir Justice Center, ACLU, Kids in Need of Defense, Luminous, Amica Center, Highest, the Women's Law Center, World Relief, and private attorneys. So we've definitely compiled a lot of information and come out with that list. Thank you. Vote favorably with amendments.
Mr. Green, please, for 2 minutes.
I'm going to be much shorter, Chairman. Thank you very much. I just want to point out that the amendments that the State Bar Association Immigration Law Section has proposed are in compliance with federal law. So the federal U statute in the Immigration and Nationality Act does allow for all of the provisions in this bill. So this bill is not going to create conflict, which is an issue that came up earlier today. This should be fine in terms of how the federal government operates. And I want to give a real life example. I had a U case where we applied for a certification from the local police department, and they refused to certify and said we had to go to the state's attorney's office. So we did, and the state's attorney's office said, no, you got to go to the police department. And no explanation for the denial. They just wanted to play a game of hot potato. So we want the games to stop. People are coming forward. It's important for good law enforcement. We want to encourage victims of crime to report the crimes, and they can get the protection that goes along with that. Thank you very much. I yield the rest of my time.
Thank you.
Are there questions for this panel? Y'all are now not asking questions?
Thank you all.
All right.
Thank you.
Thank you all very much. That concludes the testimony on House Bill, I believe, on 579. Now, registers of wills have been very patient in the back of the room, and they are here now. So we'll hear from Byron McFarland, Mary Rowley, and Joseph Griffin. I was asked by the organization to put in the bill on their behalf, and so that is the extent of my testimony. But we're going to hear. Well, it's true, thank you. That's great. Oh boy, you get an applause at this time of night. You're in bad shape. But they're here, and they will explain more about the bill. And if you have questions, we can go from there. Whoever would like to go first, please.
Thank you. Good evening, Chairman Clippinger and Vice Chair Bartlett and members of the committee. My name is Joe Griffin. I'm the Register of Wills for Montgomery County, and I'm here to testify in favor of House Bill 918. The register's salary is set in a two-step process. First, the Estates and Trusts 2205 states the maximum salary a register may be compensated. The second step is then the Board of Public Works actually sets the salary for each individual register within that maximum. We have come before this committee every 4 years to request a COLA for the upcoming term of office. Historically, we have asked that the maximum be set, excuse me, set in the code to receive the same cost of living allowance as the state employees, including those in our office, have received over the past 4 years. House Bill 918 continues this practice by keeping the registers permanently at the same grade and step on the Maryland Standard and Bargaining Salary Scale. At the beginning of each 4-year term, the new max will be set at whatever grade 26, step 20 is at that time. This is strictly a COLA. It is then up to the Board of Public Works to set the actual salary for each of the 24 registers within the new boundaries. Simply put, House Bill 918 will never, ever move the registers up the state employee's salary scale. It will only prevent the registers from sliding backwards down the scale. I ask for your support for this bill with a favorable report.
Mary. Good evening, Chair and committee members. I'm Mary Rowley, the Register of Wills from Frederick County. I'm here to testify in support of the bill. And it's important to note that in 2024, the General Assembly approved raises for the sheriffs of Anne Arundel, Baltimore, Carroll, and Garrett County. And then the year before, it was with the sheriff of Washington County. When we look at some of the other offices, for example, the state's attorney's office, a lot of the state's attorneys are tied either to district court or circuit court judges' salaries. Our state's attorney in Frederick County is actually tied to the county attorney, and therefore he receives COLAs. So his automatically goes up when the COLAs go up. Also, the sheriffs tend to also tie their salaries with either the local police or in some instances with the Maryland State Police. So at this point, we're probably the last office that deals with something that we are proposing now, that we don't have to come back year after year to ask for an increase in pay. As my colleague indicated, it's not asking for an increase, it's just keeping us and then going with the COLAs that our salaried staff make at this point. Thank you very much.
Good evening, Chair Klippinger, Vice Chair Bartlett, members of the committee. My name is Byron McFarland, Register of Wills for Howard County, and I chair our legislative committee. I also asked for a favorable report. I'm going to just second what my colleagues have said. To piggyback on my colleague from Frederick County, under current law, there's only one state's attorney where you set their salary and only 2 sheriffs. Otherwise, it's either delegated to the counties or it's set to some other position in government. For example, state's attorney in Howard County is set to the same salary as our circuit court judges. And I know you actually have a bill before you this year for the sheriff in Frederick County. So as my colleague said, you're kind of checking off the list so that, again, we do not have to come back every 4 years. And I just want to note a couple of quick things is that number one, this will not take effect until the beginning of the next term, almost 2 years from now. We will all have to earn another term in office before we would see any benefit from this. And I'll address the elephant in the room, which is funding. I was just over across the street talking about the inheritance tax, which funds the registers of wills. It is my sincere hope that the legislature will, in its wisdom, preserve this tax, which is not only a stable and reliable source of revenue for the state, but also a growing source of revenue for the state. This year, we're up almost 14% from last year. So not only are we projected to be able to basically already have dedicated funding to pay for this, and then some. At this point, I think the fiscal note says something like 700,000 for this. We are on track this year to grow our revenue by about $13 million. So that would not only pay for this, but provide additional funding to the general fund. And I feel very confident that you will all preserve this source of funding this year. So with that, I'm happy to answer questions.
All right, questions for the panel? I mean, clearly, the fiscal note is still a problem, even if it's deferred. I mean, it's the challenge we have is the structural deficits going into future years, and this, albeit not more than $1 million, less than $1 million, is still an increase. So I think that's going to be one of our challenges talking to the money committees. But I think there's a broader question about the concept, and I'll go a little bit of a step further. Perhaps looking at my friend from Frederick County, that perhaps we need to get out of the business of constantly coming back and trying to set the salaries of all the courthouse officers, not just the Register of Wills, but the sheriff and everybody else with individual pieces of legislation year after year after year, and it maybe should be a little bit more coherent and closer and attached to something else in the law. Don't you agree?
I think so, and the last after us, Mr. Chairman, is also the clerks of court. They're sort of, we're the last folks standing.
Yes. Okay. All right. Delegate Tolles. Really quick.
Yeah, I will be.
Okay.
I just want to say I have so much respect for the Register of Wills and how, they was just there, because I know they helped me a lot with my mom estate. And so I just want to publicly thank you all, because a lot of people, as we heard today and over the past couple of weeks, is so much with the states and wills. Even though I might not have been sitting in here, I was sitting out there and listening to how much work it takes and the patience you'll have to have when people go through what they're going through with their family. It's already a tough time. So I want to publicly thank you for all the work that you do, not just for my friend Sarita in Prince George's, but for all of what you do. Now to my question, are you only funded by the inheritance tax?
The inheritance tax funds, that's about a little over 90% of our revenue. The rest is in fees.
Okay, no, because as they were helping me through my stuff, and I was like, that's all you get. I mean, that's all you get, but I was saying, they were talking about their funding and the fees and was basically telling me that's how they fund the office. So I totally agree with this legislation and just wanted to again, thank you and appreciate all you do. Thank you, Mr. Chair.
Thank you.
You're welcome. Thank you very much. Thank you very much for your testimony on the legislation, our last bill of the night.
Thank you all very much.
Everybody, please, this is Mother Mary here. Be careful driving home.
Okay, so one more moment for the committee. A couple things. First, we will be voting tomorrow. We will be voting tomorrow as quickly as we can after session, probably about 30 minutes after the floor session. Then there are subcommittee meetings, and you should listen for those on the floor tomorrow. Also, if you have bills next Thursday, please pay attention to the schedule on the MGA website because of we're making some changes to the schedule now to reflect the scheduling of the viewing and the funeral for the speaker's son. We will be shortening bill hearings next Thursday significantly and moving some of those bills to the next Tuesday, whatever day that is, which I think is the 11th, to March 11th. I would encourage you, if you have a bill next Thursday, to keep an eye on the schedule because we had 20 bills that day. We've had to shrink it to 7 so that we can leave time for people to get to Randallstown. With that, we'll see you tomorrow for a voting session here, and this has been the House Judiciary Committee.